For adjournments, list one. Serial number 26, first list, 26.
Mention it when it comes, we'll do it. We'll issue notice itself. Bandidiya? Mention it when it reaches, we'll issue notice on the application. Yep.
26, 27 to 32, adjournments.
Serial number
Your
32,
Lordship.
my lord. Weeks time because the council
Which
mother passed away, my
Okay,
lord.
which matter? Which matter?
Serial number 32, my lord. Sangamesh.
Petitioner or respondent?
Petitioner, my
I am appearing for the petitioner, my lord. I have no objection. Your lordship may have it after 2 weeks, my lord.
Allah, he is saying is for the petitioner. Whom do you appear, sir?
lord. WP 10/7/84 of 2018. 32 serial.
32 is 52946.
My lord, there are 3 matters, my lord.
Okay. Even the 10/7, whatever is not here, which number, sir?
Sorry, I will tell you. Sorry, my lord. Sorry, please.
My lord,
I don't think it is 52. No, I don't think it is 52. It is something else altogether.
Please, man. I will check. I will check.
32, my lord, your lordship may kindly have it after 2 weeks, my lord. Mr. Monesh, my lord, has some inconvenience today. My lord, I have informed all the council, my lord, who are appearing.
Sir, it's a 2018 and 19 matter, sir.
My lord, we are ready, my lord. Your lordship may kindly have it after 2 weeks. We are ready, my lord. Since he has some inconvenience, my lord, he made a request to me.
Okay. The request of petitioner call on 2 weeks bit on date today. Avat adjournment illa ready ಆಗ್ಬಿಟ್ಟು
ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ಮಾಡ್ತೇವೆ.
19-8.
March
19-8.
Your Lordships, serial number 22, Your Lordships.
22
Kindly have it next week.
No. 22 mention it when it reaches. It's only B group and final hearing are being adjourned.
All right.
Yeah. Okay. Okay. At the request of petitioner, call on the next week date for it.
12.
By the
12.
time, do it. By the time, do it, and you can withdraw the writ petition based on that. No, once you do it, you withdraw the writ petition. Once you make that application, what remains? We'll direct them to consider your request. That's it. Yes.
33 to 36, list one, 33 to 36. 37 to 42. 43 to 50. 51 to 56. List one, serial number 1, Sumantil Bharadwaj.
Yes, who appears for respondent number 2?
G. Ravindra Babu.
What is this 2018 matter? Kevata respondent ತೋರಿಸ್ತಾ why? Hemavati, government. Yes. Yes, government, what is it?
See, you are formal party line.
Mr. The sought quashing of annexure, which is your order.
I will get instruction because file is not. I get
What type of submission is this?
I get instruction.
No further time. Correct, ready ಆಗ್ಬಿಟ್ಟು ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳ್ಬೇಕು. ನೀವು ಆರ್ಡರ್ ಕ್ವಾಶನ್ ಕೇಳಿದಾರ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? And you have been taking time continuously. The previous records show it.
Kindly have next week, my lords.
The request of AG finally call on date ಕೊಡಿ ಒಂದು.
13-8.
13-8. No further adjournment.
14-8.
14-8.
14-8. Number 2. PM Sidmalappa.
Pass over ಮಾಡಿ.
3. Sangamesh B.
Hmm. The request of petitioner, ಏನ್ ಬೇಕು ಇವಾಗ ನಿಮ್ಗೆ? What is this? You want time, huh? The request of petitioner call after 2 weeks.
4, serial number 4, Ajay Jain.
The request of respondent number 2. Call on, take a date, madam. 2 weeks biಟ್ಟು date ಕೊಡಿ.
20, 28.
That day you file your objections. ಎಲ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
Yes, sir, fresh matter.
General.
But AGA R1, 2 and 3, Monica Patil. The request of respondent, call on, date ಕೊಡಿ.
20,
That day you file your objections, will dispose it.
5, Ishan GS. Serial number 5,
Pass over.
6, Ravi Kumar GH.
Yes, AGA R1, R2, R3, BDA.
Yeah, BDA. Vachan. B Vachan.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ, ನೋಡಿ ಹೇಳ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ, ನೋಡಿ ಹೇಳ್ರಿ ಅದು. ಜಜ್ಮೆಂಟ್ಸ್ ಕಾಪೀಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ. So and so for respondent
Vachan.
number 2 and 3, call on, date ಕೊಡಿ.
13, 13-8. 7, Ajay Jain.
AGA R1, KDB,
KDB.
okay, accept notice, what's your name? Pradeep Kumar is there, no?
HL Pradeep Kumar, 2 and 3.
ಏನ್ರಿ ಮಾಡ್ಬೋದೇನ್ರಿ, ಬಂದಿದ್ಯಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್? ಜನರಲ್ ಅವಾರ್ಡ್, ಕನ್ಸಲ್ಟ್ ಅವಾರ್ಡ್, ಡೇಟ್ ಕೊಡ್ರಿ.
General award.
ಆಯ್ತು, ಡೇಟ್ ಕೊಡಿ, ಅದ್ ನೋಡಿ ಹೇಳ್ತಾರ ಅವ್ರು, ಡೇಟ್ ಕೊಡಿ. That day will dispose it. Short date only, next week.
7,
7,
day after tomorrow.
day after tomorrow. ಹೇಳ್ತೀರನ್ರಿ? 7th, ವಿಚಾರ ಮಾಡಿ ಹೇಳಿ ಅಷ್ಟೇ. ಅವರ ಫೋನ್ ಕಾಲ್ you can get the and be disposed. ಅದೇ ಆಯ್ತು. It's all right. You want a possible? ಹೌದಾ, ಓಕೆ, ನಾಡಿದ್ದಪ್ಪ, ನಾಡಿದ್ದು.
Tomorrow.
Okay, ಅಲ್ಲ, you can get the instructions by that. Yeah.
7, day after tomorrow.
8 ಅದ.
Serial number 8.
Same auto mobile. ಅಷ್ಟೇ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ತಾನೆ?
Yes, sir.
Same respondent.
Please.
Respondent. First AGA, second and third HL Pradeep Kumar. Yes.
2 and 3, HL Pradeep Kumar.
Same auto mobile. ನಾಡಿದ್ದು ಹಾಕಿ.
Day after tomorrow. Serial number 9, Sundaresh HC.
One second, sir. BDA.
BDA. NR Girish.
Yes, 2 ವಾರ ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ.
21, 21-8. Serial number 10, Shailaja SV. Shailaja SV, serial number 10.
Pass over.
11, Vani H.
For the petitioner, my lord, but in the similar matter, my lord, in relation to the very same notification and award, your lordships have issued notice on the other day, my lord, and ordered it to be posted on 14/8. These petitioners are from the very same village and very same final notification, my lord. Award is also same.
R1 ಗೆ MN Kumara.
Yes, my lord.
Two to four arrow.
ಶೋಭಿತ್ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಹೇಳಿದೀವಿ ಸ್ವಾಮಿ.
Shobit Shetty.
Shobit and Shetty.
But-
ಯಾವತ್ತು ಹೋಗಿದೆ ಮ್ಯಾಟ್ರು?
14/8 ಇದೆ ಸ್ವಾಮಿ, ಟು ಬಿ ಕನೆಕ್ಟೆಡ್ ವಿತ್ 20249 of 24.
Call on 14/8, list the matter along with WP number.
20249 of 24.
Serial number 12.
Let's
Vani
say
H.
same lot, same notification, now different petition.
Same respondents,
Please, my lord.
ಇದನ್ನು ಅದನ್ನ same note.
Grateful.
13. HT Vasant Kumar. Serial number 13.
Huh? ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಿಲ್ಲ.
Sir.
ಅದು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇದು.
Is a revenue site holder. He purchased a site from one Srinivasa, who is succeeded through his family partition, my lord. Now the BD has issued a notice, site number 95 is illegally acquired with the petition. Petition nowhere consulted site number 95. He is the site owner of 8C as per the sale deed.
Where is the notice?
Notice, my lord, annexed G page 59, my lord. Same the estate executive engineer, even without passing any order from the commissioner, he is exercising his jurisdiction, he is issuing such a notice. We are nowhere consulting site number 95. Our,
Sir, the problem is revenue sites, they won't have, there won't be proper numbering. Okay, BDF, will dispose it off.
please, my lord.
BDF ಬರ್ರೆ,
PDA.
ವಚನ್ ಬನ್ನಿ,
P. Vachan.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ ಒಂದು.
But
ಕಾಪಿ ಕೊಡಿ. Annexure G ನೋಡಿ, ಒಂದು look at Annexure G for a moment. I will say he has not encroached this particular land. His submission is he has not encroached this particular land. Annexure G ಸಿಕ್ತೇನ್ರಿ?
ಈ page 41 ಮೇಲೆ
ಏನಪ್ಪ?
G, sorry.
59. See, this is the notice issued by you. ಓದಿ ಒಂಚೂರು.
Please, my lords.
I will say that he has got nothing to do with number 95.
Please.
And he has a claim over site number so and so. And he is not putting up any unauthorized construction on 95. Huh? That is his submission.
yes, my lord.
Okay, I'll further say that he is granted 2 weeks' time to reply to this particular notice.
Yes.
Okay, based on his reply, you initiate action in accordance with law. Okay,
Please.
till you take a decision, do not precipitate the matter. I'll dispose of the writ petition.
Please.
My request for a password, I'll just call them up and find
Password,
it.
no issues.
2:30, I'll.
Yes, it's 2:30. Password.
Obligation.
You got you understood what I said? Huh? Yes, password. So it can be decided once and for all.
Please, I
You only take
On-
action in accordance.
My request for, if it's not,
Really?
if it's not inconvenient, Wednesday for me so that I can get the records also and go through it and make my submissions. Wednesday ನಾಡಿದ್ದೇನೆ.
ಕೊಡಿ ಅದು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡೋಣ. So and so access notice for respondents, call on Wednesday date.
Please, my lords.
7, 8.
Copies ಎಲ್ಲ ಕೊಡಿ ವಸಂತ್. Entry notice and ಬೇಡ. Receipt, yes.
Orders 14. Hanumantappa Arvi.
My lordship, I am for appellant.
Hmm.
It's a small correction in the dismissal order, my lordship.
ಏನ್ ಕರೆಕ್ಷನ್ ಅಪ್ಪ?
My lordship,
ಏನ್ ಕರೆಕ್ಷನ್ ಬೇಕು?
my lordship is here, the order is only taken as a memo is taken on record. The appeal is accordingly dismissed as withdrawn.
Hmm.
Here, in the memo of withdrawal, my lordship, I specifically specified that to continue the MEC case, my lordship.
Huh?
To continue the MEC case.
What a missing case.
So the respondents will take the same issue always until the appeal ends. They're making and issuing the same order, my lordship. So kindly
ಎಲ್ಲಿದೆಯಪ್ಪ ಮೆಮೊ ಎಲ್ಲಿದೆ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾವಲ್
file ಮಾಡಿದೀನಿ. The last page.
Sir, you look at your
Correct.
memo, you have sought to withdraw the writ petition, I have dismissed as withdrawn, that's all. I can't confer you any rights, that those rights go in accordance with law. Okay, now who died in this accident?
This appellant's mother, my lordship.
Hmm.
Here, my lordship, in this case.
Now, if the mother dies, all the children will have a right on the
Right.
property. Okay, you agitate that over there, if the court were to hold it otherwise, then we will, you file an appeal. Okay, that's how things go.
Here, my lordship, the case is, here I filed an appeal, my lordship. This is an appeal, my lordship. On the ECA, in the lower court, the husband is filed an ECA, my lordship. Husband filed an ECA and daughters, married daughters entered as an LRs. After dying, father also died in the pending case, my lordship.
Hmm.
The LRs entered as an LRs, my lordship, married daughter. There is no LRs for the father and mother, only the two daughters. They entered as an LRs when the pending case is pending after 1.5 years. So here I filed in the ECA order is also there, my lordship. With citation, I filed an ECA there.
Sir, you filed a memo of withdrawal, sir.
They rejected and I appealed.
Yenanta. Sir, you filed a memo of withdrawal, the case has been dismissed as withdrawn, what else that remains?
So I
You did not ask for any liberty and that liberty is not required also.
So I specifically mentioned as continue the MEC in the last line, my lordship.
Which one?
I specifically mentioned in the memo, my lordship. To continue the MEC.
Sir, we have not dismissed the MVC, sir. We have dismissed the writ petition, that's all.
So I need on liberty to continue MEC. The word liberty. The case is pending in the district court, they're making the same issue.
Sir, I'm not going to pass any orders. Yes, Bunny. It is found that the order passed on the memo withdrawal to be appropriate. The question of, full stop, there is no error in the order passed.
My lordship.
Full stop, correction of the same does not arise. Yes, sir. Yes.
15. Syed Kamaruddin.
Respond to the petitioner counsel, may I pray for a short date. Your Lordship.
The request
And
of.
ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಗ್ಬೇಕು ಅಂತ ಹಾಕಿದೆ.
2012 max.
Can your lordship over
ಯಾವ ಭಾಷೆಯಲ್ಲಿ ಇದಾವೆ ಇವು?
ಕನ್ನಡದಲ್ಲಿ ಇನ್ಯಾವ ಭಾಷೆಯಲ್ಲಿ?
ಕನ್ನಡದಲ್ಲಿದ್ರೆ ನಮ್ಗೆ ಆಗ್ಬೇಕು.
ಅಲ್ಲ ಅವಾಗ ಬೆಂಚ್ ಮುಂದೆ ಇತ್ತು ಇದು ಮ್ಯಾಟರ್ಸ್ ದಟ್ ಇಸ್ ಹಂಗಾಗಿರೋದು.
It is not required. If you go on with the matter, I will hear the matter.
ಆಗ್ಬೋದು. Can
Want
your
to go
lordship-
on?
Huh? No, I want a short date. Your
Okay, at the request of petitioner, ಯಾವ ಡೇಟ್ ಬೇಕು ತಗೊಳ್ಳಿ sir.
13th or 14th, your lordship.
Sir, last time itself, you had taken
Sorry.
it for this
No,
day.
your lordship.
ಸರ್ 13th ತಗೋ 13th.
The request of petitioner finally call on 13th.
13.
The
That it is
2012
covered by
matter.
a decision of this court.
Whatever, sir. Sir, if you are ready, I will hear the matter.
13th, your lordship. Much obliged.
Okay, but no, please no adjournment on that day because it's a
Clear.
2012 matter, sir.
Yes.
16. Siddharth Suman. B.S. Radhanandan.
Pay for the petition.
B. Vachan.
ಹೇಳಿರೋದು ನಾನು.
matter pertaining to the JP Nagar 8th phase scheme, my lord.
Huh?
JP Nagar 8th phase scheme.
JP Nagar,
Now,
JP Nagar,
8th phase.
Eighth stage.
8th phase, ah.
Now, my lord, may kindly appreciate, on earlier occasion, the matter was adjourned
Hmm.
on the ground that the same shall be listed after disposal of writ appeal 1848 and 49 unconnected matters.
ಏನಾಗಿದೆ ರಿಟರ್ನ್ ಅಲ್ಲಿ?
ಅದರಲ್ಲಿ it was declared that scheme has been lapsed. The order of dishonorable court in connected matters was upheld by dishonorable court.
Matter is in the Supreme Court, my lord.
ಸ್ಟೇ ಇದೆಯೇನಪ್ಪ?
ಕೆಲವು ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ಸ್ಟೇಟಸ್ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಸರಿ.
It's a connected matter wherein the dishonorable court was pleased to hold that after disposal of the writ appeals, the same is to be listed. Writ appeal was disposed of. The matter which was taken to Supreme Court, the BD has lost there also. So it has to follow.
PDF ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
Upheld.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಇರಲ್ಲ.
Upheld soon. I'll produce the citations.
Well, moreover, he is a petitioner, is subsequent purchaser.
See, that is different, sir. We'll
And,
clear the matter.
Please, my lord.
Okay, current position, there should not be dispute as to the question of facts. ಬೇಕಾದ್ರೆ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ ನೀವು.
ಹಾಕ್ತೀನಿ.
ಅವ್ರಿಗೂ ಸರ್ವಿಸ್ ಮಾಡಿ ಕಾಪೀಸ್.
ಹೌದು.
Give him the copies of ಇದು ಯಾವುದು?
Whatever the earlier
Supreme Court
orders.
ಇದು. So that there should not be any dispute with regard to
Facts.
Facts.
the facts concerned.
ಆಗ್ಬೋದು.
So ನೀವು synopsis ಆದ್ರೆ even I will look into it and come.
That's good.
The position, my lords, is that of the 231 acres for which we have formed the layout, what would happen to all those allottees anta? So on that issue, my lords, the Honorable Supreme Court sees the matter of my instructions, my lord. I'll update my instructions to see if the
Yeah,
appeal has been
exactly. For that
disposed.
reason. 2 weeks ಬಿಟ್ಟು ಹಾಕೋಣ.
Same ಅಲ್ಲ?
ಅಲ್ಲ Thursday ಅಷ್ಟೊತ್ತಿಗೆ ಅವ್ರಿಗೆ ತೆಗ್ಸಕ್ ಆಗ್ಬೇಕಲ್ಲ. ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ. You should have some reasonable time, breathing space.
Please, my lords.
14th or-
ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ಮೇಲೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ವಾರ ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು. BDN ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡಲ್ಲ. ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಯಾವತ್ತು ಹಾಕ್ತೀರಾ?
ನಾನು I'll serve it in the next week itself. ಈ ವಾರದಲ್ಲಿ ಮಾಡಿ.
ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಆದ್ಮೇಲೆ ಒಂದು ವಾರ ಅವ್ರಿಗೆ ಟೈಮ್ ಕೊಡಿ. 2 weeks ಬಿಟ್ಟು ಹಾಕ್ಲಾ?
20th.
19th or 21st, my lords. 20th is ಮಂಗಳವಾರ, ಸೋಮವಾರ ಅಥವಾ ಬುಧವಾರ ಸ್ವಾಮಿ.
12th or 14th ಮೇಲೆ.
ಅಲ್ಲ 19 ಅಥವಾ 21. ನನಗೊಂದು ವಾರ.
Consider on 19th or 21st. When do you want?
I'll serve it in this week itself, my lord.
He wants it on 19th or 21st.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ಯಾವತ್ತು ಹಾಕ್ಲಿ?
19th ಹಾಕಿ.
ಆಯ್ತು. The request of parties call on 19th. ನಾನು ಬೇರೆ ಆರ್ಡರ್ ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. I'll
With
be
the
ready on that.
understanding that
It will be ready on that. I'll be ready on that.
okay, ಸಿನಾಪ್ಸಿಸ್ ಒಂದು ಕಳ್ಸಿ, ಇದೊಂದು ಚೂರು ನಾವು ಓದ್ಕೊಂಡು ಬರೋದು. ಆ ಕೇಸ್ಲೆಸ್ ಎಲ್ಲ ಹಾಕಿ
ಹಾಕ್ತೀನಿ.
ಒಂದು ಫ್ಯಾಕ್ಟ್ಸ್
Everything is
ಹಾಕಿ,
ready. I'll serve
position
it
of
even-
law ಹಾಕಿ, and which provision you are invoking, then you file the case laws.
ಆಗ್ಬೋದು.
That's how you do it. Unnecessarily don't elaborate.
ಆಗ್ಬೋದು.
Be precise to the point.
ಆಗ್ಬೋದು.
So I will also study that synopsis and come.
Please, my lords. I
ನೀವು
will
ಅದಕ್ಕೆ ಏನಾದ್ರು ಕೌಂಟರ್ ಹಾಕಿದ್ರೆ ಹಾಕಿಸಿ. ನೀವು
I'll assist your lords.
ಹಾಕಿ.
do it.
ಇದಲ್ಲ ನಾನು that day will hear them.
Please, my lord.
Okay. Okay. At the request of parties call on 19th. ಅದು ಸಿನಾಪ್ಸಿಸ್ ಬರುತ್ತಲೇನೆ ಚೇಂಬರ್ಸ್ ಕಳ್ಸಿ. I want to study it and come.
Please,
Hello.
obliged.
17 ಶಿವಶಂಕರ್ ಕೆ. BP ಪುಟ್ಸಿದ್ದಯ್ಯ.
For the petition. Procedural ಏನಾಗಿದೆ ಅಂತ lordship, short accommodation in this matter. But we applied for some copies before the land acquisition officer KDB, but still copies have not been given. It's next week lordship. What has happened? Well, it's 28 to, within 30 days, we have filed objections before the KDB. No order has been passed, we have already applied with copies. It's still copies we could get, next week, any day. Even in the objection statement also, they have stated, they have overruled without considering
After-
the objections filed by the petitioner.
After passing the orders, final notification has been issued. and possession was taken, notice was issued asking him to surrender the land. And he has not obliged it. And possession was taken on 31/5/2019. And it was handed over to the engineer section on 4/6/19. Award notice issue ಮಾಡಿದೀವಿ.
Let's, there are no
And
objection.
after 2 years, he has filed the writ petition
Let's-
before your honor.
Possession has not been taken. Even in the objection statements, they have, they have admitted. Still, we are in possession of the property.
Sir, it is like this.
ನೀವು ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ.
Acquisition under KITP Act.
Yes, please.
Okay. Once final notification is issued, 28/4 notification is issued, land vests with the government under 28/5. ಗೊತ್ತಾಯ್ತಾ?
Yes, please.
The need to take possession as contemplated in the under
28/6,
Land Acquisition
20.
Act or BDA Act does
28/6
not rise.
28/6.
Does not rise. ಗೊತ್ತಾಯ್ತೇನೋ? That only follows later.
Yes.
The question is, now you are challenging the preliminary notification and the final notification.
Yes, please.
Okay. What is the ground on which you are challenging the preliminary notification and final notification? Tell me.
Let's only, the ground is, let's prior to this acquisition, let's already lands have been acquired. In the year 1998 itself, but all remaining properties have been acquired by the very same KITB for the purpose of let's HPCL and others for the same. Subsequently, let's, this is the property available to this petitioner's entire family. Let's immediately after issuance of preliminary notification, we have filed objections before the KITB. Let's already lands have been acquired. Let's
Sir, were your lands agricultural?
this is the only property available to this.
Your lands, are they agricultural in nature or industrial in nature or residential in nature? Or does it fall within, say, 100 meters of Gram Thana limits? What is it? What is the objection that you can have?
Well, it's
Or
all-
have you constructed a house over there?
All agricultural properties.
Agricultural property, what is the impediment, sir?
Let's agriculture lands, remaining properties of this
That's no
petitioners.
ground Allah, sir. That is not the law of the
But
land.
Millards, this is the property because serious objections, still Millards, even we have not received the notice, I mean, the award amount, Millards, still, since beginning, we have filed objections before the KDB. This is the 3 acres, 10.5 kuntas of land already, more than 30 members in the entire family. They're all depending on this property. Earlier, you have acquired, I mean, KDB very,
I can
Millards
do-
acquired
I can do-
almost, Millards,
Sir,
the
listen.
10 acres of land.
Sir, listen, the law of the land does not contemplate that if you do not have any other property, this land has to be left out, unfortunately. See, you'll have to ask if the legislators to frame a law if you feel it otherwise.
Yes.
Okay, we can only interpret the existing laws. That is no ground. Okay, but if you want, I can make one concession for you.
Alternative.
That is, unless compensation is deposited, they will not divest you of your physical possession. Okay, I can pass an order to the effect that you don't have any other source of income, that you are completely dependent on this, that you are not physically dispossessed as of now.
Yes, Millards.
So
Still-
28/4 notification has been issued. Under the circumstances, I'll direct them unless they deposit the compensation. Or if there is no dispute amongst your family members and all of you together make a representation, they will pass the consent award. And I will give you the liberty either to accept the consent award or reject the consent award. And if they pass a consent, if you reject the consent award, then they will deposit before the reference court. After that only they will dispossess you and you will have the right to seek enhancement of the compensation in the manner known to law if you are not happy. This much I can do. But
Another Millards,
question of setting aside
acquisition.
the acquisition does not arise.
Another reason, Millards, the,
Award
even
was,
Millards,
So let him make.
Millards, even they can all, Millards allot alternative property. Millards, that is
If they
also,
have a scheme,
yes,
definitely I will
Millards, their
direct.
scheme is there.
Scheme is there.
Yes.
They will, I will direct them to consider it and
let them make a necessary application.
you
Millards,
make the necessary
I will,
application. Until a decision is taken, they will not dispossess you of the land.
yes. Millards.
Swami,
I'll make that.
Millards, I will consult Millards next week, parties.
Consultation.
Millards,
council,
party
this
is there. Millards,
I will pass it over. See, you are not made out a case for setting aside the acquisition or staying the acquisition process.
See,
It's 28-2, let's,
perusal of your papers,
that's
sir.
28-2
Now
is
listen.
concerned. Yes.
Perusal of your papers does not disclose a ground as to why the acquisition has to be stayed or it has to be set aside.
But insofar as 28-2 is concerned, let's, no order has been passed. That is one of the grounds, let's, the,
What 28-2, sir?
let's,
28 to is,
minutes after the preliminary notification, within 30 days, minutes, so 28-2 notice has been issued. Immediately within 30 days, we have filed objections. This is the land should not be acquired. Already lands have been acquired. And this is the property available to the entire family members. We are in possession of the property. All family members are doing agriculture.
Yes.
That is the objections we have filed before the
Yes.
acquisition. No order has been passed under section 28-3.
28.
After 28-3, then order came to be passed, then minutes 28-4, has to be shown. No order has been passed, minutes will.
28-3 ಇರುತ್ತೆ ಸರ್ ಇಲ್ವೇನ್ರಿ 28?
28 ಮಾಡಿದೀವಿ, ಆರ್ಡರ್ ಮಾಡಿದೀವಿ ನಾವು.
No, let's,
have
the
passed the
objection
order.
statement, Lordship,
And award amount was also deposited, my lord.
minutes 20, their own objection, minutes immediately after the objection, the statement, minutes, the petitioner filed his objection and his objections are overruled. Even not even considered without notice to these petitioners.
They need not hear you. They need not hear it. 28-3 does not contemplate that.
Lordship judgment, Lordship has passed in WP number 41961
Yeah, the-
2019.
ಏನದು?
Detailed order has been passed with regard to 28, minutes 2 and 3 are concerned. The
ಏನದು?
petitioner has to be heard. Once an objection has been filed before the acquisition authority,
You need not be called and heard, sir. You need not be called and heard under 28-3, sir.
then that's the purpose of filing objections before the land acquisition
Objections
authority.
will have to be considered. You need not be heard physically like in a court.
At least the acquisition authority, before the confirming minutes, with regard to acquisition is concerned,
Sir, these
it has
are
to be heard.
Settled principles of law. Please don't waste your time on that.
The number of
But
judgments in this
settled-
point, even Lordship's judgment is also there. In our case only, Lordship has detailed order has
Yeah.
been passed.
Put it.
That's WP number 41961/2019. That's the copy I will.
You have to be heard and the
41961 now?
objections will have to be considered. You need not be given a physical hearing.
Lordship, I have this matter on next week. I will consult the party with regard to this alternative land or minutes with regard to this.
I will,
The
I will pass it over. Please.
that's
consult-
party is not there. Then Lordship, at least Lordship, I have this matter on the 8th, 8th.
Sir, you just want to avoid the bench.
No, minutes. And next 3 days, minutes. Just I'll explain everything to the party, just minutes here. They have to accept.
Okay, we'll have it on 8, no further adjournment.
Please.
Heard in part. For further hearing, call on 8. No further adjournment, sir.
Let them, minutes, with regard to scheme is concerned. If the
ಆ
party
scheme
has not.
ಏನಿದೆ ನೋಡ್ಕೊಂಡ್ ಬರ್ರಿ ಅಪ್ಪ ಅವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರಿಗೆ.
Scheme is there. Let him make a proper application to the
Ask-
authority.
We'll give that liberty.
Yes, you make an application before the authority.
ಏನು?
Otherly construction, the house was constructed by the petitioner. Without noticing the house constructed by the petitioner, Lordship, the land has been acquired. Subsequently, without considering the objections, the land has been allotted to the
allotment.
ಎಲ್ಲಿದೆ ಅವ್ರನ್ನ ಏರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದೀನಿ ತೋರ್ಸು. ಕನ್ಸಿಡರ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ನಾನೇ ಕೇಳಲಿಲ್ವೋ ಇಲ್ಲೇ ಮನೆ ಕಟ್ಟಿದಿರೋ ಇಲ್ವೋ ಅಂತ.
yes.
ಮನೆ ಕಟ್ಟಿದಿರೋ ಇಲ್ವೋ ಅಂತ ಕೇಳಲಿಲ್ವೇನ್ರಿ ನಾನೇ ಇಲ್ಲೇ. See,
Actually, that main thing is the petitioner. Earlier also, he lost everything.
sir, can't help it, sir.
They are receiving
Sir,
the
these are the
compensation
things
amount.
to be addressed by the legislators. You understood, no? We can't do the role of a legislators. We can only interpret the law. We can't frame the law. The intention of the legislature is otherwise. Intention of the legislature is otherwise. As long as you vote based on looking at the caste, looking at money, this is what happens. Tell your villagers to look at human being as a human being.
ಗುಣದ ಮೇಲೆ ವೋಟ್ ಮಾಡಕ್ ಹೇಳಿ,
Now.
ಜಾತಿ ಮೇಲೆ ಹಣದ ಮೇಲೆ ಅಲ್ಲ. ಯಾವ ಲೆವೆಲ್ಗೆ ಇಲ್ಲಿ ಜಾತೀಯತೆ ಬೆಳೆದಿದೆ ಅಂದ್ರೆ, ಈಗ ನಾಯಿ ಬೆಕ್ಕು ಬೇರೆ, ನಾಯಿ ಬೆಕ್ಕು ನರಿ ಹಂದಿ ಕೋಳಿ ಕುರಿ ಬೇರೆ ಬೇರೆ ತಳಿಗಳಂತೀವಲ್ಲ, ಅದೇ ರೀತಿ ಜಾತಿಗಳು ಬೇರೆ ತಳಿಗಳು ಅನ್ಕೊಂಡವ್ರು ನಮ್ ಜನರು. They don't understand the meaning of Homo sapiens. That bad the society is. You understood, no? Once you start doing it, no, in a democracy, you get the leaders you deserve. If there are bad leaders, it is because people want them. Understand that. Okay. So you want to, what do the voters want? Legislators are there not to help you in your day-to-day chores, day-to-day troubles. That has to be catered to by the officers. Legislators are there, ನಿಮಗೆ ಕೆಲಸ ಮಾಡ್ಕೊಳಕ್ಕಲ್ಲ, ನನ್ಗೆ ಈ ಕೆಲಸ ಕೊಡ್ಸಿ, ಆ ಕೆಲಸ ಕೊಡ್ಸಿ, ಆ ಪರ್ಮಿಷನ್ ಕೊಡ್ಸಿ. Legislators are there to make the law. Understand that. The ministers and the bureaucracy is there to implement the law.
Especially, my lords, the acquisition proceedings are concerned.
Can't help. This is what the law is, we will implement it, that's all. When do you want? 8th you want? The request of petitioner, call on
12th,
8th.
lords, 12th. lords.
No 12th, 8th, finish it.
Next week, my lords, 12th.
On 8th, no further adjournment. For further hearing, I said, no further adjournments, okay?
Yes.
Yes. If you don't come or if you ask for time, that day I'm going to dismiss the writ petition.
Not ask party and then, my lords,
If you don't come or ask for time on that day, I'm going to dismiss
No.
the writ petition. I've heard it. I read the papers also. There is nothing in this. Yes.
Chairman, 18 V Anand, P.S. Sudhindra.
Respondent bargaining on this case.
During the course of the day, I will cure the office objections.
Yes. Want me to comply with the office objections?
I have removed two, my lord. One more later, it is.
Is there any urgency?
Urgency is there, my lord. Page
Shall I
100
pass it over?
Please, my lord.
Shall I pass it over?
Please. I shall make a submission, my lord.
Pass over. Put your. You want a pass over or time, sir?
2 days time. maybe.
Right. At the request of petitioner, call on date kodi.
8.
Dated. Compliance of office objection by them. Yes.
Chairman, 19, Bola Veda Vyash Sinai.
My lord, there is another writ petition, my lord. 2265.
How many times notice has been issued to our it?
Sir.
Chandan R8 ತಗೊಂತೀರೇನ್ರಿ ನೋಟಿಸ್?
Lord, I have for R7.
What about R8? ಯಾರಾದ್ರೂ ತಗೊಂತೀರಾ?
R8. Then Ayyappa. Then
How many times notice has gone on?
Once, my lord.
ಎಷ್ಟು ಸಲ ಬಂದಿದೆ?
Once, my lord.
ಒಂದ್ಸಲ assessment ಬಂದಿದೆ.
Unclaimed.
That's not sufficient.
Once in a
Take out
while.
notice.
The same apartment.
First time only.
He resides in the same apartment.
ಅಲ್ಲೇ reside ಮಾಡ್ತಾರೆ. They could serve the
They-
papers.
Hand summons ತಗೊಂತೀರೇನ್ರಿ? Hand summons ತಗೊಂತೀರೇನ್ರಿ?
Yes, ma'am.
ಹಾ?
Yes, ma'am.
ಆಯ್ತು. Reissue notice to respondent number 8. Petitioner is also permitted to take out hand summons on respondent number 8. Office to issue, registry is directed to issue the necessary draft. Returnable by on the Murvi Varavid date good.
27.
My lord,
8.
27.
Connected matter, my lord, this matter may be connected with this, my lord. 22651 of 2022, my
With
lord.
regard to the same subject matter.
Same
Connect-
subject
Same
matter,
subject
same.
matter. Any date given in the?
No,
the-
my lord, no.
Okay, list the matter along with WP number so and so.
22651.
22651 of 2022,
22.
22.
Yeah.
Date from. My lord, one date maybe.
27/8.
But take out hand summons now itself.
Please, please.
Yeah, have them served and give regular process also.
Yes.
21, Ajay Jain.
20 ಏನಾಯ್ತಪ್ಪ?
2020.
20, serial number 20.
One file.
My lord, I moved the application for the 6th for tomorrow. I wanted to carry out the amendments. If my lord can allow it, I will do it right now, my lord. I've given the amended petition already.
You will call it next week. 1 week to do the needful.
My lord, in ninth, can you get date can.
Just, you are not carried out the amendment which was ordered on 25/7 to
My lord, I've given it, they told me to move the memo and
I've
then
given
come.
you 1 week time. You carry it out and move the court. We'll take it up. Yes. 1 week.
21. Ajay Jain.
Query for the petitioner. Office objections are complied, my lords. ಇದರಲ್ಲಿ comply ಆಗಿದೆ. Highlights to be removed.
Good. What is this? Consent award?
No, my lords, this is compensation, land, developed land in lieu of compensation.
Lord, I sought for the
There
madam.
is- Lord, Lord, there is a dispute, it seems, Lord, I'll seek instructions and.
AGR1.
HL
23
Pradeep Kumar.
Call on date,
Next week, Lord.
20th, there is a similar matter.
call on 20th.
28. Number 22, serial number 22, P Mahesh.
Here for the petitioners, Your Lordship. Your Lordship requesting for a short accommodation. Senior is unable to come due to a minor inconvenience.
Yes, so the request of petitioner call next week.
A
Needful
date
by-
may kindly be fixed.
No date, compliance of office objection by then. Comply with office objection, madam. And move the court and
Much
maintainability also you need to argue. Isn't it?
Please, Your
Okay?
Lordship.
We'll tell you senior about it.
Maintainability is there.
23, Chandrasekhar P Patil.
I am for a petitioner. Objections are complied, my lord. One of the objection is, my lord, in annexure D, some correction is made by the authority. ಅಷ್ಟೇ LAQ ನಂಬರ್ ತಪ್ಪಾಗೈತೆ ಅಂತ ಬೇರೆ ಬರ್ದಿದ್ದಾರೆ. ಅರೆ ಏನು
D series to be.
ಅಷ್ಟೇ.
AGR1.
AGR1.
R1 and 2 is. And R3
R1
and
and
4
2
Gautam
AGA.
Dev pair of our other petition.
Tamsi Ullad.
Tamsi Ullad.
3, 4 ಗೆ ಗೌತಮ್ ಸಿ ಉಳ್ಳಾಳ?
Please.
ಗೌತಮ್ ಸಿ ಉಳ್ಳಾಳ for 3 and 4. Overwriting ಯಾವ್ದ್ರಲ್ಲಾಗಿದೆ annexure?
D series.
D series. LAQ ನಂಬರ್ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳಿ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ ಬೇರೆ.
Who has corrected it?
ಅವ್ರೇ ಮಾಡಿರೋದು. ನಾವು ಮಾಡಿರೋದಲ್ಲ. ನಾವು ಮಾಡಿರೋದಲ್ಲ. ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಅವ್ರದೇ. ಒರಿಜಿನಲ್ ಕಾಪೀಸ್.
ಸರ್ ಇದೇ ಹಿಂಗಾಗಕ್ ಸಾಧ್ಯ ಹೆಂಗೆ ಸರ್?
ಒರಿಜಿನಲ್ ಕಾಪೀಸ್ ಅವರೇ ಕೊಟ್ಟಿರೋದು. ಸೀಲ್ ಎಲ್ಲ ಇದೆ. ಸೀಲ್ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಅವ್ರದೇ ಇದೆ.
ಆಯ್ತು ನೋಡಿ.
Please.
ನೀವು ಅದು get the
Please.
government. Annexure C and D ನಾ ಅದು?
D sir. D.
Annexure D.
Please.
ಅದು ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಚೆಕ್ ಮಾಡಿಸಿ. ತಿದ್ದಿರೋದು ಇವ್ರು ತಿದ್ದಾರೋ ಅವ್ರು ತಿದ್ದಾರೋ ಅಂತ. ದಟ್ ಕ್ಯಾನ್ ಬಿ ಎ ಮೇಜರ್ ಇಶ್ಯೂ ಅದಕ್ಕೋಸ್ಕರ. Annexure D ನಲ್ಲಿ ಕರೆಕ್ಷನ್ಸ್ ಆಗಿದೆ. ಕಾಪೀಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
D1, D2, this.
Yes, call the next case.
24, Chandan. Nishant, AVTP Vivekananda.
For responding 4 to 7. And what is this matter? Ready, all sides?
Please.
Yes, go on.
Lord, here. This is an acquisition proceeding that in the year 1991 for the formation of a layout.
17/12/2020 High Court order those.
My lord,
17/12/2020 High Court order.
my lord, that is to consider the representation that was given by
Yeah, first. Yeah,
page
show me.
208.
Annex
208, my lord, page number annexure Q. At page 14 is the actual operative portion. Okay. Shall I read paragraph 5, my lord?
One second, wait.
Yes.
See, counsel, respondent side. One thing, when the court proposes to dispose of by remanding to direct you to reconsider, if there is no scope to reconsider, please tell the court there is no scope for reconsider.
Please.
Okay. Then there will be a quietus to the litigation. Otherwise, see, what is the order passed by this court in this particular case?
With great respect, Nat, we made such a submission. My friend was also there as an impleading applicant. This honorable court felt that notwithstanding the contention of MUDA that they cannot challenge the acquisition proceedings because of the earlier orders passed by this honorable court in respect of the very same land, in respect of the very same petitioners, this honorable court find that let the representation be considered.
Okay.
Then we had to accept that order. Such a submission was made.
You do one thing, you carry on and file an appeal if you are aggrieved.
No, notwithstanding the direction of this honorable court, our submission before this honorable court in the earlier petition that their grievance will have to be addressed in terms of orders passed by this honorable court as per annexure Q and R dated 1/6/2012 and 23/7/2013. That is indicated, Malad, in page 214. Malad, kindly see those orders, Malad.
Yeah, what is 1/6/2012? Where is it?
Yes, Malad. Malad, kindly come to page 186, annexure M. Your Lordship could see, Malad, paragraph number 6 onwards. Para 5 onwards, Malad, may I submit? May I read page 190.
Now, what are you asking now? You're asking for setting aside the acquisition or granting you compensation by way of developed lands in lieu of monetary compensation?
My lord, here, the issue is in the previous petitions which were before this court.
Now, what do you want right now?
My lord, if the acquisition proceedings could be quashed based on the contentions that I would submit before your lordship, that would be my primary prayer. In the alternative, a scheme of 50 is what I have sought in my representations as well. My lord, my submissions before your lordship.
What is that? Okay, the first thing is ruled out, you will argue that. With regard to the second aspect, are you open for granting them alternate land, developed land in lieu of compensation? Is it permissible?
No, it is not permissible, my lords. This honorable court in the order at annexure QM, kindly see, my lord, the operative portion of the order, page 193.
Both you are not willing to agree.
No, my lords, they are not entitled to, my lord. It is not that we are, please,
Exactly.
please,
That's your contention.
please.
Just wanted to know
Page
your-
193, my lord. of
One
the-
second.
Please.
Now, the subject matter of WP number 43506.
Yes.
Of 2011. And the present petition are one and the same?
Yes, my lord, same land, same parties.
Same party, same
party,
land.
Same land. The only relief granted was for allotment of incentive site.
Annexure D in the said petition was for what?
Annexure,
Parties, there are some additional parties, my lord. Not all parties were before the court in that petition.
no, let's see, in the next writ petition, page 195,
No,
annexure M.
annexure D was pertaining to what? You come to page number 193,
180,
193.
193. 14/3/2011 representation, my lord, is for allotment of site.
No, no, it's for incentive site. What is annexure D?
Representation.
Do you have that copy over here?
4/3.
I'll verify.
It's represented 2011. 4/3/2011.
It is not there, my lord, in
It's
the.
not there, my lord.
What is 14/3/2011, Chandan?
Lord, I'll produce that, my lord, because when I do not have a copy of that, I will produce it.
Okay, what happened thereafter? What is this 195 order?
Let-
My lord,
195, my lord, is in respect of the other survey number, which is also subject matter of the present writ petition. There also, my lord, page
It was
199.
recalled over here.
Page 199, my lord, sir.
petitioners were given liberty to make representation for the benefit of any incentive scheme.
Incentive scheme as may be available, and the respondent shall consider the case appropriately. But then the petitioners, my lords, have not approached the authority for incentives site. On the contrary, they filed another writ petition, that is annexure Q, page 1208, challenging the acquisition proceedings. But when the matter was being heard on merits, they said we are satisfied if our representation is considered. Then this honorable court disposed of the earlier writ petition, directing Muda to consider the representation. Now order is passed at annexure R, page 216, considering the representation. They have taken note of all the past proceedings. And finally concluded, my lord, in page 222. This is the relief which the authority could grant, my lord, on page 222, my lord, the order. May read, my lord, sir. ವಿಜಯನಗರ 4ನೇ ಹಂತ ಬಡಾವಣೆ ಉದ್ದೇಶಕ್ಕೆ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 108 ಮತ್ತು 109 ಪ್ರಾಧಿಕಾರವು ನಿಯಮಾನುಸಾರ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಈಗಾಗಲೇ ಬಡಾವಣೆ ನಿರ್ಮಿಸಿ ನಿವೇಶನಗಳು ಹಂಚಿಕೆ ಮಾಡಿರುವುದರಿಂದ ಭೂಮಾಲೀಕರಾದ ಶ್ರೀ ಸೋನ್ಸೋ ಮತ್ತಿತರರು 7/2/2020 ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವ ಅರ್ಜಿಯನ್ನು ಮೇಲೆ ವಿವರಿಸಿರುವ ಕಾರಣಗಳ ಹಾಗೂ ಕಾನೂನಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ತಿಳಿಸಿ ಹಿಂಬರ ನೀಡಲು ಸೂಚಿಸಿ ಆದೇಶಿಸಿದೆ. ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ WP ಸೋನ್ಸರ್ ಆದೇಶದನ್ವಯ ಸದರಿ ಭೂಮಾಲೀಕರುಗಳಿಗೆ ಪ್ರೋತ್ಸಾಹದಾಯಕ ನಿವೇಶನ ಕೋರಿ ಪೂರಕ ದಾಖಲೆಗಳೊಂದಿಗೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಭೂಮಾಲೀಕರುಗಳಿಗೆ ನಿಯಮಗಳಡಿಯಲ್ಲಿ ಅವಕಾಶವಿರುವಂತೆ ಪ್ರೋತ್ಸಾಹಕ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ಕ್ರಮವಹಿಸಲಾಗುವುದೆಂದು ಭೂಮಾಲೀಕರಿಗೆ ಸೂಕ್ತ ಹಿಂಬರಹ ನೀಡುವಂತೆಯೂ ಸಹ ಸೂಚಿಸಿ ಆದೇಶಿಸಿದೆ.
Yes.
They are entitled to incentive settlement as per the orders of this honorable court.
Yes.
My lord, my submissions before your lordship is 3 issues that has not been considered or not been taken into consideration in the earlier petitions. One, my lord, the award passed by the respondent authorities is not in accordance with law. That is the first aspect. Second aspect is that the possession is still with the petitioners and the possession has not been taken till date. And the documents furnished by the respondents are contrary to their own document with respect to possession.
Okay, next.
These are the 2 main aspects. Why I say that the award is not passed in accordance with law is, Lord. Will Lord may be pleased to take page 123 of the writ petition.
Okay, these are the 2 leg of your argument.
2 leg of my
Yes.
Lord may be pleased to take page 123, my lord. A general award has been passed. The general award has been passed on 18/7/1994, my lord. My lord has 123, my lord.
Page number?
123, my lord, is the last portion of the general award. Here, my lord, the first paragraph of page 123. ಈ ಜನರಲ್ ಅವಾರ್ಡ್ ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಂಡ ನಂತರ ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ಮಾಡಿ ಪರಿಹಾರ ಪಾವತಿಸಲಾಗುವುದು. There is no permission from the government that the authority has secured and that is not been placed on record. Neither in their objections, there is any counter to this particular submission of mine. So this is a mandatory requirement to secure the approval of the government.
Council, first you come to the order passed in WP number 43506 of 2011.
Yes, my lord.
Okay.
Yes, my lord.
This has attained finality. This has attained finality. You
Yes,
can't go beyond it.
my lord, but my submission before your lordship is this aspect of the award not in accordance with law first, and the issue of possession having not taken till date have not been discussed in this writ petition or not been held in any way either in my favor or in their favor. This is not the contention at all. And hence I am still having the eligibility to raise those contentions for the reason that this has not been considered in the earlier writ petitions. And my lord, in the last writ petition that I have filed where this honorable court has remanded the matter back for consideration on the representation that I have made, this honorable court has clearly said that at page 214, paragraph 5, my lord, this court has said that in view of the rival submission of both the sides and in the light of the aforesaid subsequent events that have occurred during the pendency of this petition, without expressing any opinion on the merits and demerits of the rival contention, I deem it proper to refer it to.
Sir, please keep that order aside. The effect of that order is nothing more than remand.
Yes, my lord.
To consider your incentive schemes or some such thing. That's all, nothing else.
Yes, my lord, but the issue here I'm making my submission is on the ground that
Adhikari ಹೇಳಿದ್ದು, when the court wants to simply remand rather than putting a quietus to the litigation, it's your duty to see to it does not happen. Every one of us are here to perform our respective duties. Disposal mania will not take us anywhere.
Please.
We are here for the litigants, not for the advocates also. When there is a remand made, when it does not warrant, you have to file an appeal. It's high time some
Yes.
authority does this. Otherwise, it opens a Pandora's box.
Please minutes.
Lord, I would rely on a particular citation with respect to this aspect.
Look, mister. The order passed in that remand order in that particular writ petition does not confer any right in your favor. Except that if the policies of the government has changed, and if you are entitled for any incentive scheme, that's the reason why I said, get that annexure D, whatever is there. Okay,
I will place it before your lordship.
Ah,
Actually.
excellent, not required. Now you satisfy first on delay and laches. You
Lord,
come to this particular writ petition, the acquisition is of the year 1991.
Yes, my lord.
Okay.
My lord, why I would say this, my lord? The acquisition proceedings, the award, everything has been issued in the name of a dead person. My father, the acquisition proceedings has not been conducted in my favor. My lord, Pullappa, who is the owner of the property, died in the year 1996. And Puttananjappa also died in the year 2000. None of them, even the award has not been made, has been made in their name, in the name of the dead person. My lord, I would like to make this submission. Though in the year 1992, final notification was issued, the general award that was issued on 8/7/1994, saying that with the requirement that the permission of the government has to be secured after the general award has been made, before individual awards has been made, such permission from the government has not been secured. Without securing such permission, the award itself is non-est. First.
Yes.
Next aspect, my lord.
The award is made in favor of dead person.
Yes.
Was your name, were you the notified Katadar? Did your name reflect in
Notification.
the revenue documents?
My lord, I would say this, my lord. Earlier, when the preliminary and final notifications were made, they were alive. After that, before the award could be made, both the owners died. I made a representation to the authority in the year 2002. Making them know that I am the Khatedar and I am the person entitled to this. But what they do subsequently, in the year 2009, they file a reference LAC 328. Again, in the name of the dead person, even though they were 2002. They don't make the award in my name, they make the award in the name of the dead person. That is the first aspect. Because I had made a representation in the year 2002, 21/3/2002, I had made a representation saying that these lands cannot be acquired for various reasons that I had made a representation. After the representation, it was obvious that they should have initiated the reference proceedings in my name, which they don't do. They initiate a reference proceeding in the name of the dead person.
Provision for initiating reference. Show it. Under Land Acquisition Act?
Yes.
Land Acquisition Act.
Section 30 and 31, my lord. $31, my lord, shall I read, my lord?
29 in the over.
apportionment of compensation. Particulars of apportionment to be specified, where there are several persons interested. If such persons agree in the apportionment of compensation, the particulars of such apportionment shall be specified in the award, and as between such persons, the award shall be conclusive evidence of the correctness of this apportionment. 30. Dispute as to apportionment. When the apportionment of compensation has been settled under section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the court.
31 ಅದು.
Now, my lord, in section 31,
ಪೂರ್ತಿ ಓದಿ.
and the Karnataka amendment, my lord, with respect to 30A, apportionment of compensation, where there are several persons interested in all these provisions, my lord, one thing may be noted. It is mentioned as persons interested. Interested in the amount of compensation, the court shall apportion the amount according to the interest of each such person and shall specify in the award the amount due to each person. Each such person shall be entitled to obtain execution of the award to the extent of the amount due to him without the consent or concurrence of other persons. Now, my lord, 31, payment of compensation or a deposit of the same in the court. On making an award under section 11, the collector shall tender payment of the compensation awarded by him to the persons interested entitled thereto according to the award, and shall pay it to them unless prevented by someone or more of the contingencies mentioned in the next subsection. If they shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title to receive the compensation, or as to the apportionment of it, the collector shall deposit this amount of compensation in the court, to which reference under section 18 would be submitted, provided that any person admitted to be interested may receive such payment under protest as to the sufficiency of the amount. Provided also that no person who has received the amount otherwise, then under protest shall be entitled to make any application under section 18. Provided also that nothing herein contained shall affect the liability of any person who may receive the whole or any part of any compensation awarded under this act, to pay the same to the person lawfully entitled thereto. Now, my lord, for all this, an making of an award under section 11 is a prerequisite. Now, my lord, I would take your lordship to section 11. Shall I? Section 11, inquiry and award by the collector. On the day so fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to a notice given under section 9 to the measurements made under section 8, and into the value of the land, and at the date of publication of the notification under section 4, subsection 1, and into the respective interests of the person claiming the compensation, and shall make an award under his hand of the true area of land, the compensation which in his opinion should be allowed for the land, and the apportionment of the said compensation among all the persons known or believed to be interested in the land, of whom or of whose claims he has information, whether or not they have respectively appeared before him. So, if there is intimation to them that these are the persons interested, an award should be made in their name. That is one part of it. Further, my lord, the Karnataka amendment provided the proviso, my lord,
Provided that
no such award shall be made by the deputy commissioner without the previous approval of the state government, or such officer as the state government may appoint in this behalf, who in the case of an award made by an officer below the rank of deputy commissioner of a district may be the deputy commissioner of the district. Here, my lord, it's a clear case that the prior sanction of the government after the general award has been passed has not been taken, and nothing has been placed on record till date.
Okay. Then, next.
That is one aspect, my lord. Secondly, my lord, as I said, they say that possession has been taken, and I would like to take your lordship to
16 to ಆಗಿದೆಯಾ? Huh?
16 to
6.
13 to 2001.
13 to
2001.
okay.
My lord, they say 13 to 2001. They have 16.2 has happened is their statement.
One second.
My
What
lord,
is the
maybe-
present status of the land?
Sites are formed, allotted, roads are constructed. And I have produced the letters of allotment issued to the allottees. And
Here
ballot
for
person.
the allottees.
Sites are formed.
Sites are formed. I have produced not the documents to that.
Yes, my lord. If the statement made by them is to be taken into consideration that 16.2 has been completed as long as in 2001, my lord, annexure N may be looked into, my lord.
No, you continue with your arguments, just.
Yes, my lord, with
just
respect
ask
to,
it
I will
for
just answer this because it would be straight to the point.
Yes, page number.
Annexure N, page number, my lord. Page number 200, my lord. 200. My lord, this is a notice issued by the respondent asking me to evict. This is in the year 2011. They say that 16.2 is completed in the year 2001, which is false. Now, my lord, I would like to read this. Vijayanagara Nalakne Hanta Eradane, and even here they issue it to the dead persons. ವಿಜಯನಗರ ನಾಲ್ಕನೇ ಹಂತ ಎರಡನೇ ಘಟ್ಟ ಬಡಾವಣೆಯಲ್ಲಿ ಬಸವನಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 108 ಮತ್ತು 109 ಇರುವ ಕಟ್ಟಡಗಳಲ್ಲಿ ಅನಧಿಕೃತ ವಾಸವಾಗಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ. We had built houses there. We were residing there from before. This is sent in the year 2011. The statement they make.
Scheme ilva to give them alternate land.
Alternate land ಗೆ scheme ಇಲ್ಲ. Incentive site ಗೆ scheme ಇದೆ.
No, what best you can help them?
Only incentive sites not that could be allotted. That is what this honorable court has found in the earlier proceedings. That is the maximum that can be granted to them.
You say what it is, you are
But they-
the incentive sites.
But, under the incentive scheme, but, if the land acquired is more than 5 acres, they would be entitled to the maximum sital area of 7,200 square feet.
Okay. Now, are they entitled to incentive scheme?
No, that is the incentive. The allotment of sites for the acquired land is an incentive scheme.
Okay, this is in addition to. the
Compensation. Compensation.
Now, are they entitled to it? Can you give them?
That's in the impugned order. We have told them to approach the authority and get the allotment. Kindly see the impugned order. Page number 216. Page number 222, the last paragraph, let's. ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸೋ ಆದೇಶದನ್ವಯ ಸದರಿ ಭೂಮಾಲೀಕರುಗಳಿಗೆ ಪ್ರೋತ್ಸಾಹಕ ನಿವೇಶನ ಕೋರಿ ಪೂರ್ವಕ ದಾಖಲೆಗಳೊಂದಿಗೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಭೂಮಾಲೀಕರುಗಳಿಗೆ ನಿಯಮಗಳ ಅಡಿಯಲ್ಲಿ ಅವಕಾಶವಿರುವಂತೆ ಪ್ರೋತ್ಸಾಹಕ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ಕ್ರಮವಹಿಸಲಾಗುವುದೆಂದು.
You become entitled to it.
My lord, I will have to seek instructions on that, my lord.
No question of instructions. You complete your arguments.
I will complete my arguments, but if that is the issue, my lord, I will have to seek
I
instructions.
just was thinking how best some
I
benefit can
understand.
be
I understood, my lord.
given to the landlords.
I
Because
understood.
see, the present law is beneficial to landlords, land losers.
Yes.
Okay.
Yes.
See, 91 acquisition, unfortunately, that pittance. They should not go out with a heartburn. That's all. That's the only attempt.
My lord, that is
Can
one
prevail
of
upon
our
Marathi.
submission, my lord, for the reason that possession is not taken till date. We are saying that you consider.
Legal issues will land it.
That is the reason we are saying consider us under the Right to Fair Compensation Act is what is we are
Yes,
saying.
next.
That is what we are saying.
Yes, any other arguments?
My lord, these are the two aspects, my lord. Further, my lord, I would like to place reliance on a couple of citations based on these, my lord. My lord, page number 3, paragraph 7, my lord. Section 11 postulates of conducting an inquiry and making the award by the collector. Here, collector has to be read as DC, my lord. The first proviso envisages that no award shall be made by the collector under subsection without the previous approval of the appropriate government or of such officer as the appropriate government may authorize in this behalf. It is common knowledge that exercising the power under the first proviso, the appropriate government made rules or statutory orders or instructions, whatever be the nomenclature. They have the statutory operation giving authorization to the land acquisition collector to make an award up to a particular pecuniary limit without prior approval, either on the appropriate government or an officer authorized by the appropriate government in that behalf. If the award exceeds the limit, prior approval of the state government or the authorized officer is mandatory. Any award made in violation thereof renders the award non-est and void as it hinges upon the jurisdiction of the land acquisition officer or officer. Then, my lord, it has, with respect to that particular case, and observations has been made. Now, my lord, here in this case, as demonstrated by me, the general award, there is a specific mention that individual awards would be made after obtaining approval of the government, which approval is not forthcoming. They have not secured any approval of the government, and an award has been passed, which is non-est, is my submission, according to this judgment. Now, my lord, the second aspect here is at page 9, para 21 of the next judgment, my lord, Patna Improvement Trust Board. Paragraph 21, my lord, page 9. Yes. The law on the subject is well settled, and in my view, the learned judges of the High Court have correctly appreciated and applied it to the facts of the case. Two principles noticed by the High Court are opposite. The first principle is generalia specialibus non-derogant. This principle is exemplified by the decision of the Privy Council in so and so. The second principle is that if statute directs a thing to be done in a certain way, that thing shall not, even if there be no negative words, be done in any other way. This principle is illustrated by the decision in so and so. My lord, what I would like to stress here is, when the statute postulates the doing of a particular thing in a particular manner, it has to be done in that manner, and there can be no deviation of that procedural aspect which is contemplated by the statute. Here, my lord, first, the statute contemplates that government approval has to be taken on the award first, and the manner in which possession has been taken, that they say that possession has been taken. One, our contention is possession is not taken at all. Second, my lord, I would like to take your lordship on this aspect as to the mahzar and other aspects that they have furnished before. My lord, at page 162, my lord. (162) is a mahzar report. My lord, by the mere perusal of this mahzar report, nothing is forthcoming. The owner of the property signature is not available. And who are these panchas? Nothing is identifiable. My lord, the Anthony Raj case of this honorable court clearly says that as to how mahzar has to be done. I would like to read that, my lord. I have also submitted, my lord, at page 37, as to how land would vest a division bench of this honorable court, page 37, my lord, paragraph 16.
This is challenge, no, in Supreme Court, Anthony.
Challenge, but there is a challenge, my lord, but there is nothing that has. Lord, shall I read, my lord, paragraph 16A, my lord.
16?
Page 37, my lord. Yes. Regarding vesting of the property, 16A, I would like to take your lordship to the relevant paragraph at 16H, my lord, page 39. I would like to read from 16G, my lord. On the other hand, if the contention of the BDA is to be accepted, the same would amount to disobedience of the court order attracting contempt. The records of the trial court would disclose that right up to 1995, the order of injunction prevented the defendant's BDA from taking possession of the suitable properties. Even in this case, my lord, right from 2011, there has been petitions and there has been interim orders granted by this court. They say that possessions has been taken and handed over to other party, sites has been formed. I do not know how could they do it when there were injunction, when there were stay orders from this court.
How the
my lord.
mahzar has to be drawn ಅಂತ ಎಲ್ಲಾದ್ರೂ
Yes,
ಹೇಳ್ತಾರೆ?
my lord, at annexure H, at H, my lord. It is a further contention of the learned senior counsel for the respondents BDA. That the records, namely the mahzar, would indicate that the possession has been taken in accordance with law in the presence of panchas. We have considered the mahzar produced by BDA for both the lands. It would indicate that the same is in a cyclostyle form. The presence of the owner is not found. Even in this case, my lord, presence of the owner is not found. The owner or the person present at the time of drawing the mahzar has been deleted. Therefore, it would show that the owner was not present when the possession was taken. Secondly, the signature made on the mahzar is sought to be argued as that of the owner. This we find rather hard to accept. There is no material to indicate that the said signature on the mahzar belongs to the owner himself. The further objection to the mahzar by the petitioner is that the panchas who signed the mahzar were not identifiable. On considering the records, we find certain signatures, initials in the mahzar which are not relatable to any person. As held by the Honorable Supreme Court in number of decisions, the mahzar witnesses are required to be identified. One would have to know who was the witness in the mahzar. If the witness cannot be identified, then the witness of such person cannot be accepted. There is no material as to who have signed this document, what are their names, where they are residing, etc. No such particulars are forthcoming. Therefore, the mahzar witness cannot be relied upon. Learned Senior Counsel for the Respondents BDA relies on the decision of the Honorable Supreme Court in so and so and others in order to show that valid possession of the land has been taken. In support of his argument, reliance is placed on para 37 of the said judgment, wherein the principles are culled out with regard to taking possession of the land. Therefore, it is contended that all such parameters have been complied with. The same is disputed with the Learned Senior Counsel for the petitioners on the ground that there were structures on the land. Admittedly, the mahzar itself indicates that there were structures. Therefore, when there were structures on the land, clause number 3 mentioned in the said judgment would be applicable. Para 37 of the aforesaid judgment reads as follows. The principles which can be culled out from the above noted judgments are: no hard and fast rule can be laid down as to what act would constitute taking of possession of the acquired land. If the acquired land is vacant, the act of the state authority concerned to go to the spot and prepare a panchanama will ordinarily be treated as sufficient to constitute taking possession. If a crop is standing on the acquired land or building structure exists, mere going on the spot with the authority concerned will by itself be not sufficient for taking possession. Ordinarily, in such cases, the authority concerned will have to give notice to the occupier or the occupier of the building structure or the person who has cultivated the land and take possession in the presence of independent witness and get their signatures on the panchanama. Of course, refusal of the owner of the land or building structure may not lead to an inference that the possession of the acquired land has not been taken. Now, my lord, in the present case, the very perusal of page 162, my lord, the mahzar report that they say, the name of the owner is not there, the panchas are not identifiable, and it is this judgment clearly lays down the law wherein as to how mahzar has to be conducted, and this mahzar is completely contrary to that principles, my lord.
Chandan, for you to take up these contentions, there are two problems. One is the writ petition was decided in the year 2012.
Yes, my lord.
Your writ petition
Page 186.
186.
okay, was decided in the year 2012. And possession was taken way back in the year 2001.
My lord, that I have objection, my lord, because in the year 2012, they themselves sent a letter asking me to evict. In 2011, my lord, they themselves sent a letter calling for eviction.
That is different.
Because that is contrary to their statement that they have taken possession.
Listen. See, the thing is, they go there, take possession. It's agricultural land. There are standing crops. Obviously, owner refuses to come and sign the mahzar because he is not cooperating. They draw the mahzar. And this is not in a cyclostyle form. This mahzar is not in a cyclostyle form. Max to max, you can take up the contention that the witnesses are not identifiable. That is again a subject matter of dispute. Okay, number one.
Number two, it was done way back in the year 2001. Okay. Now 16.2 also has been issued. No doubt, 16.2 is only an evidence of taking mahzar. I mean, say taking possession.
Taking possession.
It's not an irrebuttable presumption. Okay.
Published.
You can always contest, even if 16.2 is there, you can always contest
Yes.
saying that mahzar has not been taken. They have sat in their office, they have drawn the mahzar.
Because their annexure N would
published,
say, would clearly say that, that has not been done.
But the onus is on you heavily. Okay. Then what goes against you is the earlier decision that you have suffered in the year 2012. Because the order being passed in 2012, these aspects have been considered over there.
These
And in
aspects
the-
has not been, that is my submissions, my lord.
Okay. And in
issue
the
of-
writ petition, they have already said the writ petition has to fail based on delay and laches. Okay. The only concession given to you is consideration of annexure D, that is with regard to incentive side. Okay. Now, that being the case, practically speaking, please examine and say, your request in so incentive side. I can dispose it off.
Yes.
Okay. Granting of incentive side. I think the other exercise will be futile. If you want to go ahead with it, go ahead with it.
My lord, with respect to that, I will have to take instructions.
No question of instructions. I will say in this order itself that they will consider your request for incentive side, and apart from compensation that you have granted, if law permits, they shall grant you incentive side. I will make that observation. Because what has happened in the earlier order, it is left to the discretion of the MODA.
Yes, ma'am.
Okay, in the light of observation made in their own reply. Okay, if you can establish it, I will give you that right. They will grant you incentive side. I will pass that order. Okay, will pass. No question of adjournment.
Adjournment, no, I'm not seeking any adjournment, my lord. I'm just
See, because
contemplating as to.
see, you can go on and on. We'll be holding up the court for another couple of hours max.
I understand, my lord.
Alva. Yes, we'll pass the order.
Yes, ma'am, but my submissions may be considered and passed.
It will be considered.
Yes.
Yes, but agreed by the impugned order dated 2/8/2021 alla.
Oh,
4/8.
it's
2/8 appa.
endorsement.
Endorsement 4/8.
Nodi.
4/8/2000.
2/8/2021. And
2/8/2021.
there are two orders.
There are two
issued to-
orders.
Issued in favor of two.
4/8/2021. Huh?
Yes.
2/8 and 4/8.
Endorsement.
R and R1.
Endorsement. Huh?
Yes, ma'am.
Dated so and so and so and so by respondent number.
Respondent number 2 minutes. 2.
Respondent number 2. In brackets wide annexure R and R1 to the writ petition. The petition, the present writ petition is fine. The present writ petition is fine. Full stop. Next paragraph. The lands of the petitioners were acquired for formation of
Vijayanagara fourth stage
Fourth
layout,
stage.
Millet, Mysore.
Vijayanagara 4th stage layout, Mysore. By second respondent. Formation of so and so Mysore and Sak, full stop. By a land. Huh? Full stop. Agreed by the same. Mysore, in the year 1991.
1992. Preliminary
the
notification.
year
and-
1992. but
23/12/91 is a preliminary notification.
A preliminary notification to this effect was passed on
23/12/1990.
23/12/1991. And a final notification was passed on 10/12/1992. Full stop. Agreed by the same. WP number 43506 of 2011. All the lands were covered in this writ
No, but there
petition.
is one more writ petition, next petition.
Next petition.
195, page 195, make sure I am one. There are two families, lots, one is by,
Okay, all the.
yes, covered in both the writ petition.
both
The writ petitions.
And a final notification was passed on so and so, full stop. Agreed by the same, WP number 43506 of 2011 and connected matters, along with WP number 19831 of 2011 and connected matters, were filed before this court. Full stop. The said writ petitions have been disposed of by holding that the scheme has been substantially implemented, the acquisition notifications impugned in the writ petitions are not interfered with, full stop. It was also observed in the said orders that the petitioners therein have approached the court belatedly, and the writ petition is also liable to be dismissed on the ground of delay and laches. Full stop. However, the petitioners had made a representation to the second respondent for allotment of incentive scheme. Incentive sites.
Representation was made for a 50/50 scheme, not for incentive.
A representation for allotment of sites as compensation in lieu of sites as compensation. Sites as compensation. And the said representation was directed to be considered in accordance with law. And the said representation and respondent number 2 was directed to consider the said representation in accordance with. And respondent number 2 was directed to consider the said representation in accordance with law. Full stop. The said orders have attained finality. Thereafter, the petitioners preferred WP number 51471 -51475 of 2014 on the ground that their representation have not been considered.
Milord,
Incidentally, they have also challenged the acquisition.
Milord, in this, the acquisition was challenged.
And also.
And for applying section 25 of the fair compensation.
And also challenge the acquisition and also prayed that compensation has to be granted to them in accordance with Right to Compensation Act. Full stop. This court, by its order dated 17th December 2020, remanded the matter back to second respondent herein to consider the request of the petitioner and pass appropriate orders. Full stop. In compliance of the said directions, respondent number 2 has passed the impugned orders, wherein the request of the petitioners have been rejected, and the only concession that is given to them is if they make the necessary applications for grant of incentive sites with all the relevant particulars, the same shall be considered in accordance with law. Full stop. The same is challenged here. Full stop. Next para. It is contended on behalf of the petitioners that irrespective of the decisions passed in the decisions of this court referred to above, the acquisition of the lands of the petitioners for Vijayanagara,
Fourth stage.
fourth stage, Mysore, has to be set aside because the award passed is not in accordance with law, and the possession of the lands concerned is still with the petitioners, Full stop. In the course of the arguments, it is submitted that in the alternative, if the acquisition is upheld, the petitioners pray that they should be awarded compensation under the provisions of Right to Fair Compensation Act, although expandment, or please be granted 50% of developed sites as per the present policy of respondent number 2. Correct?
Yes, ma'am.
Respondent 2. Full stop. Next para. Per contra, the respondents submit that the award has been passed in accordance with law, that possession has been taken way back on 13/2/2001. Way
13/8,
back in the year
13/8/2001.
13/8, way back in the year 2001 itself, and 16 clause 2 notification under the provisions of Land Acquisition Act 1894 has been issued on
13/2/2002. 13/2/2002.
13/2/2002. 2002, and the same has been considered by this court in WP number in the earlier writ petition. WP number in the earlier writ petitions. Writ petitions. Full stop. It is further submitted that the lands having been acquired way back in the year 1992,
Yes.
and possession having been taken and award having been passed much prior to coming into force of Right to Fair Compensation Act. The question of granting compensation to the petitioners under the said enactment does not arise. Full stop. It is also submitted that as on the date of acquiring the lands, the respondent authorities did not have a scheme of granting alternative developed sital areas to the petitioner. And granting the same today will open a Pandora's box by many similarly situated persons making the said applications. Said applications, full stop. For that reason, it is prayed that the writ petition be dismissed. Full stop. Next para. Acquisition, challenge to acquisition can be made by the parties concerned after issuance of the final notification. And even if it is upheld, subsequently, if possession is not taken in accordance with law and award is not passed as contemplated in law. Full stop. In the instant case, we need to examine whether the petitioners can challenge the acquisition on the said grounds. Full stop. Further, the questions regarding whether the petitioners are entitled to compensation under Right to Fair Compensation Act, or are they, who are they entitled to developed sites in lieu of monetary compensation, also arise. Full stop. Next para. Admittedly, the lands were acquired way back in the year 1992. The petitioners first challenged the same in the year 2011, and by that time, the process of award and taking possession of the property had been completed. Full stop. This court has considered the aspect of this court has come to the conclusion based on the facts. This court in the said writ petition has observed that the writ petition is also liable to be dismissed on the ground of delay and laches. However, a concession has been shown to the petitioners insofar as it relates to grant of any sites, insofar as it related to considering their applications for grant of any developed land if it is permissible in law. Full stop. Thus, effectively, the petitioner is not entitled to argue on, is not entitled to raise a dispute pertaining to the final notification, the award, and also taking possession of the property. Full stop. Even otherwise, the case of the petitioner is that the original khatedars whose name found a place in the revenue records had died by the time award was made, and the respondents have deposited the award amount in the name of the said khatedars in spite of they being represented, that they being represented by the compensation has to be paid to the legal heirs of the deceased Khatidar. Full stop. Admittedly,
But on facts, millet, that may not be correct. May I give the two dates, millets? The award notice is dated 5/9/94. Mr. Kullappa died on 25/1/1996.
Said contention is the said contention is denied by the advocate for respondents, and it is submitted. The Khatidars were alive
On the date of issuance of
as on the
award.
date of issuance of
Award notice.
the award notice. Huh? Full stop. Even otherwise, the deputy commissioner is not authorized to decide dispute regarding ownership of the property, and whenever he has a doubt as to who is the owner of the property, he is required to make the deposit before the reference court, which has been done in the incident case.
Yes.
Full stop. Though
Then
it
in
is
the-
contended by the petitioners that the award does not have the previous sanction of the government, the same is refuted by the respondents. And they have placed relevant material on record to show that
No.
The award has been approved, millets, by the deputy commissioner.
No material placed,
No,
my
no,
lord.
it is there in the.
the award has been approved by the government in accordance with law. ಎಲ್ಲಿದ್ದಾರೆ ಅದು?
That there is a reference to millet, the approval of the award in the award notice itself. Millet. I'll point out.
It's all right. We presume that anyway,
Because
we don't have it.
Making an
Page
observation,
one-
material placed.
page
would not be right, no,
177.
Because no material is properly placed.
Annexure H1, page 177, in the individual award, there is a reference to the approval of the award on 6/8/1994.
Be that as it may, be that as it may, it is not open for the petitioner to adjudicate the same. Be that as it may, but if at all the petitioner, if at all, but the petitioners, if they are not satisfied by the award amount, they are always they always have the liberty to seek enhancement of the compensation before the reference court in the manner known. Full stop. Next one. As the process of acquisition is completed much prior to coming into force of Right to Fair Compensation Act, the question of awarding compensation under the said provision does not arise, and the petitioners are entitled to compensation as per the provisions of the Land Acquisition Act. Correct?
Yes.
1894. 1894, and the same has been done in the instant case. And I do not find any error in the same. Full stop. Next, with regard to possession still being with the possession, mahzars have been placed before this court. Which in my opinion is appropriate, and attention of the court is also drawn to section 16 clause 2 notification, which is dated 13/2/2002, which 13/2/2002 tane?
Yes, millets. Annexure R1.
Already been taken. Full stop. It is further, the records also reveal that layout map has been published by
Respondent number 2.
Respondent number 2, and the sites have been allotted in favor of third parties. And
Allotment letters also produced. my lords.
allotment letters also have been issued. And the area also has been developed. Full stop. Petitioners trespassing onto the land and putting up constructions thereon, and issuance of notice by the respondents to have them evicted does not give them any right to contend that possession has not been taken. Huh? Full stop. Next para. Under the circumstances, it has to be held that the acquisition of the lands concerned has been done in accordance with law. And petitioners have no right to challenge it. It has been done in accordance with. Full stop. The only relief that can be granted to the petitioners under the circumstances is that reserving them the liberty as stated in the impugned orders itself, to make necessary representation to second respondent along with all necessary particulars to grant them an incentive side as per the policy of second respondent. Full stop. If they make the necessary applications, then in that event, respondent number 2 is bound to consider the same and allot them incentive side if they are eligible. Full stop. Next para. Subject to the aforementioned observation, the writ petition is hereby dismissed.
Please, oblige.
Twenty-five, Girish Kodgi.
For his opponents. It may be taken on 13th, my lord. 13th.
Need to verify the notice acquired or not.
The final notification ಗೆ ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಬೇಕು
15th ಹಾಕ್ತೀರೇನ್ರಿ ನೀವುನಾ?
ಅಲ್ಲ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಇನ್ನೂ ಮಾಡಿಲ್ಲ.
13th ಹಾಕೋಬಹುದು. ನಾನು ಅಷ್ಟೊತ್ತು ಮಾಡಿಸ್ತೇನೆ.
June 2001 ಗೆ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ.
ಏನು?
ಅಕ್ವಿಸಿಷನ್ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ June 2021 ಮಾಡಿದ್ರು.
ಫುಲ್ ಬೇಕಾ ಕಡಿಮೆ ಮಾಡ್ಬೇಕಾ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಇಶ್ಯೂ ಇದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಕೊಟ್ಬಿಡ್ತೀವಿ ಫೈನಲ್ ಡೀಟೇಲ್.
ಅಲ್ಲ, see, June 2001 ಅಲ್ಲಿ preliminary notification ನೀವು ಮಾಡಿದ್ರೆ, if you are not done final notification till now, the notification goes. It's beyond reason. We can't consider it to be June 2001 ಏನ್ರಿ?
21.
1 or 21 now?
June 2021.
21. So, but the request of respondents call on?
13th or 14th.
The
13th.
difficulty is that, my lord, ಒಂದ್ ಕಡೆಯಿಂದ ಎಲ್ಲರೂ ಪೇಷಂಟ್ಸ್ ಇದ್ದಾರೆ ಪಿಟಿಷನರ್ಸ್, ಇನ್ನೊಂದ್ ಕಡೆಯಿಂದ ಬ್ಯಾಂಕಿನವ್ರು ಕೂಡ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಕೂಡ they wanted to take over the house where they are living in.
Let's see what's this. 14th. ಏನಿದೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನು?
Amendment to
ಬಿಟ್ಬಿಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್.
ಬಿಟ್ಬಿಡಿ
ಆಯ್ತು, we'll allow the amendment application. Let's see. Orders on IA 1/2024, the aforementioned application is filed by the petitioner to amend the writ petition. Full stop. Next para. The respondents have no objections in allowing the same. Okay? Full stop. Next para. Accepting the cause shown. IA 1/2024 is allowed. Petitioner is directed to amend the writ petition, file amended writ petition within a period of
2 weeks.
2 weeks from today. Right.
26, RC Nagaraj.
Date alla bada.
Date ಬೇಡ sir. 14/8 ಬೇಡ.
ಮುಂದಕ್ಕೆ ಹೋಯ್ತು.
RC Nagaraj, 26.
For the petitioner, file application for bringing LRs.
See,
serial number 24 ಅಲ್ಲಿ ಅವರು citations ಕೊಟ್ಟರು. ಅದು ಸ್ವಲ್ಪ chambers ಗೆ ಕಳಿಸಿ separate ಆಗಿ file ಅಲ್ಲಿ ಆಗೋದು. Relevant citations for other cases. Okay. Yeah. Just send it to the chambers. ಹೇಳಿ.
I filed an application for bringing the LRC. Petition number 6 has died. There's a delay of 44 days, my lords, filing the application.
Petition number 6 is right.
Please,
IA number?
Lord, it's IA number 1 of 2024.
ಬಂದಿದೆಯೇನ್ರಿ?
ಬಂದಿದೆ ಸರ್. R6
And
ಬಂದಿದೆ ಸರ್. R6.
there are 3 IAs. my lords.
R6.
R6.
Component number 6 daily.
Petitioner ಅಂದ್ರಲ್ರಿ?
Petitioner number 6.
ಇಲ್ಲ ಬಂದಿಲ್ಲ. Petitioner number 6 is right.
Petition number 6.
Yes. IA 1 of 2024 ಅಲ್ಲಪ್ಪ ಏನ್ರಿ ಇದು IA 3 ಇದು ಏನಿದು? Of 24 IA 3 of 24.
Please.
Renumber it. Orders on IA 3 of 24.
There's a delay of 44 days.
Is filed for bringing legal representatives of deceased petitioner number 6 on record. And also for continuation of delay. ಎಲ್ಲಿದೆ continuation of delay application?
Last IA ಹಾಕಿದ್ದಾರೆ. Under
Oh,
5.
ಹಾಕಿದ್ದೀರಾ? Separate IAS ಹಾಕಿದ್ದೀರಾ?
Separate IA ಹಾಕಿದ್ದು.
1, 2, 3 ರೀ. Orders on IA 1, 2, 3 of 2024 ಅಂತ ಮಾಡಿ. Orders on IA 1, 2, 3 of 2024. The aforementioned IAs are filed to bring of deceased petitioner number 6 on record. To condone the delay in filing the said application and also to set aside the abatement.
Please.
Set aside the abatement. Full stop. Accepting the full stop. It is submitted that petition number 6 died on 18/3/2024. Full stop. Accepting the cause shown, the aforementioned IAs are allowed. The proposed legal representatives of petition number 6 are permitted to come on record. Full stop. Petitioner is directed to amend the cause title and file amended petition within a period of 2 weeks from today. ಮಿಕ್ಕಿದ amendment ಎಲ್ಲ carry out ಮಾಡಿ.
ಮಾಡ್ತೀನಿ. I'll do it, my lords.
Okay.
Appeal remained.
Please.
Remained ಆಗಿದೆ ನೋಡಿ.
Yes.
27.
Yes, Aman.
Balaji. K. Krishna.
Yes, sir. Ready, yeah? You ready in entry government? Please.
Your Lordship heard this matter on the last date and directed me to get whether the 12-2 notice was served or not on that question.
12-2 of?
12-2 notice before passing the award, whether notice was issued to the petitioner or not on that question, my lord, because they sought the seeking liberty to enhancement of the compensation.
It's not the question of award itself was without notice to the petitioner. When the writ petition was pending, stay of dispossession, award can to be passed. 12-2 notice, they drew the merger of 2 persons, obtained a signature without an address. But these are all the questions. 12-2 should be always.
Where is the affidavit of the?
My lord,
Where is the affidavit?
original record is secured, my lord.
You secured the original record. Na torsi senior ge.
My lord, 12-2 notice was
Sir,
issued.
the short question is, award is challenged. Award was passed when the writ petitions were pending.
ನೋಡಿದಿರಾ ಸರ್?
ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅದು ಕಾಪಿ ಒಂದು ಎಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ.
ನಾನು RTI ನಲ್ಲಿ ತಗೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ 3/3/2000 there is a.
Just go on with the matter, sir. What is this?
Yes, my lord.
My lord, 12-2 notice was, my lord, issued. He refused to receive the notice by the petitioner. Then it was affixed in the presence of the 2 witnesses. And my lord, before the reference court, they represented before the court, my lord, they represented.
No, they are entitled to compensation under which provision?
My lord, the award was passed in the, as per the
Old Act or New Act?
old act, my lord. It was passed before the new act is coming into force. 2000 award was passed in
My lord,
2000.
2 times the award has been passed in 94. Award amount was deposited.
We'll go one by one, sir.
Yes, my lord.
Preliminary notification date, sir?
But the preliminary notification was
First, 19/1/89,
10/5/2.
19/1/1989, huh?
89.
Final.
Sixth,
19/1/94, my lord, is the
first,
first final notification.
19/1/94 is the first final.
Preliminary was 10/5/89.
19/1/1994. Yes, sir.
Preliminary.
10/5/89 is the preliminary notification.
10/5/89 ಅಂತಾರಲ್ಲ.
Yes, my lord.
Not 19/1.
Till the 19.
Then 19/1/1994.
Now get the dates properly, no? What is the preliminary notification date? He says 10/5.
19/1/1989, madam.
ನೋಡಿ ಅಪ್ಪ ಮತ್ತೊಮ್ಮೆ, how can there be? Take it up once again. See the preliminary notification, both of you.
The preliminary notification 19/1/1989.
Produce ಮಾಡಿದಿರಾ ಇಲ್ಲಿ?
ಮಾಡಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ?
Annexure A, my lord.
Well, page 240 kindly see, the date is mentioned in the award, 19/1/18.
This was published on 2nd February 1989, page 31. Then, my lords, final notification dated 19/1/1994. Then 19/1/1994, final notification. Now, this came to be quashed by this honorable court in a writ petition number 5042-45 of 1998. The order dated 31st August 98. On the ground, my lord, 18.3, there is no sanction of the scheme. But preliminary notification was retained. Then, final notification, my lord, as per law, after obtaining 18.3 sanction, was published on 7/10/2099.
7/10/1999, huh?
Yes.
After obtaining?
After obtaining this sanction.
18/3, huh?
Yes.
Huh?
Yes, my lords. Then, my lords, the petitioner also have filed a writ petition in WP number 1179-1180 of 2000. 1179-1180, 1170 of 2000, which came to be dismissed on 2nd July 2022.
Dismissed on?
This is, my lord, challenging the final notification.
2nd July 22.
Yes. My lord, during the pendency of the writ petition, there was a status quo granted by this honorable court on 3/3/2000, stay of dispossession was granted. 3/3/2000, stay of dispossession was granted. My lord, where the main writ petition was pending, they proceeded to pass an award on 12/5/2000. There are 6 to 7 survey numbers. On various dates, my lord, they passed. My lord, there was also an award passed under 94 notification. Amount was deposited to the civil court. and they tried to draw the merger of.
Sir, the writ petition was dismissed on 2/7/2002,
How's 2000?
2002. Award passed on 12/5/2000. Then what happened?
My lord, this award was without notice to the petitioner.
Twelve-two notice not issued.
My lord, that is also one of the ground on which.
Then,
My lord, before this honorable court, as against the single judge order, my lord, that is dismissed on 2/7/2002, we filed a writ appeal. In writ appeal number 4728 dash 4733 of 2022. Sorry, 2002. There is a stay granted, my lord, in the writ appeal.
stay of what?
Stay of, I think, my lord, dispossession. This was dismissed on 4/3/2023. Sorry, 3. 4/4 of March 2003.
4th of March?
2003. Then, my lord, the SLP was filed in civil appeal number 730 of 2004. Sorry, SLP number 9068 9075 of 2003. But when the matter came up before the apex court on 3/2/2004, leave granted, no interim order. 3/2/2004, leave granted, no interim order. So that came to be dismissed on 7/9/2010.
Dismissed on?
7/9/2010. My lord, these petitions have been filed. My lord, on 3 grounds, my lord. Sorry, 4 grounds. Number 1, when the stay of dispossession was granted on 3/3/2000, the award of May 2010 could not have been passed because there are various awards, about 6 survey numbers. It was passed on 3/5/2000, 23/5/2000. My learned friend has given the dates, my lord, in the 17/5/2000. My lord, I have placed on record the awards which are placed on record. As on that date, the writ petition is pending. I am available before this court, not only myself, my lawyer. The stay of dispossession, awards have been passed without notifying to me.
Now, first question. Was this contention taken up in writ appeal and SLP?
Pardon, lord?
Was this contention taken up in writ appeal and SLP?
That exactly pleadings are not before the court.
Pleadings idre ತಗೊಂಡ್ ಬನ್ನಿ.
Just one submission.
Tried best my lord.
ಅಲ್ಲಪ್ಪ ರಿಟ್ ಪಿಟಿಷನ್ ರಿಟ್ ಅಪೀಲ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಇಲ್ಲ ಏನ್ರಿ?
ಅದು pleadings ಸಿಕ್ಕಿಲ್ಲ.
ನೀವು ತಗೊಂಡ್ ಬನ್ನಿ.
2000 ಅಲ್ಲಿ disposal.
One submission. If any proceedings contrary to the interim order, it is a nullity.
Sir, the point is,
Yeah.
if those pleadings are already made and that has been considered by the writ appeal court and Supreme Court, then that acts as a res judicata.
But the Supreme Court did not go. Punacha case, your lordship knows about the presidential assent. Writ appeal, they said The all acquisition came to be, proceedings came to be challenged in the connected writ petition, therefore we upheld the acquisition. This question has not been gone into. In fact, there are one aspect of the matter. Blood, an aggrieved person can challenge the writ petition on 6 stages. One is preliminary notification, 6, then the award notice has not been issued, then 16, 2 notification, then there is no vesting. This is covered by 2012, 12 SCC 442 Anil Kumar case. The apex court said the owner can file a writ petition at various stages.
Yeah.
Now, my lord, we have drafted.
Citation. Rajeshwar case.
In fact, the first judgment which your lordships have laid down under the scheme section 27, that is a monument, my lords. In fact, we have relied on before his lordship Krishna Kumar Jay, where your lordships have interpreted, so far as section 27 is concerned, where by operation of law, if 36 becomes inoperative, where is the question of the survival of the acquisition? Now, my lord, if the award, there are 2 aspects. If the proceeding, if there is a stay of disposition, the apex court said if the stay of disposition amounts to stay of all acquisition proceeding. That is one aspect. If further proceedings, if you are going to take contrary to the interim order, it is nullity. Therefore, my lord, we have proceeded on the footing that the earlier award proceedings, in fact, one stage, my lord, they passed an award in 98 because the final notification came to be caught.
16 to yavagaitu, sir.
My lord, 16 to.
See, what was ordered was stay of disposition, not stay of award.
No, stay of disposition amounts to stay all acquisition proceeding.
No.
That's the interpretation.
Where do we get it?
I will give you.
16 to yavagaitu.
May I take your lordship's page, serial number 20 and 21. Page 150. In fact, there is one more development. My Lord Justice Arun Mishra said, if there is a stay of only one single number, the entire notification, that is in 2018, that is not applicable. Page 150, my lords. 1998, 3 SCC 556.
Sixteen to yavagaitu.
16 to my lord, not available my lord. Because of the litigation, the ಬೇರೆದಕ್ಕೆ ಇದು ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
Lord, all these proceedings would not stand because if award is without notice to me, that has to go. Section 9(3) of the Land Acquisition Act, I must be notified. Then, my lord, you are going to take the possession based on an award, and compensation shall be paid before taking possession. In Constitution bench judgment, my lord, what in paragraph 168 says, 2011, 3 SCC, page 1, that under section 16 of the Land Acquisition Act, you can take the possession only after an award is passed and compensation is paid. Now compensation is not paid and award is without the knowledge and contrary to the interim order. Not all that, my lord, I am appealing to your lordship. There are 2 reliefs, my lord, which I am seeking. In fact, the apex court also said, if you don't accompany the award copy along with the 12-2 notice, what my learned friend, I refuse, I never refuse. What they say, in the mahzar, Muniappa, Krishnappa, who are not the resident of that village, they obtained the signature, I refused it. 12.2, when a writ is pending, writ appeal is pending, stay of disposition is there. Where is the question of my lord 12.2? They should have taken the permission of your lordship and passed an award. That is a different matter under the transfer of property. Now that is one aspect. The
What
second
this,
is
what is this case law, sir? 98.3 SEC 556, you are relying on.
556, my lord, this is stay of disposition amounts to stay of all further proceedings. Paragraph 7, I will just read it, my lord. My lord, may I take, my lord, classicum B? Putty, one volume putty. Putty. That even if the stay of disposition grant while considering the challenge to section 4.1, the amount to stay as contemplated by explanation. ಮಧ್ಯದಲ್ಲಿ ಬಿ ಕ್ಲಾಸಿಕಮ್ ಬಿ ಆದ್ಮೇಲೆ ಓದ್ತಾ ಇದೆ.
ಕ್ಲಾಸಿಕಮ್ ಡಿ ಆದ್ಮೇಲ?
ಎಸ್, ಬಿ ಆದ್ಮೇಲೆ.
ಬಿ ಆದ್ಮೇಲ?
ರವಿ ಇದು ತಮಿಳ್ನಾಡು ವಸಂತ್ ಬಾಯ್ ಅಂಡ್ ವೆಂಕಟರಾಮಪ್ಪ so that even stay of disposition granted by the court while considering challenge to section 4.1 would amount to stay as contemplated by explanation 1-2 section 6. Consequently, it has to be held that the period during which there was a stay of disposition, that is from 2793 to 18.1, amounting to almost 6 months.
That doesn't inure to your benefit, sir, this observation. They can harp on it if there is any delay in their.
Pardon, lord?
This does not inure to your benefit. They can harp on it.
No, stay of disposition amounts to stay of all next
No,
page.
sir, this was in contention with that within 2 years that has to be made.
11A, page 155, ink page.
And also pertaining to section 14.
This is also, my lord, is interpreted in 2018. There are 2 judgments where stay of disposition amount to stay of all for acquisition.
Where is it? Show me.
Illi page 155. That is, my lord, it is no doubt.
Here I want to ille. Where is it?
11A is 155, my lord, 1997.
Hele.
The question of the High Court had been drawn to the stay order dated whereby during the pending writ and the disposition of the petitioner has been stayed by the High
Sir,
Court.
this is in reference to.
Correct, my lord. Stay of disposition amounts to.
No, sir, that is only with regard to.
11A.
Ashta. They can harp on it, you can't harp on it.
No, 11A is in favor of the owner. I can take the benefit of it.
Sir, period within which an award shall be made, the collector shall make an award under section 11 within a period of 2 years from the date of publication of declaration. Now, what happens? For some reason, there is a stay of disposition, not further acquisition proceedings. Mind you, there is no stay of further acquisition proceedings. Instead of it, the interim order is worded, there is stay of disposition.
Lord Yusuf's case.
Sir, stay
No,
of disposition.
the entire.
If that observation is made, then they may feel, okay, it is not worth going ahead with the acquisition proceedings any further. Then for 11A, the 2 years limitation, time is extended to them by excluding the period for which there was stay on disposition. If they decide, okay, fine, we go ahead with it and do all other formalities required, other than dispossessing you physically, then in that event, okay, you cannot say what they have done is wrong if your writ petition is subsequently dismissed.
Dismissal of
They dispossess you, yes, they are at wrong. When there was stay of disposition, if they dispossess you, you can haul them up for contempt. But when there is stay of disposition, they complete other formalities. You cannot say that they should not have gone ahead with it at all.
That I think I will have to take out 91 Supreme Court, my lord. This concept has been discussed and again 2018 and 19, two judgments. Your lordship may take it on some other day. I will not ask for adjournment. And this
This
interpretation.
is my view, sir.
Illa.
You're always show me, you're
No,
at
my lord.
liberty to show me the other
Your
way.
lordships are entitled to take the view, but it is my duty, my lord, to assist your lordship. No. Dispossession amounts to stay of acquisition. So therefore, if it is stay, then computation of 2 years is a different aspect. The provisions of the Land Acquisition Act will have to be interpreted in favor of the owners.
Okay, Nodi, this is my view. You also look into it.
Illa, adon
Also find out when 16.2 was done.
Yes.
And also try to lay your hands on the pleadings in writ appeal and SLP. Tavu ದಯವಿಟ್ಟು ಅದನ್ನ ಇದ್ರೆ ಒಂಚೂರು produce ಮಾಡಿ. Okay, if the aspects are already agitated and covered, then let's see how it goes. Yes.
My lord, all that, my lord, I am appealing to your lordship says, it is an admitted fact that the award is without notice to me.
Let's see, let's see.
The award is during the pendency of the.
Sir, he is disputing it, sir.
Award says, my lord.
Let's see, sir. Let's see.
Award says.
We'll examine it. When do you want it, sir? Whenever you want, I'll post it.
After 1 week, my lord.
ತಗೊಳ್ಳಿ ನಿಮ್ಗೆ ಬೇಗ ಡೇಟ್ ತಗೊಳ್ಳಿ.
14. 16 ಆಗಲ್ಲ 20.
21st.
At the request of petitioner, call on 21st. Yes.
ಅದು 12 notice ಜೊತೆಯಲ್ಲಿ award ಇಲ್ದೇ ಹೋದ್ರೆ all that, my lord, I am entitled for benefit of now going for a reference. That is all, my lords.
Done. No, let's see. Yes, sir.
28 Subhash Shastri, HL Pradeep Kumar.
My lords, I appear for respondents council, my lords.
Yes, sir.
Serial number 28.
Ready?
Ready.
Yes, sir. Please go on. You are ready, sir?
Yes, my lords.
Yes, please go ahead.
Preliminary notification was issued for acquisition of 1,103 acres and 37 guntas. And date I will give you. Anakshari, please. This is March 24th.
Should I give it?
24/3, which year?
Preliminary notification is dated 24/3/2011 and final notification is dated 7/2/2011.
7/2/2011.
13, sorry, I'm sorry, 13.
To an extent of?
1,100 plus acres was the preliminary and it was restricted to 350 acres in the final notification. In fact, my lord directed us on 4/1/2024 to file an affidavit as to why this extent was reduced to 350 acres, and we have filed an affidavit explaining the reasons. On 4/1/2024, your lordship passed the order. On 29/1/2024, we have filed an affidavit.
That copy is not served on me, my lord, the affidavit. They say that they have sent it by RPD, but so far I have not received.
Copy ಕೊಡ್ರಿ.
No, it is served on them, lords. In fact, it was
by RPD, they say, but I have not received.
You want
that
time now? What do you want?
Let me serve that affidavit copy of, so that I can.
So he is asking for time now because he doesn't have a copy of. I have asked Pradeep to give a copy.
They have sent it by RPD to the old address which I have not received. Last occasion also I made the same submission.
Okay, when do you want, sir?
Court itself, Lord, ಕೊಡ್ತೀನಿ.
When do you want?
Anyway, next Monday.
Date ಕೊಡಿ.
No,
The
no
request
problem.
of petitioner call on
13th.
server copy.
13th better, Swami, your lordship may kindly have it on 12th also. 12th.
Yes.
11th also is okay, my lord. 11th is also.
Sir,
Sorry.
11th to.
11th is.
I'm sorry, my lord. 12th is okay.
Yes, sir, 12th.
12, 29 adjourn. 30. H.N. Basuraju. H.N. Basuraju, serial number 30.
Lord, I am appearing for the petitioner. Lord, I work one more week, my lord, to get instructions in the matter, my lord.
Sir, it's a 2014
Yes, my lord, last week, my lord, after the BDA has given a proposal, my lord, we are ready to consider under 38D. Lord, I have to get instruction, my client, my lord, from my client, my client, my lord, is not in a position, he is a bedridden. Therefore, my lord, I want one more week only.
I did told, the
Please.
request of petitioner finally call on.
12, 8.
Much okay.
12 ಓಕೆನೇನಪ್ಪ?
ಆಗ್ಬೋದಾ?
ಆಯ್ತು, 12
Much okay.
31, Ashwini Rajgopal.
With my lord's kind leave, I appeal for the petitioner, please, my lords. This, my lords, the BDA has filed its reply statement, my lords. I pray for, I've sent the rejoinder, my lords, for approval, my lords. I need a week's time, my lords. I'll file it during the course of the week, please.
The request of petitioner call next week. Date ಕೊಡಿ, call on.
Interim order may kindly be extended, please.
13, 8.
13, no further adjournments, okay?
Please, my lord. Interim order may kindly be extended.
If any is extended-
Grateful to my lords.
32 adjourn. 33, Prakash T. Abbar. TP Vivek Desai SV.
ಹೇಳಿ sir.
Lord, there is a delay of 19 years, Lord, after the preliminary notification. So under the ground that no award is passed, nothing has happened after the final notification. 19 years have passed. So therefore, Lord, I filed this writ petition to quash the acquisition proceedings in view of section 27 of the Karnataka Urban Development.
Yes. Go up, yes.
SV Desai. SV Desai.
Yes, I need 2 weeks time.
Why, sir? Why 2 weeks? Tell me.
Because I have to get the instruction from other section to find the objection.
Sir, it's
They have sent some papers, my lord.
2021.
Yes, yes.
matter.
Lord, 19
Grant you time, but not 2 weeks. Okay. Award has not been passed, position is not taken.
Nothing.
See,
Acquisition proceedings are not complete.
Yes, only 4-1 has been done. So they have sent 2 notifications to me. Some doubt is there.
you
And
ask
also,
them.
and also they, according to them, they formed the road, it seems.
Sir, listen. You ask them what happened pursuant to 1997 and 2001.
Yes, yes.
If they have formed a road, okay,
Up to what extent they have taken the land?
we will regularize it
Please.
with compensation payable as on the date of survey.
Yes.
To be done at a future date,
Yes.
not as on the date of preliminary notification.
But they have sought some other prayer in this case, my lord. For the joint venture like that, they have sought the prayer also.
What joint venture? Forget all those things.
Yes, please. I'll get the
Nothing
instruction.
I wanted
See,
to
listen, 1997 preliminary notification, 2001 final notification.
Yes.
If no award is passed, no position is taken, then automatically the notification will have to be
Yes,
set aside.
yes.
However, you had already formed public road with his consent. I'm telling you, with his consent, we are going to save your public road.
Please, please,
Okay,
please.
provided a fresh survey will be conducted
Yes,
within whatever date.
yes, yes.
And you're going to pay him the compensation as on the
Yes.
date of survey
Please.
and not as on the year of 1997.
Yes,
Okay, that would be a fair order.
please.
So your time, everything
Ye-
will be
Yes,
saved,
yes,
everything. It's good for everybody.
yes. 2 weeks, 2 weeks. By that time, I will collect all information. Please.
That's all what
Yes.
remains.
Yes, my lord, I understood.
Okay, other lands, you give it back to them.
Yes. Please.
The notification is set aside in respect of other lands.
Yes.
But with regard to road, he
Yes.
gets the compensation
Yes.
as on the date of survey being conducted.
I've passed such order in.
No, only thing is here, I have not filed the object statement. So by next date, after next day hearing, it can be disposed.
That's all.
Please.
Yes, sir.
1 week time maybe.
ಅಲ್ಲ 1 week ಇಲ್ಲ ಇದು.
ಏನಪ್ಪ,
ಬಹಳ ಓಲ್ಡ್ ಇದೆ ಅದು ಅದಕ್ಕೋಸ್ಕರ.
According to me, I have yet to confirm whether the road is formed or not. Because nothing has proceeded.
ಅಲ್ಲ, that's why to, in the interest of
Let
the
them
petition
say
also.
so. They will know what it is. You can't ask them to lie around for that.
I will also.
Land also with them only, we are not doing anything also.
So the request of respondent number. Which respondent?
2 and 3.
2 and 3. Call on. Ya date beka date ತಗೊಳ್ಳಿ sir, but ಅವತ್ತು ಮುಗಿಸಿ.
2 weeks.
2 weeks ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ. 20ನೇ ತಾರೀಕು.
ಇನ್ನೊಂದು 2 ದಿವಸ.
ರೇ ಸ್ವಾಮಿ 20 ದಿವಸ ಕೊಡ್ತಾ ಇದೀನಿ. ಎಷ್ಟು ತಾರೀಕು?
Today we are 5th. 2 weeks ಅಂದ್ರೂ ಅಷ್ಟಾಗಲ್ಲ.
2 weeks ಅಂದ್ರೆ 2 weeks ಕೊಟ್ಟಿದ್ದೀವಿ.
Please. Next time I should not take time. Before that I will profile.
On 20th you finish it.
Please.
Finally
Please.
call on 20th. No further adjournments.
Please ask my director registry to delete my name.
Yes, sir. A registry is right to delete the name of TP.
Even my Okalat also returned, they mentioned, I don't know in what way it is.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿ.
Great.
34 Siddharth Suman. Ajay Kumar.
Please, but I appear for the petitioner's counsel.
Yes, sir.
Salpar, no, I don't will not complete the
When do you want it, sir?
anytime convenient because I am asking time, so therefore anytime convenient. to the court.
Any time is convenient for us. You take a date of your choice, we'll do it on that day.
20th ಆಗ್ಬೋದಾ?
20th. Is it okay for the respondents?
Whatever is convenient to the court and senior counsel. We will not say anything.
20th, sir. Yes, the request of petitioner call on 20th.
Please.
35 HS Santosh, Ajay Kumar.
With your lordship's kind leave, my lord, I am appearing on behalf of the petitioner.
For respondent matter.
My lord, petition for a writ of mandamus for consideration of representation at annexure Q, my lord, page 46.
The case is this. Case is this, Mullas, that the site which was allotted and CLD and all was executed. There was some writ petition which was filed. And there's an order passed by this honorable court in the year 2019, holding, Mullas, that the lands insofar as where this particular site is formed, that survey number, the scheme is said to have been lapsed. That's the order which has been passed. I've just sought for instructions, Mullas, whether writ appeal has been filed and any further action has been taken up.
Listen, if you get back that land, allot that particular land.
What?
If you get back that land, allot that particular land.
Please.
Otherwise, allot him an alternative.
Please.
I'll pass that order and I'll dispose it.
May have this matter this week itself someday. Thursday or Friday, let me just put it on record.
Listen. Rightly or wrongly, you have allotted a site to his mother.
Please, I follow them.
Okay.
I follow them.
And sale deed was executed. It was not lease cum sale agreement.
Please, that's the reason
A sale deed was executed.
Please.
For reasons beyond your control, the site is not available.
Please.
To be enjoyed by the allottee.
That's
because it has been denotified now.
No, not denotified, my lords. This honorable court has held, my lords, the scheme has lapsed. If I have executed sale deed, I have a handed over position, my lords, scheme lapse could not have been passed. It could not have been held that a scheme has lapsed. That is the reason.
Okay.
That is the only reason.
When do you want?
Let's next Monday get the whole.
Next Monday, sir, is it okay with you?
Please, my lord, please.
The request of respondents call on Monday date.
12.
Grateful.
Today all matters are collapsing.
36.
Everyone is taking time.
Number 36. Satraj Baba.
Respondent.
Ready? Why next week?
Now.
2010 ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಅವಾರ್ಡ್ ಆಗಿದೆ, ಸ್ವಾಧೀನ ತಗೊಂಡು ಕಾಂಪೌಂಡ್ ಡಿಪಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ. The grievance is also for payment of compensation. Because of the suit pending, my lord, we could not disperse. We are departed before reference court. They can work out before reference court.
They work it out in your reference court.
Yes, LAC numbers ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ. That is the whole grievance. Though the prayer is for quashing of the notification, the pleading shows only for payment of compensation.
What grounds you have said that,
But still today, they are not taking possession, my lords. And second thing is, my lords, there is a price fixation committee report, my lord. They are not considered that report, my lord, as per the price fixation.
you want compensation, no?
Compensation and till today, they are not taken possession, my lord. That is why, that is the reason why we are.
I have said position is taken, award is passed, the amount is departed for reference court, they themselves are given LS numbers also.
Page 169, my lord. Also involved residential house, my lord. We are paying electricity bill, my lord. 169. We have produced electricity bill also, my lord.
That's okay.
We are in the possession of the property, my lord.
When they start for,
Withdraw the compensation amount also.
No ground, sir.
Like 1 week time, my lord. To prepare.
No, sir.
it is settled law, that once they start for compensation, they cannot enter into question the notification.
Position out,
The position is taken on 5/4/2019, my lord.
compensation deposited,
No, 13/6/20, award passed on 26/7/2019, deposited on 13/6/20. That is themselves have produced the notices also.
KDB,
Okay.
Bane.
Before the reference court, because the suits are pending.
Lands of the petitioners have been acquired by way of, have been acquired for the purpose of respondent number 2, KADB. Full stop. In this regard, preliminary notification was passed on 19/7/2010. And final notification was passed on 10/2014. Full stop. Subsequently, physical possession of the land also has been taken and on it, and it is submitted that on 13/6/2020, compensation has been
Award passed on 26/7/2019 because of the dispute.
has been taken, and award has been passed on 26/7/2019.
Annexure C.
And the same has been deposited before the reference court. Full stop. Next, the petitioner has challenged, alla continue ಮಾಡಿ. ಮೇಲ್ಗಡೆ ಏನ್ ಬಂತು ಸ್ಟಾರ್ಟಿಂಗ್ ಹೆಂಗ್ ಶುರು ಆಯ್ತು? The petitioner aggrieved of of his lands being acquired has challenged the same. Full stop. Next para. Objection ಹಾಕಿದಾರ ಅವರು?
ಹಾಕಿದ್ದೀನಿ, ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ 28(3) ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರ?
ಅಲ್ಲ, ಅವ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳ್ತಾರೆ, ನಮ್ಗೆ ದುಡ್ಡು ಕೊಡಿ ಅಂತಾನೆ ಕೇಳೋದು.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅದು?
ಅಲ್ಲ, ಅವ್ರ ಗ್ರೀವೆನ್ಸ್ ಆದ್ರಲ್ಲ ಅದನ್ನ ಹೇಳೋದು, ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತಾರೆ. ನಾವು ಕನ್ಸಲ್ಟ್ ಕೊಡಕ್ ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಎಲ್ಲಿದೆ ಅವ್ರದ್ದು?
ಈಗ
ಮನೆ ಇದೆಯಲ್ರಿ, ನೀವು ಮನೆ ಬಿಟ್ಟು ತಗೋಬೇಕಲ್ವಾ? ಮನೆ ಕಟ್ಟಿದ್ರೆ ಮನೆ ಬಿಟ್ಟು ತಗೋಬೇಕಲ್ವಾ?
page 125, they are seeking for compensation. Annexure D series. Request you to pay the compensation 30 lakhs per acre. They are seeking only compensation.
ನೀವು ಸರಿ ಇದೀರಾ?
ಅವರ ದುಡ್ಡು ಕೇಳ್ತಾ ಇದಾರೆ, ಅವಾರ್ಡ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸೂಟ್ಸ್ ಇದೆ ಪೆಂಡಿಂಗು.
Come to page number 119.
We have made representation.
ಅಲ್ಲಪ್ಪ 119 ಏನಪ್ಪ ಹೇಳ್ತೀರಾ?
Please.
ಎಲ್ಲದರಲ್ಲೂ ಎಲ್ರು ಅದೇ ಹೇಳಿರೋದು. ಎಲ್ರು ಅದನ್ನೇ ಹಾಕಿದ್ದಾರೆ, ರೆಫರೆನ್ಸ್ ಕೇಳಿದ್ದಾರೆ.
In view of the same, we did not object for acquisition of the land belonging to us. Huh?
ಹೌದು.
You go say that we further state that we have no objection for the proposed acquisition of our land
ದುಡ್ಡು
for
ಕೊಟ್ರೆ
industrial
ಸಾಕು ಅಂತ
purpose, and our only concern is about compensation.
ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು.
ಏನ್ ಬಂತ ಹೇಳಿ?
They are not taking position.
As HAS, has challenged the same. Full stop. Next para. Materials placed on record reveal that the petitioner never objected for acquisition of his lands, of their lands. Petitioners alva. Petitioners never objected for acquisition of their lands. But only have raised concerns about the amount of compensation determined by the authorities concerned. Full stop. Further, the records reveal that the lands are agricultural in nature, and there is no impediment for the authorities to acquire the same for industrial purposes. Full stop. No valid reason is assigned by the petitioner in either by the petitioners in either their representations to the authorities concerned or in the writ petition as to why their lands should not have been acquired by the state. State. Full stop. Further, it is not the case of the petitioner that further the acquisition further the acquisition has been done in accordance with law. Further, the acquisition has been done in accordance with law. Full stop. Under the said circumstances, the writ is liable to be dismissed. Full stop. However, dismissal of the writ petition will not come in the way of the petitioners to agitate before the reference court for higher compensation in the manner known to law. Full stop. Further, consent award ಏನಾದ್ರು ಬೇಕಾ?
ಅಲ್ಲ, ಕನ್ಸಲ್ಟ್ ಅವಾರ್ಡ್ ಕೊಡೋಕೆ ಏನಾಗಿದೆ, ಸೂಟ್ ಇದೆ, ಅವರೇ ಹೇಳ್ತಾರೆ, ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ.
ಸಾಕಷ್ಟು. Full stop. Next para.
Residential housing.
Subject to aforesaid observations, the writ petition is hereby dismissed.
They cannot seek for enhancement for reference court. They have to make application for the land action officer only, as per law. ಅಲ್ಲ, 18 ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲೇ ಕೊಡಬೇಕು, ಇವ್ರು ರೆಫರ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ. ಇನ್ ಟೈಮಲ್ಲಿ ಕೊಡೋದೇ ಇದ್ರೆ ಅದು ಹೋಗ್ತದೆ ಅವ್ರಿಗೆ. ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ.
Make necessary request for higher compensation in the manner known to law.
ಅಷ್ಟೇ.
In the manner known to law. Yes.
37. Prakash T. Abbar, Hanumantaraya D. Ni Krishnan, N.R. Jagdishwar.
For the
37, N.R. Jagdishwar.
Objections.
Sorry, my lord, yes,
Doesn't matter. I understand. Monday hakolli. One probably my lord, they have filed a circular now. I may have to challenge it.
Yes.
Monday hakolli.
The request of petitioner call on Monday date.
12/8. 38, D. Prabhakar.
And the same lots. This court has already set aside the acquisition proceedings in respect of several of the lands.
Covered by annexure C, page 61, my lords.
Nothing after PN,
Yes.
Nothing after preliminary notification. The lands of the petitioners have been sought to be acquired for the purpose of second respondent Muda, and a preliminary notification dated 28/6/2016 was issued. So, however, it is submitted that thereafter there is no progress. However, it is submitted that thereafter there is no progress in the acquisition proceedings.
Final notification is not yet issued.
And the same have been abandoned. Full stop. For that reason, it is prayed that the preliminary notification, insofar as it relates to the land of the petitioner, be set aside. Full stop. Next paragraph. The aforementioned submission of the petitioner is not contravened.
But in the light of annexure, Your Lordship may kindly say.
Is not contravened
But in
by the respondents. Respondents. Full stop. Next paragraph. The acquisition proceedings have to be completed by the authorities concerned at the earliest and within a reasonable period. Full stop. Delay of 8 years in issuing final notification. Delay of 8 years. In spite of delay of 8 years, in spite of delay of more than 8 years, final notification has not been issued in the instant case, and the same cannot be considered reasonable, and the acquisition proceedings are liable to be set aside. Full stop. However, setting aside of the acquisition proceedings will not come in the way of the authorities concerned to initiate fresh proceedings in the manner known to law. Full stop. Hence the following order. Writ petition is allowed. Sentence segment previous paragraph. In spite of the banta. In spite of in spite of mele in banta. Hence the following order. The preliminary notification dated so and so, bearing number so and so, issued under Karnataka Urban Development Authorities Act 1987 by respondent number 1. Respondent number 1 tana?
No, minute, 2 minutes. Preliminary notification will be issued by the authority.
Respondent number 2 is hereby set aside insofar as it relates to the lands of the petitioners are concerned.
Item number 41 is also.
See.
41.
Please.
Rajkumar, government advocate Rajkumar. 39, Hitesh Gowda.
This is the 5th round of litigation before this honorable court. My lord, in every, I've succeeded in every round of litigation.
How much time will take? How much time will take?
Just 15 minutes just to.
We'll continue at 2:30.
Please.
Yes, anybody wants any adjournments?
Not, maybe taken up on next.
We are ready, no? 2:30, finish it off.
Senior
Adjournments?
engaged, but till the 45.
2:30 ಮಾಡಿ ಏನೇ?
Serial number 10.
45.
Serial number 10. I have filed.
10 ನಾ?
Yes, my lord. Pass over ಆಗಿತ್ತು ಬೆಳಿಗ್ಗೆ. I have filed the memo for withdrawal, my lord.
10 ನಾ? ಕುಡಿಯೋದು, ಮೆಮೊ ಕುಡಿಯೋದು. 10 dismissed as withdrawn.
Counter Friday ಕೊಟ್ಟಿದ್ದು.
45.
Dismissed as withdrawn.
ಬರ್ಕೊಡಿ ಗ್ರೀನ್ ಶೀಟ್ ಕೊಡಿ. ಒಂದು ಬರ್ಕೊಡಿ.
ಒಂದು green sheet ಬರ್ಕೊಡಿ.
45 months.
10 ಗೌರ್ಮೆಂಟ್ ರಾಜ್ಕುಮಾರ್ ಸರ್.
ಕಲಾಸ್ ಬಂದಿದೆ 45.
ಏನ್ ಬೇಕು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ?
ಈಗ ಫಸ್ಟ್ ಕೇಸ್ ಇದು ಬಂದಿಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ಮೂವ್ ಮಾಡಿ
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರು ಡೇಟ್ ತಗೊಂಡಿದ್ದು
ನಾ ಡೇಟ್ ಅಲ್ಲ ನಾವು ವಕಾಲತಿಯಲ್ಲಿ ಬಂದಿಲ್ಲ ನೋಡೋದು ಬೇಕಿಲ್ಲ
ಯಾಕಂದ್ರೆ ಸುಮ್ಮನೆ
ಕೇಸ್ ಇದು SC ಮ್ಯಾಟರ್
ಅಲ್ಲ SC ಅಲ್ಲ ನಾವು ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಏನು ಅಕ್ವಿಸಿಷನ್ ಏನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ ನಮ್ಗೆ ಇನ್ಸ್ಟೆಡ್ ಆಫ್
compensation, we are requesting the developed land ಕೊಡಿ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ. SC ST
ನೋಡೋಣ ಬಿಡಿ ಸರ್ ಏನೀಗ.
ನಾನು ವಕೀಲಾತ್ ಬಂದ್ರೆ ಏನು ಬಂದಿಲ್ಲ.
ಅವರು ಇದೇ ತರ ಹೇಳ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. ಬಿಫೋರ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ವಿ ಸರ್ವ್ಡ್ ದ ಕಾಪಿ.
ಫಸ್ಟ್ ಕೇಸು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ.
ಆಯ್ತು ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ.
2 weeks ಬೇಕಾದ್ರು ಎಲ್ಲ ಕವರಿಂಗ್ ಲೆಟರ್ ಎಲ್ಲ ತರಿಸ್ಕೊಂಡು
ಪದೇ ಪದೇ ಹೇಳ್ತಾ ಇದಾರೆ. A time may be fixed, reasonable time may be fixed.
Okay, live it on 19th.
45.
45 at the request of respondent number 2, call on 19th.
46, my lord.
47, my lord.
46, government will have to file objections, whether my land is acquired or not. Government has not filed objections till date.
Yes, government.
2 weeks time.
The date won't matter. What is
19th.
36.
the request of AGA, call on 19th.
19.
46.
Serial number 47, my lord.
Appear for the
Point to file
petition.
objections.
Lordship, it's been,
Of respondent number.
it's been over a month. I appear for the petitioners, your lordship,
I will
since
give
25/6. May I kindly have it?
1 week.
Tuesday as
2 weeks.
finally, your lordship.
2 weeks at least. 2 weeks.
1 week. Lordship, it's been more than over a month, your lordship.
All right. 47 also 19th. Okay.
Lordship, Tuesday, next week.
So, all right. They will again ask for time, I say, and it's BDA.
Lordship, it's been over a month. The educational institution is being run on the scheduled premises. That is the
Serial.
Without fail, do it.
Yes.
It may be recorded as finally, your lordship.
Fine.
For submission.
The
Obliged.
request of,
My lord,
respondent finally call on 19th. Somebody's. What is over?
serial number 40.
54. Date given matter, part 2014, why should we adjourn it? The request of petitioner, call on 54, date kodi appa next week.
13/8.
13/8.
Serial number 48.
No further adjournment on that day, sir.
Serial number 48.
Matter is covered, my lords.
ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ಬೋದು. ಬೇರೆ 2 7 8 ನಾಡಿದ್ದು ಹೋಗಿದೆ.
The other two matters which were there today is also adjourned today afternoon.
48 at the request of petitioner, call, request of parties, call on another date.
7/8.
One second, Basuraj.
Please, my lord, 42, my lord. The case of the petition is, my lord, to consider the representation and it's a case of the petition is alternative site. So consider the representation. You will consider the representation in accordance with law.
ಆಯ್ತು ರೀಚ್ ಆದಾಗ ಹೇಳಿ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾತ್ರ ಇವಾಗ.
Serial number 44, my lord,
ಹಾ.
for filing of objection, 2 weeks.
Mandamus notes. The amount is deposited by the.
If she wants some time, we'll grant her some time.
We'll just file objection and my lord, then the honorable court.
The
will
request of respondent number 2 and 3, call on 19th.
19/8.
No further adjournment, madam.
For filing of objection.
Your lordship, serial number 6 in list 2, my lord.
Second list.
Second list. Your lordship, kindly grant 2 days time, my lord, to rectify the.
ಬಂದಾಗ ಹೇಳ್ರಿ 230 ಲಿಸ್ಟ್ ಅಲ್ವಾ ಅದು.
Liberty mention.
My lords, serial number 10,
Yes,
I
ma'am.
have filed the memo for withdrawal, liberty to file the fresh, my lords.
Why liberty?
Some mistakes ಇದೆ ಮತ್ತೆ add ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ, request.
Then ಹಂಗಾರೆ we'll take it up at 230, madam.
230.
Mention it at 230.
ಕೊಡಿ ವಾಪಸ್.
ಇದು serial number 10.
ವಾಪಸ್.
ಶಿವರಾಮ್ಕಾಂತ್ ಲೇಔಟ್.
ಏನ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, 230 ನೋಡೋಣ.
ಶಿವರಾಮ್ಕಾಂತ್ ಲೇಔಟ್ ಆಯ್ತು. DB ಹೋಗ್ಬೇಕು. ಶಿವರಾಮ್ಕಾಂತ್ ಲೇಔಟ್.
ಹೋಗ್ಬೇಕಾ? ಆಯ್ತು, serial number 10 ಈ ರೀತಿ ಮಾಡಿ. It is submitted that the matter pertains to Dr. Shivram Karantayot. Registry is directed to post the matter before the appropriate bench. Dismiss ಬೇಡ. ಅಲ್ಲಿ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. Liberty ಕೇಳ್ತೀಯಾರಲ್ಲ. So let it go there.
Liberty to file the fresh.
Shivram Karantayot, madam, separate bench is there. That's
Yes,
the
my
reason.
lords.
Pass over.
Lord, one submission. Second list, Lord, 230 Mac. Serial number 14, kindly have it next week.
Yes, who appears to the other side? Serial number 14 in second list. ಹೇಳಿದಿರಾ sir other side?
ಇಲ್ಲ ಹೇಳಿಲ್ಲ.
The comment object, sir. Okay, anyway. When you want, take a date on that day, no further adjournment, it's a 2018 matter.
Please,
Stay idea.
stay ಇದೆ.
This is the problem,
ಇಲ್ಲ next date ಎಲ್ಲ ಇಲ್ಲಿ ಮಾಡ್ತೀವಿ.
because it's 6 years up and OS, how many years it will take? The request of petitioner finally call on, date could
12/8.
Next week date ಕೊಡಿ ಅಪ್ಪ, it's a 2014 matter, madam.
Thirteen eight.
Everybody is taking date today, I'll be left with no work.
Lordship, list one, serial number
The
40.
request of petitioner call on so and so the matter.
13/8.
50 matter, 51 ಎರಡು.
List one, serial number 47. We had sought for an adjournment, Lordship. We forgot to mention about the interim order extension. Kindly be extended till the next hearing. Serial
47
number 47.
serial number 47 ಬೆಳಗ್ಗೆ ಅರ್ಜನ್ ಆಗಿದ್ದಾರೆ.
19 ಗೆ ಆಗಿದೆ ಸ್ವಾಮಿ.
Interim order, if any, is extended till next date of hearing. Check ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಿ. Interim order ಇದೆ extend ಮಾಡಿಸಿ.
Oblige.
47.
Pass over matters. Serial number 2, PM Sidmalappa.
You appear in serial number 2.
Adjournment.
None appears to the petitioner. Call next week.
Sir, last.
ಕೊಡಿ, ಏನಿದೆ ನೋಡೋಣ ಮ್ಯಾಟರ್ ಇದು. But then it will not have any merit, ಸುಮ್ಮನೆ ಹಾಕ್ಬಿಟ್ಟಿರ್ತಾರೆ ಅಷ್ಟೇ. None appears with the petitioner. Even on the last date of occasion, there was no representation for the petitioner. It appears petitioner is not interested in prosecuting the writ petition. Writ petition dismissed for non-prosecution. ಈ ರೀತಿ ಮಾಡಿ, none appears with the petitioner even when the matter is called the second time today. Yes.
5, Ishan GS. Serial number 5.
Yes, CJ accepts notice for R1 and 2 respondents. Call up to 2 weeks, objections if any by them. Yes.
The first list continue. First list continue. Serial number 39, Hitesh Gowda.
For the petitioner.
Yes, respondent.
HL Pradeep Kumar.
This is a case where the petitioner are on the 5th round of litigation, my lord. Earlier, there were 3 writ petitions and 1 review petition, in which in all these petitions, the petitioner has succeeded, my lord. My lord, the latest writ petition will be at page number
Yeah, what is the matter about?
My lord, this is with regard to grant of compensation, my lord, whereas the land acquisition is of the year 2010 and 11. Whereas till date, there's no compensation being paid to the
How is
petitioner.
writ maintainable?
My lord, I bring your lordship's notice to annexure R, my lord. because the land is, initially the contention of the respondent KADB was that the land is a pot kharab land. Henceforth, the compensation is not being, cannot be granted for the said land. Subsequently, several writ petitions were filed. In every writ petition, this honorable court has considered my case and has granted order in my favor, my lord. Whereas the last writ petition comes at page number 120 at annexure R, my lord. The final findings of this honorable court, if your lordship can see at page number 138, my lord. In the above circumstances, the writ petition succeeds. The writ of mandamus to issue the second respondent CEO and the fourth respondent SLAO, both KIDB, to compute and pay compensation to the petitioner within 8 weeks in the respect of the subject land, measured 12 acres, 26 guntas in the interest at rate of 9% per annum to be reckoned from the date possession was taken, failing which the part from which is likely action for contempt and additional interest of 9% per annum shall be payable ab inceptio, and the same may be recovered personally from the respondent 2 and 4, my lord. This is the observation made by the this honorable court in the previous writ petition, my lord. Subject to this, in compliance of the order of this writ petition, my lord, the respondent KIDB, they make the deposit under section 30 and 30 sub 31 subclause 2 of the Land Acquisition Act before the trial court, my lord. And the observation made by and the claim made in the petition can be seen at page number 143, my lord, which reads as: the respondent claimant here are the persons interested in the land acquisition. As the persons failed to appear before the petitioner to deposit the compensation by producing necessary title deeds coupled with revenue documents, though the award was award amount is deposited. The above facts are clearly mentioned in the general award. It is submitted that the provisions, the persons interested claimants failed to appear and civil dispute pending between the respondents. My lord, this is not the case of the petitioner, my lord. If your lordship may see the order sheet, my lord, the order sheet says 1 Govindappa and 2 Veeraswamy Mudaliar. They are not the petitioners before this honorable court in the last 5 rounds of litigation, my lord. My father, one Veeraswamy Mudaliar, he passed at the time when the land acquisition notification was came out, my lord. Subsequent to which 5 rounds of writ petitions, I have come before this court and I have obtained the order. And along with the order of this court, I have made a representation to the KIDB at annexure T at page 145, my lord. This is a representation on behalf of the petitioner herein. Whereas they say that the deceased father of the petitioner did not appear before the SLAO, and henceforth they have made the deposit. Further, going by the amount of deposit, my lord, they have deposited 5,39,631 rupees, my lord. My lord, this is for 12 acres, 26 guntas of land. My lord, this is only with regard
What is LSC 49 or 23?
Lord, after my lord passing of order as per annexure, my lord R, you have, my lord, passed general award and my lord deposited before the, my lord, the reference code. Since, my lord, there is a dispute. Lord,
Go there and produce.
Lord,
necessary
there's
documents.
absolutely no dispute between parties, my lord. If there's any dispute,
You go there, you produce the necessary documents and get it released. Anyway, compensation is paid.
my lord, compensation is not paid, my lord. Not even a penny is paid, my lord.
Compensation is deposited.
My lord, that is where the issue comes, my lord. My lord, the actual compensation that will be payable by them, including the interest as directed by this court, my lord, it will come up to 15 crores, my lord. They have deposited 5 lakh rupees and washed their hands telling that nobody has appeared before them.
Lord, what
This
was-
is the discrepancy, my lord.
Lord, what was happened, my lord, in the year, my lord, 2006, my lord, 26 acres, my lord, was, my lord, acquired by, my lord, the state for the purpose of KDB. My lord, out of that, my lord, 12 acres, 24 guntas was government, my lord, kharab land. My lord, there was no, my lord, record to show that, my lord, this land was granted, my lord,
For the entire amount. What is the subject matter of the writ petition?
12 acres, 24 guntas. 12 acres, 24 guntas.
What was the subject matter of the writ petition at annexure RS?
Are, my lord, to seeking direction to, my lord, to pay compensation for the kharab land.
My lord, initially the land existed of 21
As per the
acres.
government, my lord, policy, my lord, land has to be granted, my lord, to any person who, my lord, claims to, my lord, the in occupation of my lord, the such my lord government land. Before my lord issuance of my lord the preliminary notification. Here is the case, my lord, there's no such my lord grant made in favor of the petitioner, my lord, as or his father, my lord. One 21, my lord, where prayer, my lord, is extracted in page number 121, annexure R.
Kharab land under the ownership of
Lord,
private
as
person is called A Kharab or B Kharab?
Yeah.
A Kharab. B Kharab is government land. Where is the
Yes.
RTC?
My lord, furnishing additional documents, RTC and the observation made by the revenue officer, Tahsildar, AC, the ADLR, DDLR, all reports have been annexed to this writ petition, my lord.
RTC torse.
My lord?
RTC.
My lord, I have not annexed the RTC, my lord, but
Idra kodre.
RTC annex madela, Swami, but page 79 can be seen, my lord.
Lord,
Show me the RTC. If you have the RTC, give me the RTC.
Lord, I have filed
Lord,
an
I'm filing the RTC, Akar Band and the survey record. Page number 2 is the Akar Band, my lord. 3 is the mutation entries and 4 to 7 are the RTC records. Veeraswamy Mudaliar is my father, my lord.
What is the extent held by you?
My lord, the total extent held by me. My lord, 26 acres, 11 guntas, my lord, out of which 12 acres, 26 guntas are of Kharab land and 13 acres, 25 guntas are agriculture land.
You are seeking compensation for how much?
I've already received consent award for 13 acres, my lord. The remaining 12 acres, 26 guntas, I'm seeking for compensation.
According to you, it's A Kharab and not B Kharab.
My lord, it has been decided by this honorable court, my lord. It's not as per my submission, my lord. It is as per, your lordship can observe that at annexure G to annexure K, my lord. These are at page 79 to 82. Various observations made by Tahsildar, Assistant Commissioner, DC, and the Bangalore, the District Commissioner. And these were the observations made by the authorities.
It is your land.
My lord. My lord, page 79, my lord.
You are placing your ownership on which document, counsel?
My lord, ownership, I've produced the document just now, my lord.
Which one?
Please, my lord. Those are the documents on which I'm claiming my ownership, my lord. And also, the respondent KIDB at the initial rounds of litigation itself, my lord, they had sought for the Tahsildar, DC, and Assistant Commissioner to give a report whether the land is a Pot Kharab land or a B Kharab land, my lord. Whereas they have clearly ascertained that annexure G, H, and J, my lord.
Annexure?
Annexure G, my lord. If your lordship may permit to read annexure G, my lord.
page 79.
Page 79 of the writ petition. Towards the end, my lord. Survey number 21/1 ರಲ್ಲಿ 12 ಎಕರೆ 26 ಗುಂಟೆ A Kharab ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ ಮೂವತ್ತರಲ್ಲಿ
16 ಗುಂಟೆ.
16 ಗುಂಟೆ A
Come and
ಖರಾಬ್
get restrictions.
my lord.
Lord,
What restrictions you have?
Lord, thereafter, my lord, your lordship, kindly see, iddu ಬಂಡೆಯಿಂದ ಕೂಡಿದ್ದು. Lord, I have filed, my lord, an affidavit, my lord, on 8th February 2024. My lord, I have annexed, my lord, the government order. As per government order, my lord, if, my lord, it is a rock area, my lord, it has to be classified as B Karab. Even assuming that, my lord, they have said, my lord, as A Karab only, but there is no, my lord, grant, my lord, made in favor of the petitioner.
Sir, what is Karab? Karab is that land which is not arable.
Yes, correct.
It cannot be cultivated.
Yes, correct.
It can be owned either by the government or.
They say that it is ಬಂಡೆಯಿಂದ
Yes, sir.
ಕೂಡಿದ್ದು ಅಂತಾರೆ.
ಬಂಡೆ ಇರ್ಬೋದು, ಹೊಳೆ ಇರ್ಬೋದು,
ಹೌದು.
ಮತ್ತೊಂದು ಇರ್ಬೋದು.
It cannot be cultivated.
Okay.
Correct, my lord.
See, if it is owned by private person, it is A Karab.
A Karab.
If it is not owned by a private person, it becomes
B Karab.
B Karab.
Correct.
Now, if it is owned by private persons, what happens?
Lord,
It is not assessed for land revenue because it is not cultivable. Once you, with your efforts, bring it under cultivation, it becomes cultivable
Lord,
and it can
they
be taxed
themselves-
accordingly. Listen,
Please.
it can be taxed accordingly.
Correct.
Okay, just because it is a Karab land, it does not mean private person is not entitled to
Compensation.
compensation. See, if it is his land, he is entitled to compensation.
Correct.
Okay. The question is, who is the owner of that land? Just because it is a Karab land, it does not mean that the private individual is not entitled to compensation. Okay.
Yes.
You are required to assess based on the documents produced before you, whether it's a private land or a government land. We need to look at prima facie, we first look at RTC.
That's what, my lord.
To see whether it's A Karab or B Karab. Now the RTCs are handwritten RTCs. They are written in between over here. So we are not able to understand whether it's A Karab or B Karab, number one. Then number two, I am looking at MR. Next I will be asking about MR. Show me the MR.
Lord, MR is at page number 3, my lord.
Page number?
Page number 3, my lord.
ಇವಾಗ ಹಾಕಿರೋ documents ಇವಾಗ ಹಾಕಿರೋ
ಇವಾಗ ಹಾಕಿರೋ documents. I filed it earlier with the other writ petitions, my lord. Because
Serial number?
ಮೊದಲಿಯ ರಾಮಸ್ವಾಮಿ ಮೊದಲು. Serial number 150 ಅಂತ ತಿಳಿಸಿ. Serial number 150. In the left hand side, my lord.
ತ್ಯಾಮಗೊಂಡಲು ಕಂದಸ್ವಾಮಿ ಮುದಲಿಯಾರ್ ರವರ ಮಗ.
It does not reveal anything.
ಹೌದು.
It does not reveal anything, this document.
That's what, my lord, my lord, even after, my lord, the disposal of the
Asking him to show his documents. First, I am asking you the revenue record.
My lord, I'll just read out that number 15, my lord. ತ್ಯಾಮಗೊಂಡಲು ಕಂದಸ್ವಾಮಿ ಮುದಲಿ at 150, my lord. ತ್ಯಾಮಗೊಂಡಲು ಕಂದಸ್ವಾಮಿ ಮುದಲಿಯಾರ್ ರವರ ಮಗ ನಾರಾಯಣ ಸ್ವಾಮಿ ಮುದಲಿಯಾರ್ ತ್ಯಾಮಗೊಂಡಲು ಇವರ ಮಗ ಕೆ ಕುಪ್ಪುಸ್ವಾಮಿ ಮುದಲಿಯಾರ್ ದೇವರಾಜೇಂದ್ರ ಮುದಲಿಯಾರ್ ಗಣೇಶ್ ಮುದಲಿಯಾರ್ ರವರ ಮಗ ವೀರಸ್ವಾಮಿ ಮುದಲಿಯಾರ್ ರವರ ಭಾಗ DNO ನಂಬರ್ 2657 of 4647 dated 21/4/1947 ಪೈಕಿ ಸರ್ವೆ ನಂಬರ್ 2/3 and the reference to the mutation register is with regard to 5/96.
Whatever, show that what is the extent, where is it mentioned, and then show your title deed.
My lord, page number 4 is the RTC, my lord. Page number 4 RTC.
Sir, RTC, the problem is, it says 26 acres, 11 guntas, of which 12 acres, 26 guntas is Karab land. We don't know whether it is A Karab or B Karab.
Yes, my lord.
Because it is written in between, okay?
Please, my lord.
Then it says Ulidu 13 acres, 25 guntas.
Please, my
Now we come to column number 9, it says Govindappa bin Dodakalappa, that is 4 acres, 12 guntas.
Please, my lord.
Right side note, Ray.
Because of this confusion, my lord, because of this confusion, the respondent SLAO, he himself made a representation, requisition to the Tahsildar AC and DC, my lord. with regard to this very confusion. This was before 2 rounds of litigation, my lord. I'll bring your lordship's notice to page number 79, my lord. Page number 79 of the writ petition. Subsequently, thereon, all the authorities, the competent authorities have given clarification with regard to all the Kharab lands that were in question, which includes the petitioner's property, my lord, wherein it is clearly. Please,
ಈ RTC ಪ್ರಕಾರ ಹೋದ್ರೆ
please, my lord.
4 acres, 12 guntas for Govindappa.
Please, ma'am.
Then Veeraswamy Mudalayar ಮತ್ತೆ ಮುರುಗೇಶ್ ಮುದಲಿಯಾರ್ಗೆ 6.32 acres, ಆಮೇಲೆ ಇನ್ನೊಬ್ರಿಗೆ 2.25 acres.
Please.
Okay. See,
My lord, this will come up to the land, not the Kharab land, my lord. This is not with respect to the Kharab land. Kharab total extent was 21 acres, my lord. Out of the 21 acres.
show me your title deeds, counsel. Show me your title deeds. How you became owner of the property? What is the extent of your property? Show me that. How did you become owner? Any grant was made in the name of your family?
No.
From time immemorial, you have been cultivating it?
My lord, it's from time immemorial, it has been cultivated by the petitioners, my lord.
Names ನೋಡಿದ್ರೆ doubt ಆಗತ್ತಾ? ತ್ಯಾಮಗೊಂಡ್ಲ, ಮುದಲಿಯಾರ್ sir.
Please.
It's doubtful.
My lord, there have been.
It's very doubtful.
My lord, I'm showing documents of 1947, my lord. What is the?
Show it.
My lord,
It's not time immemorial.
my lord, the page
1947
number
is not
3
time
itself speaks of a document that where the mutation is of the year 1947, my lord, where my ancestors have been there, through them have obtained this property is.
Sir,
There's no
show your title deeds to establish you are the owner of the property. Show your title deeds.
My lord, the very fact that the.
What?
My lord, the government ascertaining the fact that the land is an acre
Nothing
of
has
land.
been ascertained. Nothing has been ascertained. Here and there, stray reference will not confer any title to you. Supposing it's your property, you want to sell it.
Please.
How we are going to sell it? To the intending purchaser.
Please.
Okay. Yeah. How do you show the flow of title in your favor? Show your title deeds.
My lord, I pray for time.
See, some stray observations here, there,
My lord,
this.
My lord,
Not
because for
confer-
13 years, my ownership
sir.
was not disputed when
Look,
before.
sir, I am not in a hurry. I don't
Please.
want to close anybody's right.
Please.
Okay. Because rights in the property are very valuable. At the same time, some administrative malfunction should not result in undue benefit to anybody.
Please, ma'am.
Okay.
Please.
So you have to produce your title deed. Government,
Please, my lord. See,
find out
yes. Here, my lord, see.
whether ಸುಮ್ನೆ ಏನೋ ಒಂದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳೋದಲ್ಲ ಮಾತಾಡ್ಬೇಡಿ.
ಅಲ್ಲ, petitioner here in my lord. He
ಏನು?
is the son of late Veeraswamy Mudaliar.
No, so
That's why my lordship now,
he doesn't get any right.
LAC is pending before the competent authority. LAC is pending.
You can urge all the, my lord.
LSI ಮಾಡಿರೋದೇ ತಪ್ಪು.
LIC ನಲ್ಲಿ ಪೂರ್ತಿ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ.
My lord, I've
ಎಲ್ಲ
received-
ಕೊಟ್ಟಿದ್ದಾರೆ, my lord.
Look, you have determined what is government land, what is private land.
Private land we already paid.
Only in respect of private land, you have paid. He has no question, qualms with the amount deposited in respect of private land.
No.
Wants-
The amount deposited, my lord, is in relation to, my lord, this government land. Private land, you took, my lord, the money in the year 2012 as per under the consent rate.
Exactly. See, what he is telling is the Karab land is A Karab and it is not B Karab. And he is the owner of A Karab land.
Lord, as per, my lord, government order.
That's what he is contending.
That's correct.
His contention is he is the owner of the 12 acre and odd acres.
There should be some grant certificate or
Okay,
something.
12 and odd acres.
Please.
Now, you'll have to say, now, on what ground you claimed ownership over remaining portion of land?
My lord, on the
What is
basis,
your title deed? Show me the title deed.
my lord, on the basis of the Akarband mutations and the RTC.
Nah, show me the same carbon mutation and RTC. If it should reflect the extent of land held by you.
He's only, my lord, climbing on the letters of, my lord, correspondence between Tahsildar and, my lord.
That's why I said those correspondence will not come to your rescue.
That's
Show
what.
it.
From 2012, my lord, till date, my lord, there are so many correspondence based on.
Yes, the petitioner, Bani Barkule. The petitioner prays time to place before this court the copies of documents of title and also the revenue documents to prima facie establish that he is the owner of the property concerned. Full stop. At his request, call on, beg a date tole.
2 weeks ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು
2 weeks ಬಿಟ್ಟು date
because I
ಕೊಡಿ.
have to
19th.
get the documents.
19th.
See, government and KIDB, what you should do, make a list of documents based on which you gave him compensation in respect to other portion of the land.
Please.
And show that those documents reflect that he is the owner of the land only to an extent of what he has deposited compensation. Okay, only to that extent he is the owner. Remaining extent is government land. That's how your contention should be. Okay, some observations here and there, even in the writ petition for that matter, will not come to his rescue.
Yes, ma'am. Yes, ma'am.
You got it?
Yes, ma'am.
Prima facie, if he is, see, in these proceedings, I cannot make an inquiry into the title of the petitioner. But prima facie, if he is able to establish before the court, he is the owner of the property, then in that sense, at that time, I'll direct you to pass an award with regard to that also and deposit it
No, we
before
have-
the reference court.
Yes.
And upon he producing the necessary title deeds before the reference court, there will be an inquiry as to title and he can withdraw the amount. Okay, but he is not able to prove prima facie that he is the owner of the property.
Correct.
See, and furthermore, what happens, it's a larger extent of land, 26 acres.
12 acres. Dispute is 12 acres.
Dispute is 12 acres. Otherwise, the RTC pertains to
26 acres.
26 acres.
26 and odd acres.
13 acres we have already paid count.
That 13 acres, on what ground you came to the conclusion he is the owner of the property?
Lord, he produced my lord title deeds, my lord, in respect of the.
What is the title deed? You verify that. And you place it before the court.
Yes.
See, ಅದಕ್ಕೆ ಬೇರೆ ಟೈಟ್ಲ್ ಇದಕ್ಕೆ ಬೇರೆ ಟೈಟ್ಲ್ ಇರಲ್ಲ. ಯಾರು ಅದು ವೆರಿ ರೇರ್ ಅದು ಏನು ಖರಾಬಿಗೆ ಬೇರೆ ಸೀಲ್ ಡೀಡ್ ಬರುತ್ತೆ, ಅದಕ್ಕೆ ಬೇರೆ ಸೀಲ್ ಡೀಡ್ ಬರುತ್ತೆ, ಎಲ್ಲ ಸೇರ್ಸ ತಗೊಂಡಿರ್ತಾರೆ. ಗೊತ್ತಾಯ್ತೇನಾ? Probably you can have a relook at whether you have the title there also or not.
Lord, while receiving compensation at the agreement rate, my lord.
ಟೈಮ್ ಇಮ್ಮಮೋರಿಯಲ್ ಬರಲ್ಲ, ಹೆಸರು ನೋಡೋದ್ರಲ್ಲಿ.
ಬರೋದಿಲ್ಲ.
ಗೊತ್ತಾಯ್ತೇನಾ? ಹೆಸರು ನೋಡಿದ್ರೆ ಇಟ್ಸ್ ಓನ್ಲಿ ಆಫ್ಟರ್ ಬ್ರಿಟಿಷ್ ಇನ್ಕರ್ಷನ್.
Yes.
1946, 47, ಅದೇ time.
During British period, basically.
British period.
British period. They had some, they came and settled down here. It's an interesting history. The local population refused to serve the British.
Yes.
Okay. Bangalore was a cantonment. The British had placed their army over here. So they got their men from the neighboring state.
That's why, my lord,
That's why cantonment, you don't have the local population. Traditional Bangalore cantonment, you don't have the local population.
Yes.
That's how it goes. So these persons will have come basically at that particular point of time.
Lord, that's why, my lord, we have passed award, my lord, insofar as this Karab land is concerned. Let him, my lord, go before the reference court and let him, my lord, produce his title document.
Their inquiry is only with regard to, let's say you produce a title.
Lord. 18, my lord, is, my lord.
Yes, call on ಯಾವತ್ತು? 19th ಅಪ್ಪ. ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಅದಕ್ಕೆ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಮಾಡ್ರಿ, ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ದೋಸ್.
Because it's 2013 ನಲ್ಲಿ ಆ portion separate documents.
ಅದನ್ನ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ
ಅದೇ documents.
Further hearing ಹಾಕ್ಬಿಟ್ರೆ 230. Further hearing 213.
ಆಯ್ತು, ಕಾಲ್ ಆನ್ 19th ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
Please.
230 ಏನ್ ಬೇಡ, ಇಟ್ಕೊಳ್ಳಿ ಬಿಡಿ, ತೊಂದರೆ ಏನಿಲ್ಲ. Yes.
40, Dayanand KG, Ajay Kumar.
Yeah, what is this matter? Last time, where was it urgent?
This much.
What was the date given last time? Order sheet,
Please. So it's sought for time. Plus, we have executed lease cum sale deed in favor of the husband, late husband of the petitioner herein. So now they're sought for an direction, my lords, for execution of seal deed.
ಕೊಡ್ಬೋದಾ?
Please. Direction.
ಏನಂತ?
to execute the sale deed.
Lease cum sale agreement in favor.
ಆಗಿದೆ, lease cum sale agreement ಆಗಿದೆ.
ಹ್ಮ್.
Now they are seeking for execution of an absolute sale deed.
ಆಗ್ಬೋದಲ್, ಮಾಡ್ಬೋದಲ್ವಾ? ಹಾ?
Please, direction.
ಬರ್ಕೊಳ್ಳಿ. Husband of, the late husband of the petitioner was allotted as a site by the respondent, and a lease cum sale agreement was executed in favor of site bearing number 269, block 19, Arkavati layout, Bengaluru. Full stop. After his death, in spite of, after his death, comma, in spite of complying with all the terms and conditions of the lease cum sale agreement, and ಗೊತ್ತಾಗ್ದಲ್ಲ ಕೇಳಿ ಮೇಡಮ್, ಅಲ್ಲಿ ಗೋ ಸ್ಲೋ, ಏನೇನೋ ಬರ್ಕೋಬೇಡಿ, and giving a representation to the respondent to execute a sale deed in his favor, in her favor, comma, the respondent has not executed the sale deed. Full stop. Hence the present writ petition is filed. Full stop. Next para. Admittedly, lease cum sale agreement has been executed in favor of the late husband of the petitioner, in favor of late husband of the petitioner, in respect of site number 269. Full stop. The learned counsel for the respondent is not in a position to contravene that the conditions of the lease cum sale agreement has been complied with by the petitioner, and a respondent is liable to execute the sale deed in favor of the petitioner. Full stop. Hence the following order. Next para. Hence the following order. Respondent is directed to execute an absolute sale deed in favor of the petitioner in respect of block number 90, in respect of site bearing number 269, block number 19, Arkavati layout, Bengaluru, within a period of 3 months.
Subject to they also complying. We'll call upon them for further action. They'll also have to comply.
Within 3 months from the date of receipt of the certified copy of this order, provided petitioner is willing to comply, petitioner complies with all the necessary legal formalities, and there is no rival claimant.
Please.
To the interest of her deceased husband.
English, let's see.
Pay for the petition in this case.
Hmm.
A G category site was allotted in favor of the petitioner by the respondent authority.
Instructions ಬಂದಿದ್ಯಾ?
And then the lease cum sale agreement was also executed in his favor in the year 2015 itself. Then the area in which the site was formed was quashed by the Honorable Court on favor of the landowner. Then he made an application for allotment of alternative site. Thereafter, the site was confirmed by the Justice Shailendra Kumar Committee. They recognized the petitioner. Then the law officer has given opinion to place the matter before the committee for allotment of alternative site. Even the commissioner has also passed an order to place the matter. So far, matter has not been placed before the committee for alternative, for allotment of alternative site. So that's why I made a representations to consider my representation for placing the matter before the committee and to allot alternative sites in my favor.
Page number 47, madam. Point number 84, madam. In the bottom, ಮಾನ್ಯ ಆಯುಕ್ತರು ಉಪಸಮಿತಿ ಮುಂದೆ ಮಂಡಿಸಬಹುದು. The case of the petitioner may be
Yes,
considered.
Bane. Case of the petitioner is that, the case of the petitioner is that, he was allotted, a site by site measuring 50 into 80 by BDA. By BDA, full stop. However, the area of the site was denotified.
Denotified, quashed by the Supreme Court. Challenge, the notification has been challenged and this court has quashed the acquisition proceeding.
However, the area of the site, however, the area where the site was located, however, the acquisition of the area where the site was located has been quashed by this court. Full stop. Because of the same, the petitioner requested the respondent authority to allot an alternative site. Full stop. As the same has not been allotted so far, the present writ petition is filed. Full stop. Next para. The learned counsel appearing for respondent number 2 and 3 BDA submits that the case of the petitioner is being considered in accordance with law. Full stop. Hence the following order. Respondent number 2 and 3 is directed to consider the case of the petitioner in accordance with law and take appropriate decision within a period of 3 months from the date of receipt of certified copy of this order. And full stop. Writ petition disposed of the body.
43, Srinivas V.
ಏನಿದೆ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟ್ರ್ ಕೊಡಿ. ಕೊಡಿ, usually comes. None appears to the petitioner, call on date ಕೊಡಿ. Next one, 12th.
49, 40, 44 to 48 adjourn. 49, Rajeshwar PN.
Kindly grant a week's time, my lord. Senior
Ordered
has some
made.
inconvenience.
The request of petitioner, ಯಾವ್ದ್ರಿ ಇದು? ಗೌಡ ಬಂದಿ.
B ವಚನ್.
ರಿಟ್ ಅಪೀಲ್ ಜೊತೆ ಹೋಗ್ಬೇಕಂತ ಹೇಳಿದ ಅದನ್ನ see, it has to go club with writ appeal. I don't know what judgment your senior is. Okay. The request of petitioner call on, ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ ನಾವು ಹಾಕುವ.
Any day next week, my lord.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಕೊಡಿ.
12, 12/8. Adjournments. 50 adjourn.
Continuous as it is. Yes.
51 adjourn. 50, sir.
What it is?
Okay. 52, KK Vasant, TP Vivekananda.
Petitioner by
52. Sir, Srinivas sir. 12.
ಶ್ರೀನಿವಾಸ್, ಇದು ರೆಡಿ ಇದೀರೇನಪ್ಪ? 43. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ. B group sir.
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬರ್ತಿದೆ ಅಲ್ವಾ? ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬರ್ತದೆ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಆಯ್ತು, 42 ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಆಯ್ತು, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಯಾವ ಡೇಟ್ ಹೋಯ್ತು? 12/8 ಅವತ್ತು ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತರಿಸಿ ಗವರ್ಮೆಂಟ್ ಬೈ ದಟ್ ಡೇಟ್.
KK Vasant, TP
petitioner
Vivekananda.
one. Respondent. Lord, the petitioner is questioning the notification. The annexure U and the annexure V, my lord. Lord, the petitioners are the owner of the land to an extent of 11.5 guntas, totally 20 guntas, which has been acquired without notifying against his name. The notification, my lord, is in the name of the original owner then in the year 1932. Subsequently, my lord, the sale deed has been transferred to various persons from hands to hand. And in one of the other writ petition, my lord, by annexure, this court has already quashed the notification insofar as to the part of the land in the very
11 guntas,
Ah?
11 guntas.
And number 11 guntas of land which we are in before this court, my lord. Earlier, my lord, in the another writ petition, my lord, in the very same notification has been questioned by another owner who has been derived title from the original owner of who is stands 1932, has been quashed, which is at the annexure at page 154, my lord. Sorry, 151. This also is in arranged out of the same notification and same serial number. May I take the page number 111, my lord. Serial number 167, survey number 49, which has been notified in the name of Alamma, wife of Rachaya, to an extent of 5 acre 13 guntas. The same been issued by way of final notification. This petitioner is also has been purchased in the year 1967. my lord. CLD dated 24/7/1967, my lord.
Yeah,
the first-
On the ground of parity.
In the case where, my lord, the Honorable Court has quashed the acquisition proceedings, that is a case where, my lord, in spite of
First, one by one.
Yes.
Has it retained finality?
acquisition proceedings has,
Allappa.
the other,
Has the judgment retained finality?
yes, that has 10
You
penalty.
did not challenge it.
No, my lords.
Okay. 1984 acquisition challenged in the year 2014. Ground of delay and lapse is not taken. Writ petition is allowed. And you do not challenge it.
But the earlier writ petition was of the year 2006, my lords. And the order was passed in 2009. And in that writ petition, my lords, the ground was, in spite of the petitioner's name having been entered in the revenue records, as on the date of preliminary notification, his name was not shown. But in this case, there is no document to show that as on the date of issuance of the preliminary notification, the name of the petitioner was reflected in the revenue records.
Sources are.
That is one aspect.
No, that is the only aspect. Source.
One and 1967, my lord, thereafter, and section.
Sir, if you are, see, in the connected matter has been allowed only on the ground.
That my name was incorporated in RTC.
But still no notice was issued to you. To your predecessor in title, notice was issued.
Please.
Okay. Now,
show that your name found a place in RTC.
My lord, even otherwise, my lord.
No, not even otherwise.
128, section 128, my lord. It is the authority who has to get it transferred after the sale of in the end.
Sir, is it your case that your name found a place in the revenue records as on the date of issuance of preliminary notification?
Even otherwise, my lord, the Alamas
Then
name.
answer Madi, sir. Amel will go for even otherwise.
Although it is not, I have a doubt that it may not be appearing.
Sir, no, that's all. It can't be a.
No, in the,
doubtful
but
one.
mutation is there, my lord, where subsequently, my lord, there are so many other developments has been taken place.
Sir, first question, ಇದಕ್ಕೆ yes or no ಹೇಳಿ.
ಅದು ಆ ವೇಳೆಗೆ ಇವರು ಹೆಸರಿಗೆ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ಮಾಡ್ಕೊಂಡಿಲ್ವಾ? Okay,
ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
that is ruled out. Now tell me why acquisition is bad. Now answer me on delay and latches. The acquisition preliminary notification in the year 1981, final notification in the year 1984. The writ petition is filed in the year 2014. So lapse of 94, 2004, 30 years.
ಇಲ್ಲ ನನಗೆ ಇದು ಅಕ್ವಿಷನ್ ಆಗಿರೋದು ಇದೇ ವಿಚಾರನೇ ಗೊತ್ತಿಲ್ಲ.
Acquisition ಆಗಿರೋದೇ ಗೊತ್ತಿಲ್ಲ. Okay.
It's only in the year somewhere 2013 and 14, my lord.
1 second, wait. When was the award passed?
But the award was passed on 30/10/1985.
13/10?
30th.
Okay, 30th April.
October
30 October 1985.
85.
Award
Yes, ma'am.
16/2.
But 16/2, my lord, was issued little later, my lord, in 2006. Possession was taken, my lord, on 14/9/2006.
14/9/06. mahzar,
Possession taken date, my lords. 16/2 notification date is 17/10/2006.
17/10/06. Yes, sir. What have you used the land for? After that, what happened?
Lord, it is it is designated for residential purpose only. my lord.
Last occasion, my lord, when it was heard, they are asked to report. What has happened to the land, the adjacent, which has been covered under the another order of this court? What is the stage of that land, whether it has been deleted or?
That doesn't matter, sir.
No, other, ಯಾಕಂದ್ರೆ ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇರೋದು ನಾವು.
That doesn't matter. They don't want that land, they will not proceed.
And this land, whether you have allotted to anybody or not, ಅನ್ನೋದನ್ನ they have to clarify ಅಂತ there is an
ಆಯ್ತು, ಏನ್ ಮಾಡಿದ್ದೀರಾ?
official order. ಅದೇನಾರು ಆಗಿದೆ ಅಂತ ಅಂದ್ರೆ then we have to look into, otherwise it applicable to you also ಅಂತ, that was the direction issued in the court. It's in the order
Order
dated,
sheet ಅಲ್ಲಿ ಇದೆಯಾ? ಕೊಡಿ order.
Not get the,
order dated in January 2024, I think.
ಕೊಡಿ.
Earlier orders, my lord.
Learned counsel for Muda is directed to state as to whether any sites have been formed in 11 guntas of petitioners claim in this writ petition. What has happened?
I could not get the information, but I'll get it.
Get the information. At the request of the advocate for increment, the advocate for
On number 1 and 2.
respondent number 1 and 2 submits that he requires some more time to get the information about the present status of the land which is the subject matter of the writ petition.
Please, ma'am.
Full stop. At his request, call on.
Twenty-first.
21st.
21st.
Please.
21st, but next year.
22nd,
23rd.
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 How?
Case number 53, MN Madhusudan, BH Sachin.
But sorry, 23rd ಇರಲ್ಲ, 22nd ಆಗ್ಬೋದು.
ವಿವೇಕಾನಂದ 22nd
ಹೇಳ್ತೀನಿ.
ಬೇಡ ಅಂದ್ರು. 24th ಹಾಕ್ಬಿಡಿ. ಅಲ್ಲ 26th ಹಾಕೋಣ ತಗೊಳ್ಳಿ.
25th ಆಗ.
26th ರಜಾ ಅಲ್ವಾ?
26th Monday.
26 ರಜಾ.
ರಜಾ.
27.
ಆಯ್ತು 28th ಹಾಕೋಣ.
28.
28th.
53 MN Madhusudan.
My lord, BD has allotted an alternative site for me, my lord. The allotment letter dated, which is annexure. Which is annexure H, my lord. Page number 27, my lord. ನಿವೇಶನ ಮೌಲ್ಯ 5,58,336. And they have issued one more letter, my lord, saying that to pay the additional fee of rupees 5,57,000, my lord.
Yes, BDA.
My lords.
A responsible officer of respondent is hereby directed to file an affidavit stating as to the developmental charges collected from similarly situated allottees who have been allotted sites in.
I have produced along with the additional statement of objection. My lords.
You have
Yes, my lords. My lords, annexure. If my lords turn to additional statement of objection filed by me.
ಎಲ್ರಿಗೂ ಅಷ್ಟ ಹಾಕಿದ್ದೀರಾ?
11,15,520 rupees, my lords.
ಅದರಲ್ಲಿ submission. My lord, ಇದು ಹಂಚಿಕೆ ಎಲ್ಲ 2014 ಇರೋದು ಆ ಕಾಸ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ. Kindly see annexure R3 which he has produced in page number 21, my lord. ರೇಮಾನ್ ಅವರಿಗೆ ಸೇಮ್ ನಮ್ ಪಕ್ಕ ಸೈಟ್ ಅದೇ ಲೆವೆಟ್ ನಲ್ಲಿರೋ ಸೈಟ್ ಅವ್ರಿಗೂ 5,58,000 ತಗೊಂಡೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಅದ್ರದ್ದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟು ನಾನು ಹಾಕಿದ್ದೀನಿ.
Page number?
Page number 21 of his objection.
ನೋಡಿಯಪ್ಪ R3.
My lords, I'll explain, my lords, for that also.
You can't discriminate.
My lords, what happened to that is, my lords, the allotment was made on, my lords, 12/8/2013, my lords. Before, my lords, before the resolution passed by the BDA. Hence, my lords, BDA has taken that amount, my lords. BDA's resolution was 3/9/2013, my lords. I have explained in my lords, if my lords turn to page number 3 of my additional statement.
Apart from that, anywhere else?
My lords?
Apart from that, to anybody
No,
else?
my lords. If my lords
ಆ ಟೈಮಲ್ಲಿ ತಗೊಂಡಿರೋದೆಲ್ಲ ಅಷ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ನನಗ್ ಮಾತ್ರ ಇವಾಗ ಎಕ್ಸ್ಟ್ರಾ ತಗೊಂತಿದ್ದಾರೆ which they have.
If my lord,
all other documents what they have produced are of 2014, my lord, not of 13.
My lords, after the resolution passed.
After that, I am before that resolution, my lord. My allotment was on 2011, not on 2013. Allotment ಆಗಿದ್ದು ಅವಾಗ ನಾನು ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿರೋದು 2000 ಅಲ್ಲಿ ಸ್ವಾಮಿ, 2001 ಅಲ್ಲಿ. ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್
ಹಣ ಯಾವಾಗ ಕಟ್ಟಿದ್ರೆ?
ಹಣ ಕಟ್ಟಿದ್ದು
resolution of BDA date ಏನಪ್ಪ?
My lords, 3/9/2013, my lords.
31/2004 ಅಲ್ಲೇ ಕಟ್ಟಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್. 31/2004 ಅಲ್ಲೇ.
4?
ಇದು ಯಾವ್ದು ರಿಸಿಪ್ಟ್ ಹಾಕಿದ್ದಾರೆ?
14.
When did you pay the money?
14. My lords, my lords, on 22.
When was the first demand, council?
My lords, first
ಇದು
demand.
5167 ಯಾವಾಗ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರಪ್ಪ?
10/10/2013, my lords.
ಹಣ ಕಟ್ಟಿರೋದು ಇಲ್ಲಿದೆ ಮೈ ಲೋಡ್, ಪೇಜ್ ನಂಬರ್ 29, ಮೈ ಲೋಡ್. ಇಟ್ಸ್ ಆನ್
ಆಫ್ ಯುವರ್ ರಿಟ್ ಪಿಟಿಷನ್.
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಿ
22/10/2023, my lords. Allotment letter is on 10/10/2013.
22/10/2013.
22/10/2013.
Okay, 3/9/13 resolution ತೋರಿಸಿ.
My lords, it is at page number 7 of my first statement of objection, my lords.
Page number?
7 of my first statement of objection, annexure R1.
Statement of objection ಆಗಿದೆ.
counter statement to the writ petition ಅಂತ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ 20th August 2015. Page number 7 of only one document is there. Measure.
Yes, council, what to do?
My lord, this was ordered on 13/11/2014.
3/9/2013.
My lord, the adjacent site owners ಎಲ್ಲ ಅದೇ ಕಾಸ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
Who have
I have produced even my one document, my lord, which shows that adjacent for me, my lord, in the same level.
all right, but
They have acquired in 2000 and now again they are asking for the,
sir, they have
even,
paid.
my lord, ದುಡ್ಡು ತಗೊಂಡು ಮತ್ತೆ ಅಡಿಷನಲ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಕಳ್ಸಿದ ದಟ್ ಟು ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ ಮತ್ತೆ ಲೆಟರ್ ಕಳ್ಸೋದು 14 ಅಲ್ಲಿ, my lord. On 12/6/2014 ಲೆಟರ್ ಕೊಡ್ತಾರೆ ನೀವು ಅಡಿಷನಲ್ ಅಮೌಂಟ್ ಕಟ್ಟಿ ಅಂತ.
Now you
It's
have
purely a
paid.
discrimination, my lord. ಒಬ್ಬರಿಗೆ ಒಂದೊಂದು ತಗೊಂತಾರೆ.
Okay, 11/16/572 you have paid now.
No, my lord.
No,
They
my
have
lord.
paid
5 lakh.
Only 5 lakhs.
5,58,000 I have paid.
Okay. the
Additional 5,57,000 require ಇದು
rest you
letter.
paid. Can't be helped.
My lords, the value of the site is increased.
In the light of this particular thing.
ಅಲ್ಲ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ತಗೊಂಡಿದ್ದು ನಾನು
Provided they have discriminated against you after passing of this resolution, I can understand.
My lord, it's true, my lord. After passing, before the acquire agade, before that, my lord, if after that it has.
You are not paid and you are not got it, council. It's as simple as that. Yeah, said you are paid under protest on the last date. ನೀವು ತಲೆ ಆಡಿಸಿದ್ರೆ ಆ ತರ ರೆಕಾರ್ಡ್ ಆಗಿದೆ, ತಪ್ಪು ರೆಕಾರ್ಡ್ ಆಗಿದೆ. When were you granted an alternative site?
13/6/2011, my lord. It was granted on
Can't be
13.
helped.
ಅಲ್ಲ 11 ಕೊಟ್ಬಿಟ್ಟು ಮತ್ತೆ ನಾನು ಕಟ್ಟಿದ್ಮೇಲೆ ಮತ್ತೆ ನೀವು 5 ಲಕ್ಷ ಕಟ್ಟಿ ಅಂತ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿ.
13/6.
13/6/2011.
11 you are granted.
ಅವಾಗ ಕೊಟ್ಟಿರೋದು ಸೈಟ್. ಹಂಚಿಕೆ ಪತ್ರ ಕೊಟ್ಟಿರೋದು 10/10.
Where is the ಹಂಚಿಕೆ ಪತ್ರ?
ಹಂಚಿಕೆ ಪತ್ರ is at page number 27, my lord.
2013, my lords.
It is 2013 council.
My lord, ಅದ್ರಲ್ಲೇ 13 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ. ಕೆಳಗಡೆ ಲಾಸ್ಟ್
ಅಪ್ರೂವಲ್.
ಅವಾಗ ಅಪ್ರೂವ್ ಕಮಿಟಿ. ಹೌದು, ಅಪ್ರೂವ್ ಆಗೋಗಿದೆ ಅವಾಗಲೇ ಸೈಟ್.
ಬಟ್ ಇಲ್ಲಿ 5167 ಅಂತ ತೋರಿಸಿದಿರಲ್ರಿ.
My lords.
What is your explanation for this?
My lords, that's a type handwritten and typographical error, my lords. It's the first in my first statement
Okay.
itself.
Anything else?
ಅಷ್ಟೇ.
ಬನ್ನಿ.
My lord, ಅದೇ
In the
ನನಗೆ
first-
ಮಾತ್ರ ಹಂಗೆ ಅಲ್ಲ, ಅಡಿಷನಲ್ ಪಕ್ಕದಲ್ಲಿ ಇರೋಗೆಲ್ಲ
Yes,
ಅದೇ
it's
rate
all right.
ತಗೊಂಡಿದ್ದಾರೆ.
Come. The petitioner was owner of a revenue site. Full stop. It was acquired by the respondent BDA for formation of ಯಾವ layout ಅಪ್ಪ?
ವಿಶ್ವೇಶ್ವರಯ್ಯ layout.
For formation of Vishwesvaraya layout. So, in lieu of monetary compensation, the petitioner was allotted a site of a similar dimension,
Similar dimensions.
I was allotted a site, full stop. As he was being allotted a developed site formed by BDA,
comma. He is required to, he is required to pay developmental charges. He is required to pay development charges. Full stop. A demand of rupees 5167 per square meter was made to the petitioner. Full stop. The petitioner has paid the same. Full stop. However, subsequently, it was demanded that he is required to pay development charges at the rate of rupees 10,334 per square meter. Full stop. Agreed by the same, the present writ petition is filed. Full stop. Next para. It is contended by the petitioner that once respondent BDA allotted him a site by demanding a development charge of rupees 5167 per square meter, comma, they could not have revised the same to rupees 10,334 per square meter. Full stop. It is also contended that for similarly situated persons, the development charge is levied at rupees 5167 per square meter. Full stop. Next para. Per contra, the advocate for the respondent submits that BDA had passed a resolution on 3/9/2013 revising the development charges, and according to the said circular, allottees were required to pay a sum of rupees, allottees are required to pay a sum of rupees 10,334 per square meter, and by mistake, while issuing the allotment letter in favor of the petitioner, it was mentioned as rupees 5167 per square meter, and that does not confer any right on the petitioner. Full stop. It is further submitted that the petitioner is not discriminated against. Full stop. It is submitted that only those persons who are allotted sites prior to 3/9/2013 and those who have paid the development charges at before 3/9/2013 circular was issued. Before the circular was issued on 3/9/2013. Comma, they have paid the development charge at rupees 5167. Full stop. It is submitted that the petitioner was allotted the site on
My lord, sir, 10/10/2013.
And hence he is liable to pay a sum of rupees 10,334 per square meter as development charges as the circular which was in force at that particular point of time prescribed it. Full stop. Next part, the petitioner is not in a position to contravene the aforementioned submission of the respondent. Next para. Admittedly, the petitioner was allotted a site on 10/10/2013 and the circular which was in force at that particular point of time was dated 9/2013, and according to it, the petitioner was required to pay a sum of rupees
My lords,
10,334 per square meter of
in
the
total,
land
my lords,
allotted,
11,16,000,
which
11 lakh,
which comes to
11 lakh
a sum of
16,000.
rupees 11,16,572. Huh? Full stop. I do not see any error in the demand raised by respondent BDA. For that reason, full stop, for that reason, the writ petition is hereby dismissed. Petitioner is granted 2 weeks' time to deposit the balance amount.
Meanwhile, same may be registered as soon as possible.
Right?
ಅದು ಮಾಡಲ್ಲ ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಬಿಡಿ ಮತ್ತೆ ಇನ್ನೊಂದು ಕೇಸ್
Full stop. Upon receipt of the same, the BDA will take, is directed to take appropriate steps to execute lease cum sale agreement.
Please come sell again.
Lease cum sale agreement in favor of, lease cum sale agreement in respect of the land the site concerned in favor of the petition.
Within time span on fix ಆಗಿ
ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಸ್ವಾಮಿ ಅದು
Yes.
ಮತ್ತೆ ಇನ್ನೊಂದು
That's not your writ petition, sir. This is an extra relief I given you.
ಹೌದು
Yes.
ಇನ್ನೊಂದು ಹಾಕ್ಬೇಕಾಗಿ ಬರುತ್ತೆ ಅಂತ
ಏನಿಲ್ಲ, ಅದಕ್ಕೆ ಕವರ್ ಮಾಡಿದೀವಿ.
55, Clifton Rosario.
Petitioner. My lord, the acquisition, my lord, is of the section 28(1) and 28(4), my lord, are of 1995 and 1998. Thereafter, my lord, in fact, a larger section, all 503 acres of land was notified.
Ready, respondent?
Statement of objections is highly day after tomorrow.
My lord, numerous times time has been taken in this matter.
Last.
When did the petition?
Okay, when do you want? When do you want?
Monday, next Monday minutes I'll file.
Your senior should come and argue. Your senior will come and argue.
Please, minutes.
Or you only argue.
We'll file our objection.
12th.
Please.
12th.
My lord, 14th, please, my lord.
Okay, 14th.
Lord, matter could be heard that
Yeah,
because
so
the
the
project
request-
also which they are acquiring the land for, environmental clearance has been set aside.
At the request of respondent number 4, finally call on 14th.
14,
There's an interim order, my lord.
Interim order if any is extended till next date of hearing.
56, Harish Anantamurthy.
My
Lord,
state-
if your lordships permit
state
me,
may
my lord.
also be directed, state has also not filed objections in our matter, my lord.
Objections if any by then ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ.
Grateful.
Straight to.
Please, 1 week time.
KDP ಯಾರು? BV ಪಾಟೀಲ್ ಎಲ್ಲಿ? ನೀವು ಹಾಕಿದಿರೇನ್ರಿ ಅಬ್ಜೆಕ್ಷನ್?
Please,
ಹಾಕಿದಿರಾ?
no, my lords, we'll file objection.
ತಪ್ಪದಲ್ಲ ಹಾಕ್ಬೇಕು.
Additional, please.
Yes.
56.
Lord, Lord, if your lordships will permit me, my lord. But in this case, the dispute is about identification of the land which is acquired, my lord. Lord, admittedly, my lord,
Identification of?
the land which is acquired, my lord.
Ah,
Lord, in survey number 94/6, total extent is 2 acres 19 guntas. Lord,
you ready?
2003.
Are you ready?
Yes.
Lord, 3/2/2003, my lord, section 17 notification was issued, in which 20 guntas was sought to be acquired in 94/6. And my lord, 18/6/2014 is the section 19 notification, Lord, which your lordship will get at annexure G, my lord.
What is the extent of 94/6 council?
So 94/6, totally is 2 acres 19 guntas. Of that, my lord, petitioner's area is 1 acre 7 guntas.
Okay, 2 acres 19 guttas, huh?
Yes, your lord.
Yes, my lord.
What is the? land
Petitioner has
acquired?
purchased
What is the?
for
land acquired?
Arkavati.
2 acre 15 guntas.
Of 2
No, no,
acres.
what is acquired
What
is
is the
20 guntas, my lord.
Total land is ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ ಎಲ್ಲಿದೆ?
2 acre 19 guntas.
What type of RDC is this? There is no mention of.
So kindly come to annexure G, my lord.
Okay, 2 acres.
Serial
19
number-
guntas. What is the total extent of land acquired?
Sir,
20
in the
guntas,
preliminary,
preliminary notification, it is 2 acre 15 guntas. And final notification is also 2 acre 15 guntas, but on
Lord, I can show from the
subsequently,
notification that it is
2014,
only
we have
20
issued
guntas which is acquired.
another notification, final notification. That is 20 guntas is only acquired, Your Lordship.
Lord, this is
Where is
some
the
new case that
RTC?
he is
Show me
setting
the
up.
RTC, relevant RTC. ಸರಿಯಾಗಿರೋ RTC
Lord,
ತೋರಿಸಿ. ಯಾವ್ದು annexure D ಹಾಕಿದೀರಾ ಅದು ಪೂರ್ತಿ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Annexure D is my RTC, my lord, 1 acre 7.
No, RTC should reflect what is the total extent of land, no, in that survey number. It is not
Lord,
reflected. Focus RTC.
Lord, it shows in the middle of the page, my lord, if your lordship sees 1 acre 7 guntas. Your lordship is right, it does not show 2 acre 19 guntas.
So what kind of RTC is that? Looks like a bogus RTC it is.
No, no, my lord, kindly, lord, if your lordship has the notification itself at annexure G, my lord.
No, notification.
Serial number 592. 592, my lord. Serial number 592.
Yes.
The lordship will see, my lord, total extent, my lord, in the third column shows 2 acre 19 guntas. Lord, column number 9 is the acquired area. That is 20 guntas, 20 guntas, my lord. Now, my lord, absolutely this is a new case that the VDL council is saying that there is another notification acquiring 2 acre 14 guntas. This is not even stated in there.
No. He is not stressing on a new case. What he says was initially preliminary notification was issued for 2 acres 15 guntas.
Yes.
And there was a final notification which also said 2 acres 15 guntas, but later on that has been modified and only 20 guntas is acquired. He is not.
Yes, so let's. Yes, so let us go on that. Yes, I'm very thankful to
the
him.
land acquired is only 20 guntas according to him.
Only 20 guntas, my lord. Yes, my lord. Now, my lord, in 2015 itself, some disputes, my lord, about the identity of the land which is acquired. So, my lord, if your lordships turn to page annexure H and at page 44. Ide, 44 I'm showing, my lord.
Lordship.
Map will one in the.
Ide.
Sketch ready ಮಾಡಿರ್ತೀರಲ್ವಾ?
I have filed along with an affidavit also, Your Lordship.
Where is the sketch?
And I will come to it, my lord. If your lordship will permit me, please. 1 second.
Okay, go on. Really?
Page 44. This is in the year 2015.
Page?
My affidavit dated 14/9/2020.
Page 44. Page 44 is the survey sketch that they had prepared, me.
Forty-four of what?
Writ petition, Lord.
Annexure. Writ petition, Your Lordship.
Annexure H only.
44 is some part of annexure G.
No, Lord. It is annexure H starts at page 41.
Annexure H is at page number 98 over here.
Oh, I'm so sorry. Kindly come to the Lord. 1, 2, 3. Fourth page, Lord. In that.
101,
Okay,
there's
Lord.
some
I'll
sketch
make.
over here.
Yes, I'll make an 101. Now, my lord, if your lordships turn to the legend, Lord, block number 1, which is in the middle, my lord, is 1 acre 7 guntas belonging to Lord Nagaraju, who is the petitioner here, my lord. Now, 20 guntas is acquired, is shown as block number.
Civil suit council.
No, my lord, they don't know where their land is. I will just show to your lordship within a minute, my lord. Just give me 2 minutes more time.
Yes.
Lord, if your lordship has, please come back to the final notification, my lord. And the sketch which they have produced, Lord, along with the counter affidavit. does your lordship have this sketch, my lord?
This one, huh?
Yes, your lord.
No, not that, my lord. There's a one page sketch.
That is my,
Annexure?
no, it is along with my affidavit dated 14/9/2023, your lordship.
Yeah, annexure?
R3, your lordship.
R3. Now please see, my lord. East is KNP Gadi, my lord. That is K Narayanpura Gadi.
1 second, wait.
Yes.
The document starts from annexure R5, nothing before that.
Lordship, affidavit dated 14/9/2023, your lordship.
14.
14/9/2023.
14/9 to
Got it.
yes, my lord. Now your lordship will see east is KNP Gadi, my lord.
East is?
K Narayanpura, KNP Gadi. In the notification, just please have the
Boundary of K.
notification
Narayanpura.
alongside.
Ah.
Now in the notification is 94/4. There is no 94/4 here in the west. It should be 94/5. Now please see north. It says 93. There is 93.
No,
Then south.
to the left. No, to the left-hand side of 94/6, it is 94/5 only.
Correct. In the sketch which they have produced, please see along with the notification. The boundary is mentioned in the notification. In notification, this is shown as 94/4.
No, east is shown as KNP Gadi. It is west 94/4. Is it page 8, your lordship, of my statement of objection.
See, KNP Gadi is at column 10.
East. Yes,
Column
east
11
that
is 94/4.
It is in the, now see the sketch, please. There is no 94/4. Then north is shown as 93.
I'll give
South
you
is
liberty
shown
to
as
go to
94 No, but then till then let them not interfere with my possession.
civil court, sir.
I have
I'll
a
give you
stay
liberty to
here.
go to civil court.
No, my lord, kindly, lord, there is already an order which is passed. Your lordship may kindly see. Everything is recorded here. In this court's order, only, my lord, they were given time. If they wanted to issue a corrigendum, they could have done it. But they have not done it. Kindly see the order dated 14/9/2023.
I will say they will not interfere in any land other than what is mentioned in the final notification.
No, but they are not able to identify. I will show from their own record.
Lordship, the
I will
short
show from
controversy,
their own
I will-
record.
I will-
The records were.
The short
My lord,
controversy.
please kindly give me.
Lordship,
1 second, I'll get back to you, Rajesh. Yeah.
the short controversy is total extent of out of 2 acre 19 guntas, 4 guntas is Karab, left out is 2 acre 15 guntas. Out of that 20 guntas we acquired. The only controversy what the petitioner is raising is that it comes at the eastern portion of that is the northeastern corner. The acquired land.
No, he is telling on the eastern side it is village boundary of K. Narayanpura.
Yes, your lord.
He is relying upon your final notification.
Yes, your lord.
Okay, your final notification east, west, north, south. Okay.
Yes, your lord.
So east, west, north, south. So east is KNP Gadi.
Yes,
That
sir.
he is not disputing it.
Yes, sir.
West is 94/4 he is telling.
He is disputing.
He is telling it says 94.
No, I'm not disputing.
He says it is 94/4 as per your own
Notification.
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 But in the
Then
sketch
please see
at
south
annex-
also.
in the sketch at annexure R3, west is actually 94/5.
Yes, your lord.
Okay, it is not 94/4.
It is not 94/5.
North is 93.
That is at the north, your lordship. It is 93 only.
Okay, north cannot be 93 because as per your sketch,
It has to be
It
left
should-
out portion,
it should be remaining portion of 94
94
bar
bar
6.
6.
And south is 94 bar 8. South is 94 bar 8 is correct. It should be 94
No,
bar 9.
94 bar 9.
It should be 94 bar 9. It is not 94 bar 8. So what he is telling is the description of the property as per your own notification does not match the exact
Lordship, what happens is what is shown in the preliminary notification, because in the preliminary notification, the total extent has been acquired.
no, sir, this is final notification. No.
That is what I am saying. The boundaries have reflected as it is in the preliminary notification.
You issue a corrigendum and take over, otherwise don't take over.
That is what they were given time for.
If
And
you
now
want,
if
you
your
issue a
lordship will see there,
Lordship, why I am telling is.
What is the date of preliminary notification? What is the date of final notification?
preliminary notification is 3/2/2003. Final notification is 18/6/2014. 11 ವರ್ಷ ಆದ್ಮೇಲೆ.
2004 notification was done. It is a revised notification, your lordship. Final notification was there in 2004 itself, but it was revised in 2014 because of various judgments of the courts.
Possession ತಗೊಂಡಿದ್ದೀರಾ?
Possession ತಗೊಂಡು ಇದು ರೋಡ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿದೀವಿ. Road
No,
formation
no,
ಮಾಡಿ
no, no,
site
please.
formation
To
ಮಾಡಿದೀವಿ.
2023. Milord, they are saying they have formed the sites, Milord. In 2023, the cause of action for this writ petition was they suddenly came, demolished my compound wall and wanted to lay a road. That is why I came to the court.
You got an interim
Please
order?
see the orders, Milord. Yes, I got an interim order, Milord. Kindly see interim order dated 26/5/2023. Learned counsel for the petitioner submits that an extent of 20 guntas in survey number 94/6 has been acquired by virtue of final notification dated 18/6/2014 for formation of Arkavati layout, as is evident that by serial number 592 of the final notification. Attention is also drawn to the endorsement issued by the BDA at annexure F, which would indicate that the remaining extent of 1 acre 39 guntas in survey number 94/6 is outside the purview of the acquisition. It is submitted that, however, BDA has sought to lay a road in the remaining extent of the land in survey number 94/6, which also includes the land to an extent of 1 acre 7 guntas belonging to the petitioner. Learned counsel for the BDA submits that the layout is being laid only in the notified area. However, no objections have been filed till date. Taking note of the submission, the respondent BDA is restrained from utilizing any portion of the petitioner's land.
Shall I say
Needless
that
to state.
the BDA can initiate action against you only after issuing corrigendum, giving you the right to challenge the corrigendum if required in accordance with law.
I'll just point out one more document, Milord, their own document. They were asked to produce the entire file. They have produced, Milord, along with another second counter statement of
Listen what the
objections.
court
Yes.
is telling.
No, I heard.
I'm telling you, I'll pass an order saying that the boundaries mentioned in the final notification does not match with the sketch produced by BDA itself. Okay?
Yes.
So the area that is actually sought to be occupied, sought to be acquired, as it is not properly mentioned in the final notification, they will not disturb your possession in survey number 94/6.
What they are trying to do, I understood.
Listen, till proper corrigendum is issued regarding the final notification.
Lord, may I just add one thing?
I will grant you the liberty to challenge the notification in accordance with law.
Now, I'll just add one sentence, Milord. I'll leave it to your lordship. I bow down, Milord. What they are saying in their own records is that the 20 acres of land has already been utilized for formation of sites. Therefore, what they want now is more over and above the 20 guntas which is acquired. So today, just by issuing a corrigendum, they cannot issue another notification. They want to acquire my land, that is a different issue. They have to go by section 17 and 19. But what their own case is that they have already utilized the 20 guntas for formation of sites, and that they have already been sold to the public. So how they can come beyond 20 guntas is the only question.
They can't come beyond 20 guntas.
Correct. So if their own records
Or
show
do you
that
want a
they
survey
have
to be
already
conducted,
utilized.
a joint survey to be conducted?
That has already been ordered. That has already been ordered.
That has been done. That is Annexure R3, Your Lordship. That is a joint survey, Your Lordship. With the order of
This is the
Honorable
joint
Court, we have
survey
conducted a
report that
joint
they
survey,
are producing.
along with the petitioner present.
Okay, now, Rajesh, according to you, as per R3, any of your land is acquired or not?
My land is not acquired, Lord. My land is not acquired. There is no award in my name. They have not given me any compensation from 2014.
I'm asking
Yes.
you a question.
Yes.
According to you, as per Annexure R3, now leave out all the other previous things. Just focus on Annexure R3 sketch.
Yes, Lord.
According to you, your land, does it fall within the acquired land as shown in Annexure R3 or not?
Lord, in Annexure R3, what they are showing, it is definitely within my land.
Huh?
But if you compare it, Lord,
I could
it
not
shows
hear
my
you.
land is
Repeat it once again. There was
I'm
a
sorry.
technical glitch.
Lord, what they are showing the red area, my Lord, in the sketch. According to them, this is the acquired land.
Yes.
Now, my Lord, if your Lordship sees, in 2015, there was a survey, my Lord, where the 20 guntas is identified towards the
No,
north.
that is different, Rajesh. I am
Yes.
asking you this question so that some order can be passed. That's the reason I am asking you this question. It depends on your answer.
Yes.
I am asking you, according to you, as per Annexure R3, any of your land is acquired or not?
According to R3, my Lord, according to them, it is acquired. According to me, it is not.
According to R3, it is acquired.
Lord, kindly have the sketch, please, if your Lordship will. Just the red area that is shown here, my Lord, is according to them, this is the acquired land, my Lord.
Yes.
Now,
Yes.
my Lord, now kindly see in 2014, they have 2015, my Lord, they have done a survey, my Lord. Now kindly see where
I am asking you, according to Annexure R3, that red portion, what they have marked, does your land fall?
That is my
within
land.
That is
Yes,
your
my Lord,
land.
that is my land.
That is your land. Okay.
That is my land.
Yes, I will order as I had earlier told. Yes.
Lordship, kindly look into Annexure R8, Your Lordship, page 12, in my statement of objection. It is the same petitioner who files the objection to my acquisition proceedings, Your Lordship. After that notice is issued in the year 2006 by 2004 to the same petitioner, Your Lordship. And the award is, that is at page 17, Your Lordship, notice. And award is also at page 20, Your Lordship, 4/10/2004. The petitioner name is also there in the award, Your Lordship. He has participated throughout the acquisition. And now he is saying it is not coming with the acquired area.
Final notification is 2014. If I filed objection to the preliminary notification, I have done so.
Yes. But petitioner is the owner of 1 acre 7 guntas, correct?
Yes, Your Lordship.
1 acre 7 guntas.
of land in survey number 94/6 of petitioner is said to be in Tamil Nadu. Is said to be owner of 1 acre, 7 guntas of land in survey number 94/6 of Thani Sandra village, Bangalore South Taluk. Full stop. The total extent of
2 acre 19 guntas.
the said survey number is 2 acres, 19 guntas of land.
Out of that, 4 guntas is Karab land and 2 acre 15 is the.
Full stop. Initially, the respondent BDA, how many respondents? Respondent BDA sought to acquire the entire extent of land in survey number 94/6 and a preliminary notification to that effect was issued. Full stop. However, the final notification was issued only in respect of
20
20
guntas.
guntas of land in survey number 94/6. And the boundaries to the said land, the said land sought to be acquired, said land acquired was mentioned as KNP Gadi, capital city, KNP Gadi, GADI, to the east.
Yes, sir.
Colon, semicolon, semicolon. Survey number 94/4 to the west, semicolon. Survey number 93 to the north. And survey number 94/8 to the south. Full stop. The petitioner had participated petitioner had participated, as the name of the petitioner found a place in the revenue records after issuance of preliminary notification. Petitioner also was notified about the acquisition of the land, and he had filed his objections
To
for
the
the same.
acquisition.
Full stop. The same has been overruled. And finally, 20 guntas of land
Was acquired.
Has been acquired in survey number 94/6. Full stop. Subsequent to acquisition, the compound wall of it is alleged that the compound wall of the petitioner was demolished. And at that time, the petitioner has approached this court by filing the instant writ petition on the ground that only 20 guntas of land has been acquired in survey number 94/6, and the boundaries in the final notification are not properly mentioned, and the land acquired in survey number 94/6 cannot be identified. And for that reason, the following prayers are made. Adu prayer extract ಮಾಡಿ page number 12 ಅಲ್ಲಿ. 12 next paragraph. The respondent BDA has opposed the writ petition and has contended the land of the petitioner to an extent of 20 guntas has been acquired. Full stop. Next paragraph. Has been acquired. Full stop. It is further submitted. Allah continue. It is further submitted. There is no vagueness in the final notification, and it is prayed that the writ petition be dismissed. Full stop. In the next para, in the course of the proceedings, the BDA, the respondent BDA, has filed its rejoinder. Has produced certain documents, including the map of
the lands, the lands sought to be acquired in and around survey number
94/6.
94/6. As annexure R3. Full stop. In the said survey number, in the said map, the BDA has marked the area which has been acquired in survey number 94/6.
94/6.
Full stop. Perusal of the map indicates that on the eastern side, the land acquired in survey number 94/6 is bounded by village boundary of K. Narayanpura, colon, a semicolon. On the western side, it is survey number 94/5. On the northern side, semicolon, on the northern side, it is remaining portion of survey number 94/6. And on the southern side, it is survey number 94/9. Full stop. The said map is at variance with the final notification issued acquiring the lands. Full stop. Thus, it has to be concluded that the final notification is vague and does not specify the actual area of land sought to be acquired in survey number 94/6 of
Tanisandra village.
Tanisandra village. Tanisandra village. Full stop. Next para. Admittedly, the petitioner is in occupation of
1 acre 7 guntas.
7 guntas of land in survey number
94/6.
94/6 of Tanisandra village. Full stop. In the absence of a proper corrigendum to be issued to the final notification, specifying the exact boundaries of the land acquired under the final notification, it would be appropriate to direct the respondent authorities not to disturb the possession of the petitioner or the property concerned. Full stop. Hence the following order. Respondent is hereby directed not to disturb the possession of the petitioner over 1 acre 27 guntas of land in survey number
7 guntas.
1 acre
1
7
acre 7 guntas.
1 acre 7 guntas of land in survey number 94/6 of Tanisandra village, till appropriate corrigendum is issued to the final notification, by which 20 guntas of land is sought to be acquired for Arkavati layout in survey number 94/6 of Tanisandra village. Full stop. Next para. Liberty is granted to the petitioner to challenge the corrigendum to be issued by the respondent.
If issued.
If he is so aggrieved in the manner known to law.
Lord, only one correction. Lord, my friend was saying that the entire land was notified in the preliminary notification. It's not correct, Lord. Their own document, the award says only 20 guntas was notified under the preliminary. Section
No,
17.
file preliminary notification, entire gunta, entire extent.
No, my lord. No, that is what I want to show your lordship. That for a matter of record, it should be correct, my lord. In the affidavit on 30th September 2023, if your lordship comes to page 21.
No, what is this annexure G? Is it preliminary notification or final notification?
No, it is final notification. Final notification.
ಏನು ಅಂತ ಹೇಳಿ ಓದ್ಬಿಡಿ ಒಂಚೂರು.
ಏನ್ ಬೇಡ ಅದು ಹೊಡೆದಾಕ್ಬಿಡಿ ಅದು ಇನಿಷಿಯಲಿ ಅಲ್ಲ. The respondent BDA has acquired 20 guntas of land in the said survey number ಅಷ್ಟೇ for formation of work out layout. ಅಷ್ಟೇ ಸಾಕು, ಮಿಕ್ಕಿದ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಅದು ಜಸ್ಟ್ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗುತ್ತಲ್ಲ ಈಗ ಚೇಂಜಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Obliged. Obliged.
Second list, serial number 1. Asha D. Joshi. Second list, serial number 1.
What is this, Nagaraj?
230 list. 230 list ಅಲ್ಲ ಎಷ್ಟು ನಾಗರಾಜ್ ನೀವೇನು
230 list.
serial number 1.
This case, Malad, since there is no amendment, the amended cost title is not required. Cost title is in accordance.
That's okay. You can argue on merits.
Let's, yes, sir. Any day, may I request?
Advocate for the petitioner present and appears for respondent number 1 and 2. Call on next week, date could
13.
please.
Number 2, M. Shiv Prakash.
Needful done, madam. Today morning I
Advocate for the
discussed.
petitioner submits that needful has been done, office to verify and proceed. Yes.
3.
Filing memo for withdrawal.
Yes, dismissed as withdrawn.
4. Liberty ಇಲ್ಲ.
It's a 2018 matter, sir. 1 week to do the needful.
Pending, madam.
Okay, 1 week to do the needful finally. Yes.
5. Sham Ahmad Patan.
I appear for respondent number 1. Malad. Petition copy not being.
Yes, 1 week to do the needful finally.
6. Badrinath R.
Waiting for the petition, Malad. Kindly grant a week, 2 days time.
Yes, 1 week to do the needful finally.
7. ವಿನಯ್ ಕೀರ್ತಿ ಸರ್ ಇದು 7 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್.
ಹೌದಾ?
ಡಿಕ್ರೀಡ್ ಕೇಸ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಕಂಟೆಸ್ಟೆಡ್ ಡಿಕ್ರೀಡ್.
The original suit. ಅಲ್ಲ OS ಎಂತದ್ದು?
OS number 109 of
Serial number 6, interim order has to be extended.
Serial number 6 ಅಲ್ಲಿ interim order if any is extended till next date of hearing ಅಂತ ಮಾಡಿ. Serial number 7 ಏನು ಹೇಳಿದ್ದು?
serial number 7 OS 109 of 2010 case disposal contested decreed on 25.
OS the records reveal ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲ ಏನದು the case status, the online case status ಅಂತ ಮಾಡಿ. The online case status reveals ಈ ರೀತಿ ಮಾಡಿ. None appears for the petitioner. The online case status reveals that OS 109 of 2010 has been disposed of. Full stop. The present writ petition is filed against an against an order passed on an interlocutory application filed in the said original suit. Full stop. Hence, the writ petition is dismissed as having become infructuous. Yes.
8 VB Shivkumar.
Permit me to withdraw.
Yes, dismissed as withdrawn.
Memo ಕೊಟ್ರಾ ಸರ್? ಪ್ರಶ್ನ 9. A. Binawana.
For petitioner in this case, my lords. Lords, there are 9 IAs, my lords. IA is 1 to 3 of 21 in respect of respondent number 1, my lords. IA 1 of 21 for CD 811 days, my lords. And IA 2 of 21 for setting aside abetment.
1, 2 of 3 the loss of R2.
Yes, R1, my lord.
R2 Nimsha 4, 5, 6 R3. Yes. Issue notice on IA 1 to 6 of 2022 on
My lords,
the proposed
they are already on record, my lords. A lots of
ಬಂದಿಯಾರೇನ್ರಿ?
R. Sharat Kumar.
ಇಲ್ಲ, ಶರತ್ ಕುಮಾರ್, ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಸರ್.
ರೀ ಮಿಸ್ಟರ್ ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ರಿ?
ಕಲೆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ, my lord.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? A to F. Legal is.
ವೆರಿಫೈ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಹೇಳಿ.
ಏನ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ಲ? ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ರಿ? ನೋಡ್ದಾಕಿಲ್ಲ. Orders on IA 1 to 6 of 2022. The aforementioned IAs are filed to bring the legal representatives of deceased respondent number 1, comma, deceased respondent number 2 and deceased respondent number 3 on record. By condoning the delay in filing the applications and also by setting aside the abatements. Full stop. Accepting the cost shown, the aforementioned IAs are allowed. Petitioner, the advocate for the petitioner is directed to carry out necessary amendments and file amended cost title within a period of 2 weeks from today. Yes.
10. Case number 10, so 10 also.
Disposed.
Right. The advocate for the petitioner submits that the relevant original suit bearing OS number 7459 of 2005 has been disposed and the writ petition becomes infructuous. Full stop. Writ petition, hence writ petition is dismissed as infructuous.
11, Chandrasekhar Reddy MUV.
Pay for the petitioner.
Hmm.
My lord, the order impugned here is, my lord, allowing an application which was filed by the execution decree holder in the execution proceedings, my lord, seeking for appointment of a commissioner. That was allowed.
Where is the other side? Why was it urgent today?
My lord, last date, I was unwell, my lord, sought for an adjournment.
The other side is not there, Alappa. Advocate idaralva.
Yes, sir.
Other side
Tejas,
idara.
Tejas idara.
Advocate for the petitioner present, advocate for respondent absent, call on date today. Next date,
Well-
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ will pass.
Great.
Late.
C number 12, Rohit Gowda, BJ. C number 12,
ಇದೇನಾಗಿದೆಪ್ಪ ಇದು ಕೊಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋ ಇಲ್ವೋ None appears for the petitioner. Finally call on
12,
12.
13, K.S. Narayan Swamy. You put delay.
ನೋಡಿ last time
Last time, there is no representation.
no representation.
There is no representation.
None appears for the petitioner. Even on the last date of occasion, none appeared for the petitioner. It appears, the writ petition is of the year 2018. It appears petitioner is not interested in prosecuting the writ petition. Writ petition dismissed for non-prosecution. Yes.
14 adjourned. 15, Prashant HS.
Paper assigned. Lord, it was a suit for Lord partition. Lord.
Ready both sides?
Yes, madam. It's ready.
ಹೇಳಿ ಏನಿದೆ?
Lord, appellant, my lord, in the
One
regular.
second, sir. Yes, what's wrong in the implement order?
I'll just point out. My lord. It's a suit for partition filed by the mother. Lord, a fraud was played on the mother, not by the second lord respondent herein, together with lord the fifth respondent lord. They are the lord brother and sisters. Lord, the sisters daughter was given in marriage.
Max to max, I will refer it to mediation, settle that, that's all.
We'll try.
Okay. She is your mother at the end of the day.
Yes.
Just keep her happy and that's the end of the matter.
Earlier partition 1993 ನಲ್ಲಿ ಆಗಿ
Sir,
partition
is it,
decree ಆಗಿದೆ.
sir, listen. Who are your children?
Not the second respondent lord and the fifth respondent.
Second respondent
And fifth respondent.
they are your children, huh?
Yes, yes.
Huh?
Yes. I am the second wife, not the original first defendant. That is Manchegowda.
Okay.
And through me, my lord, there are three.
Who are your children?
Second and fifth respondent.
Mohan Kumar is your son, huh?
Yes.
One son,
Yes,
huh?
yes.
And fifth,
Rukmini amma.
Rukmini amma, daughter of,
Wrong ತೋರಿಸಿದ್ದಾರೆ.
ಯಾರು ರಾಮಣ್ಣ ಅಂತ ಬರ್ದೀರಾ?
ಹೌದು, ಅದು that is shown as.
See, only your children are liable to maintain you. Own children, not stepchildren.
Own children only.
Own children.
Please.
Who represents her own children?
Earlier
Who represent her own children?
Number 2.
Served and unrepresented. And respond number?
5, my lord, by L. Raja.
on 3 to 6 appearing for the 8th respondent.
Huh?
I am for the 8th respondent. 3 to 6. 3 to 6 I am appearing.
3 to 6 andre who is Rukmini amma?
3 is none other than my lord, the wife of second respondent, daughter of my lord, the second respondent. 4 is the wife of second respondent, and my lord, 5 is my lord, the other daughter.
I will refer it to mediation. At the request of parties, refer the matter to Karnataka Mediation Center.
Partitions to dismiss ಆಗಿದೆ. In RN ಅಲ್ಲಿ impleading application ಹಾಕಿರೋದು.
Correct, sir. You know, Mudki, she is asking for some thing, just manage it. You being children.
1993 ನಲ್ಲಿ partition decree.
Sir, ನೀವು ಸೊಸೆ ಅಲ್ವಾ?
ಸೊಸೆ.
ಸೊಸೆ ಇದ್ದೀರಾ?
ಹೌದು.
Just see to it, ಮಾನವೀಯತೆಯಿಂದ ಏನೋ ಕೊಡಿ ಒಂದು ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ನಮ್ಗೆ ಕೊಟ್ಟಿರೋದು ಅವರು ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಇನ್ನೂ ದಕ್ಷಿಸ್ತಾ ಇಲ್ಲ. 93 ನಲ್ಲಿ ಆದದ್ದನ್ನ ಇಲ್ಲಿವರೆಗೆ ನಾವು ಬಿಡ್ತಾ ಇಲ್ಲ. ಮೈನರ್ ಚಿಲ್ಡ್ರನ್ ಇದಾರೆ ಎಲ್ಲ ಇದಾರೆ.
ಈಗ ಮಾತುಕತೆ ಆಡದಲ್ಲೇ ಒಬ್ರು ಜುಟ್ಟಿ ಚೀತು ಅಂದಿ ಕೊನೆಗೆ ಇನ್ನೊಬ್ರು ಬಂದು ಕುತ್ಕೋಬೇಕೇನಲ್ಲಿ ಏನ್ ಮೀಡಿಯೇಷನ್ ಕಳ್ಸಿದ್ರೆ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ವಾ ಒಂಚೂರು?
ಅಲ್ಲ ಇಲ್ಲಿ ಈ RN ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ಗೆ ಹೋಗ್ರಿ ಸುಮ್ಮನೆ ಅಲ್ಲೇ ಹೆಂಗೆ ಮಂಡ್ಯದಲ್ಲೇ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಬರ್ತಾರ.
ಮಂಡ್ಯದಲ್ಲೇನಾ? ಆಯ್ತು, ಮಂಡ್ಯಗೆ ಕಳ್ಸೋಣ.
ಆರ್ಡರ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಸರ್.
ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಮೀಡಿಯೇಷನ್ ಕಳ್ಸಲ್ಲ, ಮೀಡಿಯೇಷನ್ ಆಗಲ್ಲ ಅವಾಗ. ಏನೋ ಒಂದು ಜೀವನಾಂಶಕ್ಕೆ ಕೊಡ್ರಿ. ಅಡ್ವೈಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ನಾಟ್ ಟು ಆಸ್ಕ್ ಮೋರ್ ದನ್ ಜೀವನಾಂಶ.
ಆಯ್ತು, ಬೆಂಗಳೂರಲ್ಲೇ ಕರ್ಸ್ರೆ ಇಲ್ಲಿ ನಾವೇ ಇದು ಮಾಡ್ತೀವಿ.
They wanted Mandya. If everyone is at Mandya, go to Mandya.
ಅಮೌಂಟ್ ಬರ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ.
2 hours journey will not take.
ಮಂಡ್ಯದಲ್ಲೇ ಆಗಿದೆ.
So at the request of parties, refer the matter. ಒಪ್ಕೊಂಡ್ರೆ ಕಳಿಸ್ತೀನಿ, ಇದೆಲ್ಲ ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ ಏನ್ ಮಾಡ್ಲಿ ಹೇಳಿ.
ಕಳ್ಸಿ ಒಂದು ಟ್ರೈ ಮಾಡಿ.
ಅಲ್ಲ ಆಗಲ್ಲ ಸ್ವಾಮಿ ಸುಮ್ಮನೆ
ಕೊಡ್ರಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿ.
Please. Lord. The respondent number 2 and 5, they, my lord, filed a suit, my lord, for partition in OS number 27 of 1993 without making, my lord, the mother as the party. One of the son of, my lord, the plaintiff had predeceased her, and she was the class 1 here. She had a definite, my lord, share from out of, my lord, her first son's, my lord, notional share. My lord, when things stood thus, my lord, this OS number 27 of 1993 was filed, my lord, before the additional senior civil judge Mandya and a compromise, my lord, was entered among, my lord, the second respondent and the fifth respondent, my lord, thereby allotting all the property, my lord, in favor of, my lord, the third respondent, my lord, who is the minor daughter, my lord, of the second respondent, leaving, my lord, the mother, my lord, from the array of parties. That's why, and thereafter, my lord, a second suit was filed by them, my lord, in, my lord, OS number 200 of 2006 by, my lord, the third defendant, that is the minor daughter. Here in this
ಟೈಮ್
suit-
ಜಾಸ್ತಿ ತಗೊಂತೀರಾ ಬರ್ಲಿ ಇನ್ನೊಂದು 2 ವಾರ ಬಿಟ್ಟು ಟೈಮ್ ಅಪ್ the request of parties call out for 2 weeks.
Interim order we can leave it.
Interim order if any is extended till next date of hearing.
Last date, one date ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
ಆಯ್ತು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
Please. Please.
16, number 16.
ಎಲ್ರು ಸತ್ತೋಗ್ಲಿ ಏನ ಮೀಡಿಯೇಷನ್ ಗೊತ್ತಾ ಇಲ್ಲ, ಯಾರು ಪ್ರಾಪರ್ಟಿ ಎಂಜಾಯ್ ಮಾಡ್ದಲ್ಲ ಎಲ್ಲ ಗೊಟಕ್ಕನ್ಲಿ
ಅವ್ರದೇ
ಅಷ್ಟೇ.
93ರಿಂದ
ಅಲ್ಲಲ್ಲ ಹೇಳ್ತಿರೋದು
ಕಳೆದು
ನೋಡ್ರಿ, ಒಂದ್ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ನೀವು ಇಷ್ಟು ಸಂಬಂಧಿಕರಾಗಿ ನೀವು ಏನೋ ಒಂದು ಕೊಡೋದು ತಗೊಳ್ಳೋದು ಮಾಡ್ದಲ್ಲ, ನೀವು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ದಲ್ಲ ಇರೋರಿಗೆ ಕೋರ್ಟ್ ಯಾಕೆ ಟೈಮ್ ಮಾಡಬೇಕು? ಒಂದು ಫಸ್ಟ್ ಪಾಯಿಂಟ್. ಸೆಕೆಂಡ್ ಪಾಯಿಂಟ್, ನೀವು ಸಮಾಜಕ್ಕೆ ಏನ್ ಕೊಡುಗೆ ಕೊಡ್ತೀರಾ?
That too, my lord.
ನಿಮ್ಮಲ್ಲಿ ಬ್ಲಡ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಏನೋ ಒಂಚೂರು ಹೊಂದಾಣಿಕೆ ಮಾಡ್ಕೊಂಡು ಹೋಗಕ್ಕೆ ರೆಡಿ ಇಲ್ದಲೇ ಇರೋರು ಸಮಾಜಕ್ಕೆ ಏನ್ ಕೊಡುಗೆ ಕೊಡ್ತೀರಾ? ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ ನೀವು ವಕೀಲರುಗಳು ಬೇರೆ ಇದ್ದೀರಾ.
ಇಲ್ಲ ಇಲ್ಲ
ಮೀಡಿಯೇಷನ್ ಅಂದ್ರೆ ಇಲ್ಲ ನಾನ್ ಜಗಳ ಆಡ್ಲೇಬೇಕು,
ಒಂದೇ ಸ್ವಾಮಿ,
ನನಗಿಲ್ಲೊಂದು ಏನೋ ಒಂದು ಅಡ್ವಾಂಟೇಜ್ ಸಿಕ್ಬಿಟ್ಟಿದೆ.
ಹಂಗಲ್ಲ. 93ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಆಗಿರೋದು. ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಪ್ರಕಾರನೇ ಈಗ ಅವ್ರು ಒಪ್ಕೋತಾ ಇಲ್ಲ. ಕಾಂಪ್ರಮೈಸ್ ಅವರೇ ಆಗಿರೋದು.
ಆಯ್ತು, ಏನೋ ಬರ್ಲಿ,
ಅವರೇ ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ.
ಎಸ್
16. Honorable C party GS Balagangadhar.
I appeal for the respondent. My lord, it appears, my lord, the petitioner is not interested. My lord, I filed a suit for respondent.
ನೋಡಿ petitioner absent ಅಂತ ಎಷ್ಟು ಸಲ ತೋರ್ಸಿ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ he has sold the property also, my lord. That's
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ನನ್ನ ಅಪೇರ್ಸ್ petitioner next week date ಕೊಡಿ, next week ಕೊಡಿ.
12.
I'll give it on 12th sir. ಅವತ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ dismiss ಮಾಡಿ.
please, one more submission, my lord. What has happened? My suit for injunction, my lord, declaration and mandatory injunction is permitted. Now this petitioner defendant, my lord, he has sold it to other person. That person has sold it to other person.
Okay.
Therefore, he has lost it.
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ will dismiss.
Please,
Yes.
my lord, my presence may kindly be noted.
Yes, advocate for the petitioner absent, advocate for respondent present, call on 12th.
12.
My lord, may I request for 14th? my lord?
Aye, 14th.
Please, much.
17 Ramu case.
This is the, I was the defendant in the suit, my lord. I had sought for impounding of the MOU, which was entered between me and the plaintiff.
Other side absent ಅಲ್ಲ sir.
ಇದರಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ರೆ,
Advocate ಇದಾರ other side ಗೆ?
ಅದರ್ ಸೈಡ್ ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ.
Yes, advocate for the petitioner present, advocate for respondent absent, call on 12th.
ಆಮೇಲೆ ಇಂಟ್ರಿಮ್
Interim order ಇದೆಯೇನ್ರಿ?
Sir.
Interim order if any is extended till next date of hearing.
18. Go for withdrawal.
Yes, dismissed as withdrawn.
19 Lata Shetty.
I appeal to the petitioner.
Hmm.
Lords, the petitioners are defendants 1 and 2 before the trial court. Lords, the order under challenge is an order impounding the agreement to sell. Lords, that I have produced during the course of the trial.
Yes, advocate for petitioner present, advocate for respondent absent, call on 12th.
12.
Lords, may I request for 16th?
Okay, call on 16th.
Interim order.
16th ಇಲ್ಲ, sitting ಇಲ್ಲ.
Holiday, sir.
Let's say a week after.
19th. 19th, interim order if any is extended till next date of hearing.
Grateful.
20 Tejesh. Sampathana Shetty BS Sachin.
Petitioner in this case, my lord, regarding court fee challenged.
You are ready, Sachin?
Please, ma'am.
Yes, good.
Suit is filed by the BDA against the defendant. Defendant number 1 is the landlord. Defendant number 2 is the tenant. Respondent number 2 is the tenant under the defendant number 1. Suit is for declaration and consequential relief of injunction. Court fee is paid under section 24D. It has been challenged before the Honorable Court. It come under section 24B. This relief of declaration is in respect of immoral property. In view of the same, section 24B applies.
ಎಷ್ಟೊತ್ತಿಗೆ ಇತ್ತ?
Yes, that is only short point, my lord.
We'll call it day after tomorrow.
Please.
Day after tomorrow. Mr. Request of parties call on day after tomorrow.
7, 7, 8.